before I start, can everybody hear me? Okay, good. Okay, thank you. It's now 9:30 and time for me to open the hearing session, this hearing session, which forms part of the examination of the Enfield Local Plan. I'm Stephen Lee. I've been appointed by the Secretary of State to examine the Enfield Local Plan and report to the Council in due course. Before I get on to the main part of my opening remarks, there are some normal housekeeping matters to address. Firstly, I was informed, I don't know if it's happened or not, I was informed there was likely to be a protest outside this morning. I don't know if that's happened or not, but I just want to make sure everybody's here, expected to be here, and it's not caused anyone any problems getting in. No? Good? Okay. On that basis, I'll carry on. Can I just ask, again, as is normal, for mobile phones to be off or on silent, please? Just ask the council if they could say something about any fire exits or fire alarms or procedures for that, please. Thank you.
Thank you very much, sir. Ms Hope will indicate the situation there.
Good morning, everyone. Can everyone hear me? Okay. My name's May Hope, and I'm Head of Strategic Planning and Design at Enfield Council. I'd like to take a few moments to outline some key housekeeping arrangements, and that's to ensure everyone can participate effectively and comfortably throughout the examination process. We're not expecting a fire alarm test today. However, in the unlikely event of an emergency, the fire alarms will sound. Please exit the building promptly through the nearest marked exit to the left. Assembly points are located outside the Civic Centre, and council staff will be on hand to guide you. Toilets are located on the ground floor, accessible via the reception area. So if you require accessible facilities or additional assistance, please speak to a member of staff or our security team outside, and they will be happy to help. Tea and coffee will be provided during the breaks and are available at the front of the room. And then just a reminder that these sessions are being recorded as part of the official examination record. So if you do not wish to be recorded, please can you inform the programme officer, Mrs. Feeney, at the back. If there are no immediate questions, I will now hand back to the Inspector to proceed with today's session. Thank you.
Thank you very much. Thank you for the comments on recording and streaming. That was my next point, so thank you for that. You covered that. If anybody does feel uncomfortable, there'll be a moment or two before we get into it to rearrange seating. I think it's probably people would need to sit at the back, but we can address that when we get started. Just going through where I am. Annette Feeney's just been mentioned. I'm sure you all know Annette already and have contact with Annette. But for anyone who doesn't know, Annette is the Programme Officer and is responsible for organising hearing sessions and publication of any documents. Annette should be the first point of contact should there be a need for any assistance or if anybody has any queries about the process. And if necessary, Annette will pass those queries on to me and I'll respond through Annette if necessary. Also, any documents or additional information that I request during the process or any documents I accept should be passed on to Annette in the first instance, who will pass them on to me, and they will then be published on the examination website in due course once I've said it's okay to do so. Moving on then to what I'm actually examining. The plan under examination is the submission version of the Enfield Local Plan 2019 to 2041, which was submitted to the Secretary of State on the 6th of August 2024. Prior to submission, the consultation took place on what is known, what I'm going to refer often to, Regulation 19 stage, and I'll be having regard to the representations that were made. I've published a guidance note outlining how the examination will run, and I've identified the Stage 1 matters, issues and questions, or MIQs, that I intend to consider in this part of the examination. And I would ask everyone to familiarise themselves with the guidance note and the MIQs if they haven't already done so. Additional MIQs and subsequent hearing programme will be published in the fullness of time once I've had an opportunity to consider the outcome of this stage and once I am available. Further to the Stage 1 matters, issue and questions, I've also received hearing statements from the Council and other parties, which I shall also have regard to in coming to my conclusions, and all of these are available on the examination website. I just want to say a couple of things about why we're having Stage 1 hearings, just for clarity. There are mainly two reasons for this. Firstly, there are some issues that I think would be better to ventilate at a relatively early stage and discuss in person, allow others to contribute, rather than go through additional stages of correspondence between myself and the council. Some of these are also extremely important as to how or whether future stages of examination will progress, including, for instance, matters relating to engagement and duty to cooperate. Secondly, and in the spirit of openness and transparency, I should inform you that I'm involved in another local plan examination. I'd like to keep us busy at the Inspectorate. And the hearings for that are due to start quite shortly. So unfortunately, until PINS perfects the cloning of inspectors, which I'm sure it's working on, I can't be in two places at once, and thus I only have a short window of opportunity to address, within which I can actually start the hearings. So it was either do something now and do as much as I realistically could in this short window, or wait for several months. And I decided it would be better to deal with some of the issues now, rather than delay any form of discussion. This may well come up, but that's the main reason for this. Main reason for doing it, how I'm doing it. So to my role, I'm tasked with considering the soundness of the plan in accordance with the criteria set out in the National Planning Policy Framework, or NPPF. This means considering whether the plan has been positively prepared, whether it is justified, whether it will be effective, and whether it is consistent with national policy. Unless persuaded or told otherwise, I'll be examining the plan against the December 2023 version of the NPPF, as per the transitional arrangements that were set out in the recently published December 2024 version. I'll also be assessing whether the plan is legally compliant, which is the topic of today's hearing sessions, but also obviously there will be things which will come up as we go through the examination which apply to legal compliance as well. As set out in my guidance note, there are three possible outcomes to the examination. Firstly, that the submitted plan is sound and legally compliant, doesn't need any changes. Secondly, the submitted plan is not sound or legally compliant, but can be made so by changes, often known as main modifications, or all the work that needs to be done. Or the submitted plan is not sound or legally compliant and could not be made so by any changes or additional work. The hearing sessions are intended to assist me in reaching my overall conclusions on this, but in submitting the plan, the Council considers that it is sound and that this is the starting point for examination. If anybody is challenging the soundness of the plan, then as well as explaining why this is the case, it's also helpful for me to understand what changes are considered necessary to make it sound. As a reminder, it's not my role in this examination to consider things which aren't in the submitted plan. This includes consideration of the merits of what are often called omission sites, i.e. sites which have been suggested by interested parties but which are not included. It's also not my role to make improvements to the plan where it is already sound. In this regard, I can't make a sound plan sounder. I've read and will take into account the hearing statements that have been prepared and also the original representations that have been made. There is no need for these to be repeated. Instead, my aim is that the discussion moves on from those documents and deals with specific questions that I have or areas where further clarification or explanation is required. But at times, I may ask for a more general contribution or summary of any party's position. It's also helpful when making contributions to stick to the matter in hand and refrain from commenting on unrelated matters if possible. As the hearings will likely take place over several weeks, it may be that some matters will be best deferred to subsequent days in order that we keep on track. Also, matters covered and things said on one day will form part of the examination and do not need to be repeated subsequently. One thing I will say on this is that given the interrelated nature of many of the issues that we're going to be discussing through this plan, I expect there will be some overlap and duplication. I think it's inevitable. I'll try and minimise it as much as possible. I've got a mind like a steel trap, so if somebody tells me something today, don't worry, in a few months' time I'll still remember it. But it's likely that things will be said more than once, just because of the nature of this plan and the issues. In order to test the plan for soundness and legal compliance, I will need to ask questions. You'll have seen that I've already been doing this through preliminary questions to the Council and through the MIQs. And the Council and other participants have already responded to these. This is likely to continue as we go through the process, but anything that I ask should not be taken as demonstrating a particular predisposition. Indeed, from time to time, I will play devil's advocate in order to properly test the evidence, and nothing should be taken by this. In terms of the discussion, I will normally start a particular topic by asking for responses to my specific questions. That will normally be to the council, but it may well be to other interested parties around the table if something I specifically need to understand from them. And once I've gone through my questions, I will then invite others to contribute. If at any point you'd wish to make a contribution to the discussion, then please indicate this by turning your nameplate on its side. In speaking during the hearing, I would request that you are concise and specific. I have to say, from the hearing statements I've been provided, I thank you all for those. They've stuck to my guidelines very, very nicely, very unusually, I have to say as well, so thank you for that. So if we can continue that in the sessions, that would be great. But if you, obviously, if you wish to highlight certain parts of your hearing statements or your evidence or your representations or an evidence-based document that form part of the examination, then it will be helpful for me if you could provide me with a reference and I can look it up at my leisure. It is vitally important that people exercise their right to be heard, so please don't let me move on to another topic or issue if you haven't said what you want to say. We don't want to leave at the end of the day if you've not said something you wish to say. There will generally not be any opportunity to raise additional points with me after a hearing session has ended, unless, as I've already mentioned, I specifically request further information or feedback. It may also be, of course, if there's something that somebody desperately wanted to say about a particular issue today, that we may well come back onto that at another point in the examination, in which case there'll be an opportunity to raise it then. The Council has already published a schedule of proposed changes to the plan, which it considers might be necessary to make it sound, and I've suggested some more in their hearing statements. I will consider these alongside the submitted plan. I shall determine whether the changes suggested are necessary to make the plan sound. As well as the modifications the Council has already put to me, it's open to propose further changes to the plan as we progress through the examination. And from time to time, I may also ask the Council to consider further modifications and provide me with wording for my own consideration, and this will help me with my deliberations into whether the plan is sound or not. I'm going to ask the Council to keep a record of possible changes that arise during the hearings, as well as any other actions that I may deem necessary. And what I'll probably try to do is, in the morning of the following day, I will go through actions that were agreed the previous day to make sure we are on the same page. Just to be, for those who are not aware, any modifications that are proposed and that I consider are necessary will be subject to future consultation at the end of the process. The examination remains open until my report is submitted to the Council. No further representations or evidence will be accepted during the hearings or after they're finished, unless I specifically request or allow it. At the end of the hearing sessions, I will indicate the likely timescales of the next phases of the examination. I have one final point to make about conduct at the examination. For everyone here, you're most welcome to attend and observe proceedings. I'm sure what I'm about to say isn't necessary, but to avoid any doubt, I want to make it clear that I don't want to hear from anyone in the audience today. That includes reactions to things you may hear which you agree or disagree with. I would ask everyone here to treat those around the table and the nature of the event with due respect. This also goes for those participating around the table. Rancour, antagonism, arguing are not helpful to me or helpful to the examination, and I'm sure that won't be the case, but I'll just set it out now. I won't tolerate any disruption within the room or poor behaviour around the table, and if there is any, I will adjourn immediately and ask the Council to remove any disruptive parties. But I'm sure, as I say, that's all completely unnecessary to say. But I said it anyway. I understand that before we begin, the Council wish to make an opening statement, which is quite normal in these proceedings. So I'll allow that. And then following this, we'll move on to the first issue to be discussed. With apologies, I do intend to change the agenda slightly, such that we'll be discussing issue 1.3 first, which is engagement. Apologies if that means some moving around for participants and hot seating. I'll give some time for this before we start. And then once, if anyone does need to move, we've moved, I'll go around the table for introductions. Just a note on breaks today, I'll try and have a break around 11 o'clock with lunch at 1, coming back at 2. However, these timings are quite fluid depending on where we are in discussion. I'm not necessarily anticipating we're going to be at 5:30 today, So it may be that if we're close to finishing, we'll delay lunch. Maybe that's optimistic. Maybe I'm wrong, but we'll see. Programming is the hardest part of being an inspector because days you think it's going to take 5 minutes takes 5 hours and vice versa. So, my apologies. So yeah, we'll see where we are, but that's my plan. And then if we back after lunch, we'll have a break at 3:30, sort of thing. So about an hour and a half session. So before I hand over to the council, are there any questions about what I've just been through or procedural matters anybody wishes to raise? No? Okay, well, thank you then. I'll hand over to the council to make their statement. Thank you very much.
Thank you very much, sir. So I should introduce myself. My name is Matthew Reid. I'm King's Counsel, instructed by Sharp Pritchards. Andrew Swaffer is my instructing solicitor. Just so you know, and everybody knows who I am. I shan't be giving the opening statement, however. Mr. Leahy will be giving that statement. He's the Strategic Director of Planning, Growth and Infrastructure at the Council.
Good morning, everyone. I'm Brett Leahy, the Strategic Director of Planning, Growth and Infrastructure here at Enfield Council. And on behalf of the Council, I am pleased to welcome you here at the Council Civic Centre for the independent examination of our local plan. This plan is the result of 9 years of hard work from officers of the Council and a current investment of £7 million. And of course, invaluable contributions from our residents, our businesses and our critical partners. It's critical to shaping our borough. Enfield has challenges as well as opportunities. Enfield is a rich borough with a rich history, has vibrant character and vast opportunity. Yet, like all councils, we face significant challenges. We have a deepening housing crisis, rising homelessness, limited funding for essential infrastructure, persistent economic disparities, and an urgent need to combat climate change and achieving net zero. These challenges need addressing, and Enfield is seeking to meet them head on. Through our regeneration programme, Reading Water, we're delivering one of England's largest regeneration projects, a £6 billion, 25-year initiative creating thousands of jobs and homes, as well as our estate renewal programme, such as Joyce and Snails. We are transforming neighbourhoods with affordable housing, safe communities and improved infrastructure and facilities. Enfield is also pioneering in rural transformation in partnership with DEFRA. We've introduced London's only head of rural transformation, driving greenbelt restoration in our borough. This includes planting hundreds of thousands of trees, enhancing biodiversity, improving access and implementing flood mitigation for our residents. Additionally, our borough is home to London's largest district heat network, delivering sustainable, affordable energy to our residents. However, whilst these initiatives are significant, it's not enough to address those issues. We need an up-to-date local plan to truly address those challenges. So why does this plan matter? Enfield is more than just a borough. It's people's home. It's a place brimming with potential and opportunity, where a diverse and growing population, thriving businesses and ambitious regeneration projects reflect the vibrancy of our community, of our residents and our businesses. Over half of Enfield comprises of green and blue spaces, making it a crucial part of London's natural heritage. However, along these strengths, we face significant challenges. Like many parts of London, Enfield is grappling with a deepening housing crisis. Slow economic growth, persistent income inequality. These challenges aren't abstract, we see them every day. They impact families, they impact businesses, they impact our community every day, and they will continue to do so. For example, London's housing shortfall is stark. In 2022 to 2023, just 30,000 homes were delivered in London, against a target of about 53,000, an annual need of 66,000, and against a new target of 88,000. And these have real consequences: deepening rise in homelessness, overcrowding housing, cost of living crisis, and squeezed incomes. Our continued failure to meet our 5-year housing and supply, our continued failure to meet our housing delivery test, demonstrates the need for action. Housing isn't just about buildings, as we know, they're homes. It's about health, equality, education, economic growth, and creating strong, connected communities. That's why our plan, our local plan, is so essential. The vision for our plan is clear. It's to deliver approximately 34,000 homes by 2041, with a strong focus, a clear focus on family homes, affordable homes, and homes designed for people every stage of their life, where many local plans fall short. But this plan is far more than just housing. It's about building a thriving, resilient community, a resilient borough. It's about expanding access to clean, green spaces, investing in our schools, our transport, our healthcare, supporting a vibrant, inclusive economy, and addressing climate change and protecting our natural environment. We see Enfield as London's green lung, a borough where new jobs, new homes and opportunities empower our future generations to thrive. By focusing on urban growth, but also carefully balancing grey and green belt land and enhancing biodiversity, we're laying the foundation for a healthier, more sustainable, more prosperous borough and community. The local plan has been developed in strict accordance with our national planning policy framework and has undergone a rigorous consultation, evidence gathering and analysis. It is positively prepared, justified, effective, viable, deliverable and consistent with national policy. The Council is confident that this bold strategy will address Enfield's significant challenges while ensuring that growth is sustainable and ultimately beneficial for everyone. This local plan represents a carefully considered framework for delivering planned sustainable growth. It ensures the provision of much needed homes, including family and affordable homes, while addressing the long-term needs of our borough and our communities. Importantly, the plan takes a bold and transparent approach in engaging around grey and green belt release. It strikes the right balance between the need for growth and our responsibility to protect Enfield's environment and character. And we have the exceptional circumstances to demonstrate this. In Enfield, we deeply value and understand the importance of the green belt, yet we also recognise that our borough faces unique challenges as an outer London borough. Far too often, we're expected to meet the demands of inner London policies, which fail to reflect our distinct character and needs of our borough. This plan embraces Enfield's identity, leveraging its strengths and addressing the challenges in a tailored way that supports and benefits our community. If this plan is not adopted, we do face a stark reality, a cliff-edge moment. Without a 5-year housing supply, without meeting our housing delivery test, there will be speculative developments on grey and green belt land. These would be unplanned, uncontrolled, and will fail to meet our policy and community aspirations. Adopting this plan isn't about choosing developments or no developments. It's about choosing managed sustainable growth over speculative, inappropriate developments that will erode our community's future and ambitions. In closing, this local plan delivers on its promise of a sound, positive and strategic approach to sustainable development. It ensures that Enfield remains a borough where everyone has the opportunity to live, work, thrive, continuing to be an vibrant part of our outer London. Thank you.
Thank you very much. That's all of that will be tested over the next few months, won't it? So thank you for that. I'm not going to take any questions or points about that. Obviously, it's taken as read. One thing it might be useful for that to be on the examination website, just for information. So if a copy can be got to Annette, and then we can publish that.
We'll make sure that's done.
Thank you. Okay. I will then move on then to introductions before we get on to public engagement session. With some second to move around.
Yes, sorry. So
No, that's fine. It's my fault for moving.
As always happens.
Okay, thank you. I'll start with the council then. Mr. Reid, you've already introduced yourself, but
Thank you very much. So yes, I have introduced myself. I won't do it again. But Ms Hope, she has, of course, said who she is. Perhaps she can reiterate that.
Good morning, everyone. I'm May Hope. I'm Head of Strategic Planning and Design. And over to Adrian.
I'm Adrian Gorst. I'm the Chief Technology Officer.
James Stevens.
Matthew Spry from Lichfields on behalf of Berkeley.
Sorry, I missed that.
Steve DeVos, on behalf of the Hadley Wood Neighbourhood Planning Forum.
Wood. Sorry.
It's only one microphone at a time. So.
Okay. Sorry. David Harbert, a resident of Hadley Wood for the last 30 years, and I'm also been involved in the development of the Hadley Wood Neighbourhood Plan.
Morning, Richard Collins from Landvest. We're a promoter on one of the Cruise Hill allocations.
Carol Fisk, I'm representing Enfield Road Watch, Friends of Trent Country Park, Trent Park Conservation Committee and Western Enfield Residents Association.
Wow, before we move on, I'll probably just Enfield Road Watch might be in, and we'll et al. If we just accept it for that now. If any time you're wearing a particular different hat, let me know.
I'm Andrew Lack. I'm a trustee with the Enfield Society, representing the Enfield Society at this examination.
Good morning, Vicky Pite. I'm a trustee of Enfield Over 50s Forum and representing them today.
Good morning. I am Matt Byrne and I'm here today representing Better Homes Enfield and NCAF Land Use Working Group.
I am Councillor Alessandro Giorgio, leader of the Conservative Group in Opposition. I'm also a London Assembly member, and I'm also joined by my colleague, Councillor Mike Rye, who's my deputy leader. There we go. That's all right.
Good morning. I'm Monica Jain, representing Transport for London, and my colleague, Josephine, was also from Transport for London.
Good morning. I'm Lisa Fairmanner, representing the Greater London Authority.
Thank you very much. In the first instance, I may well refer to you by your organisation names, and as I get to know you over the coming weeks and months, so it might change, but it's for organisations for the start, I think. Thank you. Right, so, as I said, I'm going to start with issues around public engagement, SCI and regulations. And as I said in my opening, I've got quite a lot of questions to ask about this, so I beg your patience and in listening to this. And once I've got to the end of my questions, I'll open it up. Obviously, there have been issues with the representations and the representation database. I don't think I'm saying anything out of turn. I think it's been understood. There's been quite a lot of correspondence between myself and the council about this since the plan was submitted. And we'll no doubt discuss what those issues are as we go through my questions. I did give the council some time at the start of the examination to address problems identified, publish revised Regulation 22 statement, and I was assured from time to time that the issues have been resolved. However, engagement and particularly the representation database and how they've been presented does seem to be a continuing issue, and is one of those I referred to in my opening remarks, which is necessary to try and address matters now rather than more back and forth correspondence between myself and the council. Also allows obviously input from interested parties. Before I go on, I will just say one thing, just to manage the discussion as we go further. Some of the hearing statements do go beyond the critique of the engagement and the, if you like, the procedural side of the engagement, and get into matters of how the council have judged, council judgment on particular sites. Don't necessarily tend to get into those issues there about merits of a site or merits of allocation. That's for another time. I'm more interested in procedural issues and whether or not the council's met its obligations under the regulations and its statement of community involvement. But I'm going to start, so starting with my question 1.12, which also takes in question 1.14 really. I'm going to look at the regulations. Regulation 22, this is local plan regulations. Regulation 22(1)D requires copies of representations made in accordance with Regulation 20. So that's the consultation that took place, Regulation 19 plan. So the representations that were made at that stage to be submitted to the Secretary of State, i.e. me. Also in relation to this, Regulation 22(3)(3 requires, amongst other things, for the local planning authority to make available any documents referred to under paragraph 1D, which includes copies of the representations where it is practicable to do so. Beg your pardon while I open my copy of the regs. So, as recently as last week, I understand there are another 117 representations added to the database. I have received those, just so everyone is aware of that. I have, as far as I'm aware, well, I'm hoping I've received them all. Clearly, I haven't had time to consider them or give them any particular thought, given that I only received them on Friday. And obviously, the purpose of Regulation 22 is to make sure I have all the information before me, before I get to this stage. So it is an issue. Just first point, those 117 I know about, there's been other changes. Just roughly, can you just give me a quick run through of the changes that have been made to the database, spreadsheet, whatever you want to call it, since submission? So I can, and just a sort of overview of the changes that have been made, not every single one, but how many stages of changes have we had? How many, and if you're part of that, you know roughly how many additional representations have been added to the database since the plan was submitted. That would be quite useful.
Yes, sir. So there are three separate areas that I'll deal with that are irrelevant when considering the extent of representations that haven't gone onto the database. And so can I start, perhaps speaking out of turn, but can I start firstly with an apology both to you and to the public? It is what has happened is something that certainly the council very much would have wanted to have avoided, and it has tried to do its level best to correct the situation. To the extent that now I can say that an external company is going to be handling all future database issues and future representations, such as they may be coming in through the bonification process and otherwise, which I hope will give you and members of the public greater confidence with the issues that have happened so far being eradicated for the future. But returning to where I was, there are three main areas. The first area occurred between August and November, when it was discovered that some 3,500 representations, that's not representors, but representations, were not on the database. So that's the first area. The second area concerns 117 representations that were discovered after November. From the beginning, at the end of December 23rd is when it was first discovered, indicated by the Enfield Society, and we're grateful to them for that. We have undertaken further analyses, but 117 representations are new. And that is of, or in respect of 41 representors. Now that's us having broken down after us analysing how many people who were told us by the Enfield Society had not been put on the database, had in fact been on the database, but in a different guise or by way of their other representations. Because, of course, what we're most concerned about is ensuring that those who either want to or have indicated that they want to attend the examination are given an opportunity to do so. So that's why we've looked just to see whether the representations, representations can be boiled down to those that are new representations in respect of new representors. So that's the second area to keep in mind, the 117 and the 41. The last group is a group of people who were identified over the last week, I think from the 16th of January. I'll check my notes, but as I'm speaking extempore, that's as I understand it. And that's 4 people. We have checked with regard to those 4 people, and I can give you details of who they are, should you want them this stage. But those 4 people we've checked, and in respect of 2 of those people, they already did have representations on the system, so they would have been notified of the examination. One of the representors is the partner of one of the representors of the 4, so 2 of them are partners, so we would expect them to be aware also of the examination. And a final representor, there is a person with the same name, the same address, I say the same name, the same surname, not the same forename, who was a representor on the system and so would have been given notification of the examination. So we as a result of that, just to put it in summary, in overall terms, with regard to the issue of notification, the 3,500 representations in relation to representors, those representors have been notified of the examination in the 6-week period. With regard to the 41 representors, they haven't as yet been given notification of the examination. And then with regard to the 4, we think that those representors will have been given or will have had notice of the examination. So that's where we are in terms of the degree to which those people have been notified. With regard to the representations you have, all of those representations, as we understand it now, have been given to you at least through the programme officer. As to whether they've actually reached you personally as yet, I don't know the answer to that.
The 4. So can you hear me? It might be
yes,
one
yeah,
microphone at a time. Sorry, I'm not aware. Annette has made me aware of. I didn't know it had been necessarily been sorted. I knew there was discussion. People had highlighted concerns. I wasn't necessarily aware that that had been resolved. That there was definitely 4 missing. So I don't think I've had their representations. Yeah. Okay. Is there anything else you want to say on the pro? A bit.
So that's the summary of the situation.
Okay. No,
I, of course, can deal with the law, and I can deal with the way in which we think it's appropriate to address the issues.
I'll be coming on to that. I mean, I will just say, obviously, it's a concern for me in continuing, even now, beyond today, because of the potential for people to be prejudiced and for me to have to basically repeat this session, no matter how likely or unlikely that may be. There is a matter of principle. I mean, I'm happy to hear representation on that. I'm not coming to a view now, but I'll be honest at the start. That's clearly something I've got to be mindful of, and fairness. I mean, it is useful to know the 3,500 because that, if they hadn't been notified, I think it would be a different issue to 41. But still, it's still a matter of principle. But let me go through some of my questions before I get to that point. If you like remedy and remittance.
Yes, quite.
Can I just understand? Because obviously, one of the things that I'm, aside from what I've just said, also worried about is this being a continuing issue as it goes through the examination. If I could just understand, if you have identified what failings happened and whether or not it's likely that I'm going to get a steady stream of this throughout the entire, process. So, we found another 4, we found another 10, we found, and if I could just understand what's precipitated this, it'd be useful, I think.
Yes, sir. I can. The issues arose around the systems that we used And also, it's fair to note the failing, or human failing, if I can put it like that. With regard to the issue of the technological matters, Mr. Gorse can, of course, speak to it in detail. But in overall terms, there is an inbox, but the inbox has a filtering system, a security filtering system. And that filtering system can either send back a blocked sender notification to the person who sent an email if it appears to be suspicious, or it can issue a warning that is then received into the inbox of the intended recipient. And as I say, there is a local plan inbox that representations could go into. And what happened in part was that when emails came into the system, they were sent back, or rather blocked. And it's the case that certainly some of the representations have come from a proprietary system. And I think it's in part the Enfield Society. And I make absolutely clear that there's no blame attached to the Enfield Society at all. And we certainly don't seek to ascribe any responsibility to the Enfield Society in respect of this, but just as a matter of how these things turn out. And what that proprietary system does is send block representations through its system. And if they are then blocked by our system, the return email will go to the proprietary system and won't notify the person because it goes to the proprietary inbox of that organisation that sends out the material. So we think that is part of the reason for it. Another part of the reason is, as I say, because of the checking that was going on within the inboxes, or the inbox rather, and that they were just missed in terms of those numbers. Now, I've put that in, that's as a generality, the position, and it may be that Mr. Gorse wants to, or Ms. Hope wants to add something more about that. But what I want to impress is that, that the problems around the 3,500 were the subject of checking and rechecking. And you'll have noticed, I don't think it's just teleological, I think it actually is a reflection of the fact that we have undertaken search, is that you go from 3,500 being initially missed to the 117 to the 4. So we don't believe that there's going to be a recurrence of this issue because of the rechecking that has gone on. And it took place over months, I should say, and there was an engagement paper that we produced as part of our MIQ responses that you will have seen, sir, that explains in detail, albeit in summary form, but in detail nevertheless, what we did in order to try to correct those failings. As I say, we think is unlikely that the matter is going to return as an issue. If it does return as an issue, and of course we cannot, and it would be wrong for me to suggest that we can guarantee a situation because we have had these errors occur, but we're as sure as we can be that they won't return. There are two reasons why I think that it will not come back again as an issue, certainly not in any significant way, or a way that would harm the continued progress of the examination. The first of which is the proprietary system that I've referred to earlier on, that once that's taken over, it'll be rechecked, and if by chance there is any missing, we'll have had, as it were, an audit of the system. The second is that if it arises in the light of what we've got by way of the reducing numbers of reducing numbers of people who have been missed, what we think is the right approach, and I'll come on to it and I'll seek to justify it later on, but what we think is the right approach is to carry on with the progress of the examination with the proviso that if any of the recipients, the misrepresentors who do want to attend the examination, if there are such people, of those 41, that they are given an opportunity to return to the examination and to make their representations accordingly. We think, for reasons that I'll come on to, I won't deal with it now, so we think for reasons that I'll come on to, that that's an appropriate approach. But if that is an appropriate approach, we think that with the objective, with the company objective, dealing with the handling of the representations, once they have identified anybody else, if there is such a person, then they can be notified in good time for the for a further date, should it be necessary. And so I've dealt with that in overarching terms. Is there anything else you want to raise in terms of the reasons? No. So we think that does the job of explaining the position in summary.
Okay, so other than the 4 that I don't think I have had, you're now satisfied then that all, like, in terms of the regulations, that all copies of the representations have been submitted to the Secretary of State?
Yes.
Other than the 4, which I've said.
As I say, so as sure as we can be. Yeah. We've checked and we've rechecked, as I say.
And then, in terms of making those the other side, so I have my own copies that have been sent to me as the inspector. The interested parties, members of the public,
yes,
have had to use the Excel spreadsheet or the comma delimited file to try and see representations. You will have seen that presumably, as you know, there's a mechanism there. The council isn't saying those representations, it wasn't practical to publish those. It's presumably not seeking to say, well, we couldn't do it because it wasn't practical. So no, it's practical to do it.
Yeah. So in terms of the regulations.
In terms of regulations, yeah. Yes. And then, but you'll be aware that there are representations to me through hearing statements where links to using the spreadsheet, links to representations are not correct. And I have to say, I have made you aware, well, I say you, it made the council aware, yes, of that myself. It was recently, a couple of weeks ago, when I found similar issues, and I obviously let Annette know. So in terms of the regulations and making representations available, has the council met the regulations in that respect, bearing in mind there are errors?
In straightforward terms, no, though all of the representations were not on the system. But I have said that I accept that it wouldn't be practical, or rather the practicality is something that it's obviously a requirement of the legislation. And as I indicated, in terms of your question, with regard to practicality, the fact that they weren't on the system doesn't mean that it was impractical to put them on the system. But in respect of the 117 of which we were unaware, there is a very real justification in terms of practicality that you can't practically put something up if you aren't actually aware of its existence. But I accept that it's an unattractive submission if I were to make that.
But it's also, sorry, just to be clear, I'm also talking about if I was going through, you know, obviously some people make one letter covers every representation.
Yes.
The link is to that, and it could be, if you've split it into 20 representations, there's the same link to every representation, takes to the letter, that's sort of fine, it's there. Where people have, if you like, followed the rules and done a separate representation for every point they want to make, I found that, I didn't go through 15,000 lines of the spreadsheet to make sure everything was accurate, but I have found examples where a summary would be to policy X. I'd click on the link and it would take me to a completely different representation. Yeah. And looking at the totality of that person, that interested party's reps, they might have made 10 reps, 10 summaries, but the link was the same for all of them. So it was effectively taking you to the wrong place every time. So what I'm really getting to is the 9 other representations that are in the system have not been technically made available to members of the public. Is that, yeah.
I accept that. I accept that, sir. They haven't technically been made available. The question ultimately is whether substantial prejudice has been done to any third party as a result of that. And that, I think, is going to be something, no doubt, that you'll want to deal with at some stage. I'm happy to deal with it whenever you wish to do so.
So we're well, you acknowledge Industrial Card Regulation 22 hasn't been met. So, and both in terms of the pre-117 and now the 117, well, the 117 are probably there now, presumably, aren't they?
Yeah, as I understand it, they have been uploaded.
But it's the
3,500, yes, those have been made available.
Yeah, but it's the technical errors, it's the technical things I'm slightly bothered
Yeah,
about, and I don't know if anyone's the council has actually been able to address that. Maybe it's. I mean, is this something that's actually feasible to address, given the scale of the exercise?
So maybe Ms Hope can just deal with that briefly, just that one point as to whether or not that has been corrected. I have my own position on it, but maybe that Ms Hope can do it.
We are committed to enhancing our future consultations. So we have appointed Objective, who were formerly Limehouse, as a consultation platform. So the platform will actually improve accessibility, so a simplified digital submission, enhanced tracking and also accuracy. So it's automated logging and categorisation of representation. So where you're clicking onto a representative commenting on policy SS1, it will take you to policy SS1. And also just streamlined management as well, so it's the efficient handling of large-scale consultations, so enabling officers to focus on analysis and also meaningful stakeholder engagement. So we have appointed Objective Limehouse to do this for us.
But in terms of the rectifying the errors in the spreadsheet, what is it, again, well, it's two things. Has it been done, or is it actually feasible to do?
It is being done, and it will be feasible through Objective Limehouse.
So is the intention then to effectively republish the database in a different format where all reps are linked to the correct place?
Yes, sir.
And how long is that going to take?
We have given an indication to Objective to get everything completed by the 31st of March.
So in effect, notwithstanding any other issues, it will take until the 31st of March to make sure Regulation 22 has been adhered to.
Yes.
Okay. So just to, again, you've already explained this, Mr. Reid, thank you. I've got questions. The formal notification has taken place of everybody, bar, as far as you're concerned, as part of the 41 who were part of the 117. Under Regulation 24, there's 41 who haven't been informed, and then the 4 may well have been under.
May well have been in substance.
Yeah.
Yes, but forgive me, sir. May well have been in substance, but of course the requirement is that there is notification, and I'll come back to whether that's truly a breach. But on the face of it, it isn't in fact a breach in respect of those 4. I think the position that you can take forward is that it's the 41 that need to be concentrated upon for the purposes of the regulations.
And for the same reason, obviously they weren't on the Regulation 19 database, so they've not been obviously invited to attend
Exactly
or submit statements and so on. So they are. So in the forms of, I suppose the question is, have their interests been prejudiced?
Exactly so.
And if you want to cover your,
Yes.
at least give your view on that now.
Of
I'm
course.
sure others will have a different view.
Yes, of course. The question ultimately is whether substantial prejudice has been caused by two issues. The first being the lodging of the representations, that's to say, objections to the plan and notification. Now, I say this, of course, with no disrespect to you, sir, but much as we are apologetic to you as to the inconvenience that you've been caused in the process, the issues around compliance with the regulations insofar as they affect you are ones that can, of course, be overcome because you're charged with the process of considering all of those representations in any event. So from that perspective, there wouldn't be, so long as the matter is corrected and so long as you have the representations, any prejudice arising to third parties around your ability to consider the matters. So then the only question is what prejudice is done to, or in respect of any party as a result of the representations not being available, and any prejudice done to the notification, in respect of the notification of those 41. Now, in terms of prejudice, it's important to note that it's a question of substantial prejudice. It's not just any prejudice. And substantial requires one to look at the substance of what actually has been deprived by a particular person or persons when considering the process, and what would indeed be ultimately a proportionate way to address any prejudice. So the simple fact that, in theory, somebody may have not been able to see somebody else's representation doesn't necessarily establish that there's prejudice, more importantly, substantial prejudice, to that third party. And of course, the courts will consider necessarily the question of substantial prejudice, both on a judicial review, if that happened procedurally before the end of the adoption process of a local plan, or statutorily under Section 113 of the 2004 Act in respect of an adopted local plan. And the case of CK Properties, which so we can certainly give you a copy of that, so you have it to hand if necessary. The CK Properties case in the Court of Appeal made clear that it was, in the first instance, rather, made clear that it was a question of considering in part the issue of prejudice. So returning then to those two areas, that's to say the third parties who haven't been able to see other objectors' representations. There's a further wrinkle in this insofar as that the Regulation 22 statement, on the face of it, could be regarded as deficient because it, of course, couldn't have looked at the substance of those representations. But what I can say is...
Sorry, I will be coming on to the Reg 22 statement.
Very good, sir. Can I say then, shall I set out my stall at this stage on that, which is that the Regulation 22 statement is to identify a summary of the representations issued at Reg 19. And we've undertaken a check of those representations, the 117 representations, and indeed the 4, to see if in substance they raise the same points that are summarised within the Regulation 22 statement. And we're satisfied that they do. So in terms of the substance of the Regulation 22 statement, the fact that those representations were not directly taken into account doesn't mean that you have a defective Regulation 22 statement, and in fact you don't, in the light of that. That's my position anyway, in respect of it. But it does affect the question of any third-party involvement in this examination, because that's who we're concerned with. It's these third parties here at the examination, as opposed to any third party who ultimately might want to make further representations. This is the time, post-Regulation 19, that those representations are to be made. So we need to focus on the nature of the representations that have been made by third parties in this examination through the MIQs to see if there has been any prejudice done to third parties as a result of not having these other objectors' representations. And it's probably clear now, in the light of what I've said about the summary of the Regulation 22 statement, that in substance, if one is looking at the strategic issues that we're concerned about in this part of the examination, we're looking at these issues. Those in substance have been covered off by the representations that have been made so far by the third parties. And I mean no disrespect, but they have been very clear and comprehensive in their representations. And they cover many different issues, quite rightly, in the light of the questions that you have asked. And they have been clear and to the point. And one can see in those representations that they don't seek to, except in very minor ways, refer to another third-party objector. And if they do, actually they refer to those who are already involved directly in this case. For example, TfL, which is something that I think the Enfield Society rely upon. But so, when one looks at the question in substance as to whether any third party here has been prejudiced as a result, or substantially prejudiced, as a result of not seeing those 117 representations, we think that that wouldn't be the situation. But there is a further question, which is, well, even if there is the potential, even if there is a risk of substantial prejudice, is that capable of being cured through the examination process in a proportionate way that wouldn't involve the adjournment of the examination at this stage? And we think there is, for two reasons. And I've indicated one of them being that there can be a further date set down in the future. Should it be that the third parties who are here now consider themselves deprived of the opportunity of saying something around a third-party objector's statement, and that has to be, again, as a matter of substance, being something of significance, they can come and attend at the same time as the 41, who I'll come back to in a moment. And that, in my submission, would be the proportionate way to deal with the question of any prejudice that might have been done to a third party, who we think, as I say, wouldn't, as a matter of substance, when you look at the representations, be affected. So that's what I say about the first tranche of issues. Turning to the second tranche, the notification question. Those third parties, as I say, they in substance are raising the same points that have been raised now. And as I'd indicated at the start, only 5 of those representors indicated that they wanted to speak at the examination. Now, we think that, and this arises because the Enfield Society was the society that provided us with the details of the 117. We think that the vast majority of those representors, the 41, have come forward through the aegis of the Enfield Society. And again, the Enfield Society, quite rightly, have been very clear and fulsome in their representations. They've covered all of the matters that they have raised at the earlier stages in the process. They've done, and I say again with due respect, a sterling job in representing the issues of those who support them. So we think that, and having done the process of analysing the position as well, we think that those representors would consider themselves to be adequately represented by the Enfield Society here in any event, so that you can take comfort that the issues that are raised or would have been wanted to have been raised are ones that ultimately would have been addressed by the Enfield Society. Again, however, there is the ability to offer the opportunity for those people to return to the examination in due course. And as I say, that would be the appropriate way of dealing with it, because the consequence of an alternative, that's to say adjourning the entire examination, is that there would be a very significant waste of resources and time that needn't ultimately be necessary. But that in part can't really be determined until you've gone through the process of hearing all of the the issues that have been raised. And so, in fact, it's a much more efficient way of going about the process, of considering all of the issues now and then seeing what is left as a result of what might be said by those 41 people. So that's what I'd say in terms of the issues that you've raised.
Okay, thank you. I'm going to move on then to, that deals with, I think, your position on the representations and the database. I'm sure we'll be coming back to some of that. I would do want to talk about the Regulation 22 statement. Obviously, there's a couple of versions of that. Under Regulation 22, 1C, the Council are required to submit a statement setting out which bodies have been consulted under Regulation 18, how they were consulted, a summary of the main issues raised in relation to Regulation 18, how many representations were taken into account, and then in relation to Regulation 20, the statement should set out the number of representations made and a summary of the main issues raised, some of which you've already talked about. You will have seen, first question first, really, very overarching. With everything we've talked about, are you satisfied that the most recent version of the Regulation 22 statement actually meets those requirements? I'm mindful of what you've just said about those 117 reps are effectively in the same main summaries and stuff like that, but in all other aspects, and particularly also when you've obviously you've read the statements from interested parties, which do, and I'll just get onto this, which raise particular criticism about the how the statement deals with Regulation 18, yes. Whether or not you're content that the Reg 22 statement is fit for purpose.
I do say that it's fit for purpose. Yes, of course, I've seen the representations that have been made around the failings of the Regulation 22 statement insofar as it doesn't deal, it's said, with various issues that have been raised by third parties. But it's important to come back to the regulations, which is that it's a summary of the main issues. And that judgment of the main issues is the judgment, ultimately, of the writer of the statement, which is the Council. So on a judicial review application, it would be an assessment as to whether what has been provided is in reasonable terms a statement that falls within the terms of the regulation. And when one looks at the document in that light, bearing in mind the wording of the statute, or rather the regulations, deriving from the statute as it does, one can see that it does cover the main issues. It may be regarded in some ways as being capable of being better drafted, but that isn't the question. So that I do say that it's adequate for purpose.
And that's both in relation to the summary of main issues raised at Regulation 18, how they've been dealt with, and Regulation 22?
Correct.
Okay. Sorry, Regulation 20.
Yeah, the test is the same for both. Yeah.
And I had a question about whether or not, given the changes that have been made since the plan was submitted and since the last version I got, could you be satisfied that it's still accurate? But I think you've answered that. I
think I probably did as a result of going on a bit long earlier on.
And then just finally, again, some points have been raised now, and I think I may have raised this through a query through a net at some point, is that the two versions are quite significantly different. Now, in my initial letter to the Council, I did set out some points about usability and so on, so I would expect them to be different because you've taken those on board. But I think the main thing, I think, is that it's quite a lot shorter, which is no bad thing necessarily if it's still meeting the requirements. But is it right? Am I right in saying that the main change is that the summaries of individuals' representations were removed for you?
That is right, yeah. Yes, it is. Sorry, so yes, that is right. At least in terms of my understanding.
And does that change anything in relation to the regs?
No, I don't think it does, if only because actually it was unnecessary to have that length of analysis within the document. I can see, of course, how that then raises expectations that that would be repeated in a later document. But it's unnecessary in order to accord with the regulations.
Thank you. All right, so I'm sorry, I'm moving on. I may as well get everything done. We may well break when I finish my questions, but I'm going to pick up some matters of the SCI and general sort of access to documents and whether there was any evidence of failing to meet the SCI's requirements. One thing I do want to pick up on is that you have seen, and I just want to get this for the avoidance of any doubt, there's been lots of criticism in various statements about the way the plan's been considered within the council and various approval procedures, including whether or not the plan should have been taken or was taken to cabinet and then committee and full council. Just for the avoidance of doubt, does the SCI or the regulations have anything to say about this?
So no, not in terms of the requirement for a particular form of decision-making process. In fact, the LDS was what said would happen in terms of one of the relevant subcommittees that was ultimately not used for, forgive me, I should stay close to the microphone, was not used ultimately for the purposes of taking the plan forward. But with regard to the SCI, that's not something that is required, but principally because it is a statement of community involvement. That's what it's dealing with. It's setting out the procedures by which those who are to be consulted on certain documents, including a plan or indeed a planning application, will be will ultimately be consulted upon. So, looking at the nature of the position, even if there were something in the statement of community involvement which set out some sort of governance procedure, and I stand to be corrected if I'm wrong about that, but or if that is in fact the situation. Even if it were, that isn't something that would be ultimately a breach of the statement insofar as what it needs to deal with.
Thank you. Yeah. So, to all intents, but internal governance procedures are not, as far as you're concerned, within my remit.
Exactly so.
Yeah. Okay. Just on this, I did note, it has been pointed out, well, I read it as well, that the LDS does refer to this, but again, in the context of what I'm talking about today, in terms of SCI and the regulations, does that have any bearing on my conclusion, do you think?
No, I don't think it does. And the other point to make about the LDS saying what it does, of course, there's a requirement to accord with the terms of the LDS, but the LDS, again, is looking at the timing of the production of a local plan or indeed any other development plan document. And it's that which needs to be considered for the purposes of assessing compliance with it, not governance procedures.
Beg your pardon. Sorry, I'm just making sure of where I am. The SCI sets out potential consultation techniques in a table, which I've got I haven't made note of the table, but again, any suggestion that you haven't done what you said you would do in that regard?
No, the obligation in terms of the SCI under the Act is ultimately in relation to the preparation of a local development document. And when one reads the relationship between Section 19 and Section 20, on the face of it, preparation is up until the point of deposit, or rather submission of the plan for examination. So that anything that happens thereafter wouldn't, on the face of it, be a breach of the SCI. So that I accept that that's a point of statutory interpretation, and here we're concerned with the practicalities of the decision-making processes. And of course, a series of steps were identified within the SCI. And to the extent that there is any contravention of the SCI, it's capable of being overcome by virtue of the issue of prejudice. So I was just at that stage of going to the SCI itself. Could I just be given a moment to make sure I... Yes, the relevant part is, it's in sub 17 of the database. So it's page 14.
Figure 2.3.
That is, yes, that's exactly it, so yes. And then further down is dealing with the regulation 19 stage on the PDF, page 14. And
So just as far as what you were saying about the stage 4 of that table,
yes,
if you like, or is...
Stage 3, I think.
Sorry, stage 3 is the relevant one. So up to stage 3, the relevant one. Then post submission,
exactly.
it ceases to be it's like the duty to cooperate. In effect, it ceases to be a test.
Exactly. Yeah. That's exactly the point. And one can see why there's a purpose in that, because again, the SCI is dealing with the consultation process, and as you know, there's clear authority to the effect that the Reg 19 stage actually isn't a consultation stage at all. It's the pre-stage before submission, because the representations are considered by you. But going, though, nevertheless, to the SCI's provisions at page 14 and 15, you'll see that under the second bullet, under the council will, it says, send direct notification by email to specific general consultation bodies, duty to cooperate bodies, any other key key stakeholders and members of the local community registered on the local plan consultation database and requested to be notified, and publish a notice in the local paper specifying the consultation period and locations and where the documents can be viewed. The council may use any of the consultation techniques. And in terms of actually inviting people to be consulted, which is, of course, what those various steps are related to, at least as far as I understand it, there's no difficulty with regard to the compliance with those elements.
Okay, thank you. Just if we go back, if you've got the SCI open, if we could scroll back up to paragraphs 1.14 to 1.16, which is titled
Yes.
Community Engagement, or Consultation Principles, I should say. It's got a lot of it's got bullet points, which I'm not going to go through in any detail, but what is the relationship between those bullets and the table in figure 2.3? And I raise this because obviously, again, you'll have read in the hearing matters statements that the concerns that while you might have met the consultants on these things, it's things whether criticisms of whether it's been meaningful, for example, proportionate scale and so on. How does that fit into my deliberations, shall we say?
So it's certainly right that the principal requirement within the Act is to ensure compliance with the consultation, the statement of community involvement. And when one looks at what the statement says, it includes the consultation principles. But the consultation principles are drafted in broad terms. And I should say that at the outset, and you've seen our MIQ responses on this, that we believe that we have engaged with each of those elements, and we have assessed the processes, or rather the responses, in accordance with those aims and objectives. It's fair to note, though, that when one is looking at the question of compliance, it's compliance in overall terms. And the most important aspect is ensure that there is adequate consultation ultimately, so that there can be consideration of those representations by the council and consideration of the representations by you. As I say, we've accorded with the second part insofar as we're required to the extent, of course, of having the errors around the non-notified representors. And in relation to the Regulation 18 stage, we have engaged, we say, with those particular elements, but they are only a part of those elements. And the principal requirement is to ensure that all of those representations are with the council, so that they can be properly considered.
Thank you. Okay. So the other point is about consultation material and whether it was whether it was sufficiently clear as to what the consultation was about and not misleading in any way. And that particular point comes about where seemingly some of the material didn't refer people to specific sites or allocations or make it clear. Again, do you see any breach of the SCI in that regard?
No, so there of course are going to be glitches in a system, but to focus only on those glitches means that you don't look at the matter in totality. We're dealing with a very complicated plan and undoubtedly with a large number of other evidence-based documents. And the question ultimately is whether the council has done enough to ensure that the substance of the issues, those that are of real concern to third parties, are raised and are capable of being engaged with. And it's fair to note again that when one sees the representations made even at Reg 19 stage, that has been done fulsomely by the representors. So they haven't been in difficulty in terms of understanding the principal issues that need to be considered. And in more general terms, of course, aside from looking solely at the database, one matter for consideration is how far have members of the public understood that there is a plan that needs to be considered, and how far have they been able to look at the substance of the main issues that they want to make representations on. And it's clear on the face of it that given the rounds of engagement that we've had in this case, that they have been able to both understand the nature of the plan's direction and the issues that it raises.
Thank you. The other thing, as you say, it's a complicated plan. There's a lot of evidence. It's a dense plan. You will see from my matters questions. I think we'll be coming on to some of that at various points. Slight digression as to whether it's all matters of soundness will be open to debate and something to consider later on, but I think there probably will be some. But the point, again, put to me, I think it's fair for me to highlight these points, is that the volume of evidence that was published in one fell swoop very close to the start of the consultation period made it very difficult for people to actually engage with the process properly. Again, what was your view on that?
Yes, it is, as I said, it's a complex plan, and as a result of that, it's unsurprising that there's a significant amount of documentation that is necessarily something to be, or something that has to accompany that plan in order to understand the justifications for its approach. And the numbers of documents, whilst in page numbers it can appear to be very significant, actually the substance of them are no more than one would expect to find in the examination process. There's no doubt you know, and no doubt have experience of. Well, you do, obviously. There are some ways that certainly we've tried to ensure that people do have a proper direction towards the decision-making processes. And that's by issuing topic papers at an early stage, which have enabled people to understand the substance of the rationale behind the decisions that have been made. And so we certainly, there was a large amount of material, but it's justified in the circumstances. The other question is, how much time did the third parties have to make representations? Well, we accorded with the terms of the SCI in relation to the length of time that we would give members of the public to make representations to consider the relevant material. And I take the point that it may be considered that it's insufficient, but actually, in some regards, we went beyond the statutory period and beyond the SCI period. So in terms of the pre-publication, it was, I think the documentation was available 12 weeks before the submission itself. Now, I know that there may be comments about, well, why did that arise? It was actually asked for by certain politicians who wanted to ensure that it was proper engagement. But the reasoning, I don't make any representations on. I'm simply making representations on the amount of time and is it sufficient, and it is for those reasons.
Yeah, thank you. That's all from me for now. Other things may arise as they occur to me. However, and I do apologise to everyone who's had their... Oh, there's only one. That's surprising. One went up and down. But I think give it as it's 5 to 11. And I said we'd have a break at 11, and you've had to sit and listen to me for some time. I think I'll take a break now, and we'll come back at 11:15 to pick up the comments from around the table, and then obviously anything else I need to address as part of this. Is that okay with everybody? Thank you, and again, thank you very much for your patience, and we'll come back at 11:15. Thank you.
Can I just say,
sorry, beg your pardon.
I'll be taking some instructions over the next break, and it may be that there is something else that I just need to say in order to make sure that everything is covered off for present purposes. Can I?
Okay, yeah, well, all right, we'll come back to you first, then, if there's anything you need to say, and then I'll open it up. Okay, thank you. Right, so yes, 11:15. We'll continue. Mr. Reid, did you have something you wish to add?
I did, sir. Thank you. Yes, there is one other matter that I should deal with, and it concerns part of the Regulation 22's statement in its current form. That's to say, in the form that you'll find in sub 12.1, because there's a schedule within that, Schedule A2. Which is at page 100 in the document. And that schedule shows the differences between Regulation 18 and Regulation 19.
Bear with me a second.
Of course, sir.
Sorry, table A4.
It's Schedule A2, it should have on it.
Sorry.
Yeah. Page 100, both the PDF and the document.
Sorry, is this sub 12.1?
It is sub 12.1.
Oh.
Which should be the Regulation 22 statement. At page 100, you should just have one page, I think.
Oh, yes, sorry. Beg your pardon. Here it is. Yeah.
Good, thank you. What you'll see at the moment is that it is just literally one page. It, in fact, should be a schedule that includes the includes the actual changes. It's a lengthy part of the document. Includes the changes between Regulation 18 and 19. That was in the original submitted Regulation 22 that was sent to the Inspectorate in August. But when it was then updated, that schedule wasn't included. It's an administrative error, but nevertheless one that we want to have corrected. So I'm flagging that up at this stage. Can I put that on probably the first of my list of requests with regard to documents that can be uploaded? As I say, it was there originally. It was just missed in the updating.
Okay, if it's not going to change, then sub 12, the original.
Yes, it's just literally inserting the original.
Let's make sure that's still on the examination website. Should be, presumably.
The original has been just literally replaced by the updated.
Right.
So that's why it's not.
Probably need to rectify that.
Yes.
At our end, so we've got both versions. I think would be sensible. But having the full document, I mean, may well be. Just hold fire on that, because obviously there may be other changes. You know,
Exactly so.
There may be a general outcome of this where I ask for
Yes.
a revise, sort out everything.
Yeah, quite. Quite.
In which case, but okay, thank you for that anyway.
Thank you.
Okay, thank you everyone. I will go around the table. I can't remember who got their sign up first, so I'm just going to go around. Well, I was going to. It's very kind of you, but I'm going to go around that way. I'm going to go around anti-clockwise. Just for now, because I can't see, if you could just remind me who you are representing when, and I'll say I'll get the hang of it as I go on, and just make your point. What I'll do, is also go around everybody, build up. If the council could obviously make a note of what's been said, I'll build up a set of points that the council may wish to come back on. So, but thank you.
Yeah, so Steve DeVos on behalf of the Hadley Wood Neighbourhood Planning Forum. The main question I have is that it concerns one of the most controversial parts of the local plan is obviously the greenbelt allocations, and in terms of whether the MPPF has been complied with. One of the main issues that we had or have is that the key evidence was in fact only published and maybe produced, who knows, after the original date of the council meeting of the 6th of March 2024. That was deferred after legal counsel objected to the proceedings. So I don't understand how you can have a vote on submission of a plan when key topic papers where the evidence or substantiating or evidencing the exceptional circumstances, etc., are published.
When you're going to just get some clarity on that, when you say were published, were they available during the consultation period?
No.
No.
The first sight that the public had was after the 6th of March. It was about a week later that they were published.
Okay. So and the consultations took place. It was published during the consultation period.
It was before the consultation took place, but after the date of the council meeting.
Right. Okay. But you could comment on it if you wanted.
In the Reg 19.
Yeah.
Yep.
Thank you. Is there any other points you want to make? No. Thank you. Mr. Harbert.
Yeah, thank you. I don't know if this is the right time to discuss your question 1.14, but have representations been adequately taken into account? My concern is that we have submitted significant evidence over every round of producing this local plan, and similar evidence in the preparation of the Hadley Wood Neighbourhood Plan, but the consultation statement doesn't make reference to this evidence. It simply asserts that a number of key planning documents respond to our representation. And as you will most probably have seen from my written statement, I've analysed those key documents, and they include practically no information about the proposed allocation of site in Hadley Wood. So they've cross-referenced the spatial strategy, the exceptional circumstances topic paper, the site allocation topic paper, and there is the occasional paragraph and less than 1 page in total responding to hundreds of pages of technical submission. And when you analyse the responses, they don't address any of the detail. There are errors and omissions. So in the case, and I know I have to do it in relating to my own personal representation and personal written statement, there is no response. So the representations, I have to conclude, haven't been taken into account. They've been ignored. There's no robust criticism, critique, justification, explanation, or any other fact that would lead me to a different conclusion or convince me that the evidence we've submitted has been treated seriously. Thank you.
Okay, thank you. Okay, thank you. Various groups, wasn't it? Yeah.
Jump around a bit in response to some of the statements that have been made. Firstly, in terms of the length of the plan, I'd like to draw attention to MPPF paragraph 15, which requires that plans should be succinct. This was anything but succinct. And why that's important is that, as was said, the policies have to be read as a whole. Such lengthy plan makes it really hard for decision makers to make the necessary decisions when planning applications and other things come in.
Sorry, I'll come on. I've made a note of that in my other matters. So we will come on to that. But
Okay.
Obviously, if there's a point of that which relates to the consultation and engagement, because obviously what you're talking about there is implementation, really.
I'm talking about how long it was. But yeah, okay.
Yeah,
yes.
but if it's,
Yeah.
I'm talking about, in terms of engagement purposes.
Right, okay.
The effectiveness of the plan, because of its length,
Okay.
is something we'll definitely come on to.
Okay. Right. Well, the next one is about the representations. I think that, it's wrong to say that missing a few representations is not important, because you don't know what's in those representations. And I highlight the Western Enfield Residents Association one, which did finally get in there, but was totally missing for a while. And that represents about 1,100 people who live in Western Enfield. So it's not immaterial that their voice should be heard. I would also question that there's no breach of the SCIs, of the SCI. I think one of the people up there is going to talk more about that. And the level of public engagement and understanding would not have been where it was were it not for all the local groups. We sent out 25,000 flyers. We had banners up. We had meetings. We reached out to people all over the borough so that they would understand the plan. And then the Enfield Society facilitated them responding. Those were not only supporters of the Enfield Society. They were people who found it easier to do it that way. And just a correction on the pre-publication, that was not because of politicians, as stated. that was because of a public petition which raised over 4,000 signatures asking the council for advance notice of the plans so that we could read it and have time to read it, so that members could go out and have forums in their constituencies and inform their residents. So that's why that happened. Because of change of personnel, it was subsequently forgotten that that commitment had been made, but we reminded the council and they did fulfil that commitment, so thank you for that. And in terms of the Reg 22, as the gentleman over there said, it doesn't include everything. It doesn't include Enfield Society, Reg 18, things about the area of special character. And at Reg 18, the Enfield Society also submitted about the structure of Enfield Chase, and that's not included or responded to. So it isn't complete. So those are my points for now. Thank you.
Thank you. Moving on, is it Enfield
Yes,
Society?
I would like to respond very briefly to the matters of the missing representations, partly because I guess could be partly responsible for causing this problem, as I was the IT engineer who put the form together that about 7,500 representations were submitted to the council via. I have been working since August to try and resolve the missing representations. I'm only able to speak about missing representations that were submitted by the Enfield Society's web form. I don't know if the council, in their comments about this, have included other missing representations. We do believe, as it's been pointed out, that the Western Enfield Residents Association was missing, and I don't think that was published through our site. There are three things I want to just point to. The first is that we became aware that there were problems submitting representations during the Reg 19 consultation. And as a result of that, on the 22nd of May, which is after the consultation ended, we submitted a full spreadsheet of all 7,500 representations that had been made on our platform. So the council had all this information right at the start of the period. However, there have been several databases, so-called, published in the interim, which have progressively added more and more to the public record. In early November, I sent a secure file to the council containing about 700 representations, which I thought were missing at that point. But that still didn't fix the problem, because after the November's index was published, there were still 446 missing, according to my analysis between what we recorded on our website and what was in the council's record. Then in mid-December, finally I sent another record through to a different council officer, and that resulted in the latest file, which was released on the 15th of January. Now, I've not been able to analyse that file because I've been preparing for the examination, but my initial view is that, yes, a lot more have been added to the file, but unfortunately, the names have been put in the wrong columns. And so, at the moment, I'm unable to do an accurate analysis to see whether everything has been resolved. I'm hopeful that it has, but unfortunately, I can't confirm at this examination meeting today that it has. The other point I would like to bring to your attention is the matter of Top 5, which was the exceptional circumstances paper of the release of Greenbelt. Now, this was not published in December when the council published other documents in the 12-week period leading up to the full council vote in March. And I opened an FOI with the council asking for the document in mid-December. And in mid-January, just before the end of the statutory period for responding to the FOI, I received the following reason why I couldn't have it. I can confirm that the council holds the requested information. However, this information is exempt under Section 22 of the Freedom of Information Act, as the requested information is intended for publication at a future date. So this important document was actually available in the Council's record, but it was withheld from public view. Thank you for your attention.
Thank you. Just one quick question to you then. Going to, I will thank you, as far as I'm concerned, for helping the council. It seems in the background with all this. It's very helpful, and I appreciate it. You said you've had several tranches of changes, and there was in mid-November there was still 446 or 464 missing.
Yeah.
And then in December, the 117 we've been talking about were found. As far as you're concerned, are you still, I mean, I know you've not had to be able to look at those, but are you still on the working on the basis that from your system there are still missing, further missing reps, or are you now content that, at least as far as the Enfield Society's
no, I can't be content, because, as I mentioned, the names that were added in the latest version of the index, which incidentally on my count is number 8, the names have been put in the wrong field. So the automatic script that I've got that does the data comparison, and there's over 15,000 records to be checked, that has failed. So I need to update my record, or the council needs to republish the index with the names in the correct fields. I would like to thank the council, though, for taking on my suggestion of publishing the index as a CSV file, because working with proprietary Microsoft spreadsheets is not easy. CSVs are much more straightforward. So thank you for doing that.
Thank you for that. If you've said what you need to say, can you put your signs down so I don't come back to you? Obviously, you can put them back up again if you need to. Over 50s forum, please. Thank you.
Thank you, thank you. I'll be corrected if I'm wrong here, but I think we've heard that the consultation statement is a summary of the main issues, and therefore is kind of without prejudice, because it covers all of the submissions, even the ones that came in late in the day. Now, what I'm about to say I think might come up under question 1.14, but I'm slightly uncertain, so just in case, we think that there is a major issue that has not been represented in the summary, which is the issue of older people who are not likely to be in need of care or specialist accommodation. We, the forum, exists to support older people, keep them informed, blah, and always bear them in mind. I think we feel that our representations have not been kept in mind, because the majority, the over 50s, according to Enfield's 2024 Borough Profile, page 11, says the over 50s make up a third of Enfield's population. That's not insignificant in our view, and it's projected to grow. All being well, the vast majority of over 50s will continue to live independently up to 60s, 70s, 80s, 90 even, if my neighbours are anything to go by. And we don't see anything about their accommodation needs. So the notion that the consultation statement, and we've been making this point since Reg 18, represents the main issues. I think we're kind of puzzled, really. Thank you.
Just to explain, I said I'd play devil's advocate now and again. Just to play devil's advocate on that, if obviously through the course of the examination you're able to put those points to me, which you already have, and there'll be other opportunities to do that when we get into specific policies, does that set your mind at rest at all?
You mean if I can continue to contribute to this hearing in the way that I've planned, will I be content?
Yeah,
Yes.
I mean, at the end of the day, obviously, there's one element as Mr. Reid points out, and it's something I've got to consider, is prejudice. If there is a deficiency, how can it be addressed? And it may well be. I'm not coming to any conclusion on that yet, but it may well be one of those ways to address it. Is obviously you have the opportunity to come and tell me these things, tell me why the plan isn't sound on that basis, and then I consider it. So it's whether or not it not, the Reg 22 statement not including that particular point is going to prejudice your interests at all, I suppose,
And
is the question.
that's the question for me now. I think it's actually quite tricky because we're volunteers and not lawyers, and are very mindful of the kind of minefields that can emerge when discussing issues of prejudice. So I think I'm open to be wrong, but I think we feel that we've made, through all of the questions that are due to emerge today and be discussed, we're not at the moment confident that our views are heard. And in terms of a third of the borough's population and their accommodation needs. And I think I'd want to add that this is almost not a selfish position, because many older people live in family homes. And if there were to be a what we would consider a coherent policy, like there is in the London plan, then we would feel that we were making a substantial contribution both in this process and to the borough as a whole. We can unlock logjams.
Okay. Well,
Thank you.
I think the thing is, part of my role is to make sure everybody gets the opportunity to say what they need to say. I'm very confident that there'll be more than ample opportunity for you to put those points forward as we go forward. But in regard to the question 1.14, if you like, obviously I will go back to the council and get them to talk about that anyway. So thank you. So if we move on to the Better Homes Enfield rather, and does that say England on it?
It does say England. We've expanded. Just this morning, big announcement.
I think it's good that I'd noticed it was an error. I think I need some credit for that. Thank you.
Thank you, sir. So I'm going to just try and deal with some of these issues chronologically and briefly. So there was 2 Regulation 18 consultations. There was one in 2018-19 and then another in 2021. We cannot see that either of those consultations, the responses to those, were taken into account adequately by the council. And this has real implications. So one of the things that was raised by us and others at the second Regulation 18 consultation was the volume of evidence that was published simultaneously. We didn't just raise it in our representations, we also sent letters complaining about it, and I know that others have as well, because I've seen the Enfield Society's hearing statement. So this was a big issue. It then followed that there was a petition signed by thousands of people, and linked to that was about the way that the local plan was being conducted in terms of the volume of information that people were being asked to deal with. So we moved forward in that context to come to the Regulation 19 consultation. And at that stage, 300 documents plus were published with over 7,000 pages of information. Now that is massive. I've gone through lots of other Regulation 19 consultations, and I can't see anything remotely of the scale of that. And I also note that some of those documents didn't make it into submission, so I question why those documents were put forward in the consultation. It was just completely overwhelming. So this was completely against the spirit of the petition and against the Reg 18 issues raised and the letters of complaint about the volume of evidence, which was only about 60 documents at Reg 18. So the issue is how long do you have to look at that information as a volunteer community group? And what we had was 7 weeks. Okay, well, a bit more than 7 weeks, but roughly 7 weeks. Now, the problem with that is that's about roughly, excluding the plan and the IIA and various other documents, that's about 1,000 pages of evidence a week that you have to try and think about if you're trying to understand the plan in its entirety and try and really get to grips with it, which is what NCAF and Better Homes Enfield did. We approached it seriously and took our time to really get to grips with it and to try and understand the council's arguments and the council's positions. It was completely overwhelming. And that was made much worse by the fact that it was conducted during an election period and during Easter. Now, 1.13 of the Statement of Community Involvement says and commits the Council to following the government's 2018 guidelines. Those guidelines say that you should not carry out consultations during an election period, but that is precisely what happened. Now, that impacted us because we were trying to have conversations with the GLA and with our councillors, and it was difficult because they were in a political mindset. And we did manage to have a meeting with the GLA, but it was difficult because they were hampered by the fact we were in this period of an election. So it did hamper us. In terms of prejudice, well, we are prejudiced because we weren't able to respond to all the things we wanted to respond to. I'll give you an example. We weren't able to respond to the industrial land issues, which we would have liked to spend much more time with. It was just completely overwhelming. Mr. Lack has picked up an issue of freedom of information. You'll note from our statements, we also had issues with getting information from the council, which speaks to a lack of transparency. And we're pleased that Judge Buckley has found in our favour now for the council to release the information that we want. And the other outstanding FOI is still with the Information Commissioner's Office. This isn't in the spirit of transparency in terms of a local plan, that we have to work that hard to get missing information. So we move on then to how the information's been dealt with. And I think Mr. Reid mentioned that the council had done its level best to correct the situation. Okay, so we informed the council of issues with our statement in October. We then received a response about them, and we went back and they were still not corrected, same issues. We then issued another response saying these issues are still there. Our representations don't appear under the correct policy number. So if you were looking for specific policy responses, we've responded to specific policies, and the council has decided to reallocate us to other policies, but not keep us in the ones we responded to. So you'll never find us under those policies. And they were aware of that, and they said it would be dealt with at the examination, rather than actually just addressing it before. So we don't really agree that they've done their level best. In terms of using that Excel database, it is, in terms of the issue of prejudice and time, it is not that there are a few issues, there are massive issues. And it takes up a huge amount of time to actually deal with them. I can give you an example. Just the other day, preparing for this hearing, we were trying to look at the statements made by Trent Park Golf Course, for obvious reasons, because of the TfL statement. Quite reasonable to try and prepare and think about that in some more detail. Now, one of those statements says, Trent Park Golf Course has provided a map. You open it up, no map. So we're not quite sure which bits of land it's referring to, which we really need in order to understand their representation. There's another bit of the Trent Park Golf Course representation which gives a long spiel, a long summary about what it says. You open it up and it's just a blank form, completely blank, not a single word on it. So we completely disagree. And these issues, were these one-offs or just occasional, then yes, I could see that how could we be prejudiced? But of course we are. If there's so much of them. Now, where does lots of these issues stem from? Well, in our view, one of the big issues, and it'd be good to try and understand this, we think, is the potential use of AI in generating summaries of our responses. And what that seems to have done for us and for others, but certainly for Better Homes Enfield and NCAF in particular, is generate rather odd summaries of our consultation responses. And just to let you know, we checked lots of these and we put them into AI checkers. And every single one we checked came up with 100% certainty that it was generated by AI. The problem then is that that means that the summaries, our representations, are not accurate. But then I think the subsequent problem is that I think the council, when it responded to our representations, was responding to the summaries. So I think the summaries probably weren't the responses were not AI generated, but they were a response to an AI generated summary. And that's where a lot of the issues all seem to stem from in terms of this strangeness that you get when you look at the summary of the representations and the council's responses. And I think that and also alongside our statements, both for Better Homes Enfield and NCAF, spells out our issues.
Okay, thank you. It's very helpful. What, from your perspective, then needs to looking to if I determine there was some issue to address, how do you see the issue being addressed in the context of the examination? If you can answer them.
Yeah. So we would need considerable time to look at a corrected version of the database, and I have to say that we're quite concerned about the underinvestment in trying to do this consultation with Excel. Just seems, I mean, yeah, they spent £7 million and they didn't spend barely anything on dealing with the consultation. But we would need to kind of have a much better, accurate database which we could use as part of the ongoing plan making, but also we would be needed to give the opportunity to revisit our representations for Regulation 19, because we were prejudiced, because we could not submit, because we ran out of time. So there are areas where we could not submit on. And that means we haven't submitted hearing statements, because our understanding is we can only submit on the things where we've actually responded to at Regulation 19. So we are blocked from actually being heard. If we were to be allowed to be heard, we would need time to prepare.
Thank you. And Councillor Georgiou.
Thank you, sir. And as I understand from Annette, it's your call as to whether Councillor Roy can sit next to me. Otherwise, we're happy to hot seat because he has contributions in this area as well. It's ultimately your decision.
For now, we'll hot seat, I think.
Okay, thank you. Can I begin, given the nature of the beginning of this representation, to make very clear that the aim of the Conservative Group is the adoption of a local plan that is sound and consistent with the London plan. So going on to the database at the beginning, and some of the things that you've already teased out from Mr. Reid, is that essentially we have a database that even as elected politicians that we're looking at, which is collapsing in on itself, which as far as we're concerned is not the best way to do it. The missing representations have already been addressed, and we've had a number of residents and just so you're aware, there are 25 Conservative councillors in Enfield. Many of us have had representations from residents where they have said things have been missed. We've reported it to the council, and things have eventually gone on. But that's not clearly how the process should have been run. And as far as I'm concerned, having been a councillor for 11 years in this borough, having a spreadsheet of representations is not fit for purpose. And I'm clear in my mind that it should never have been a spreadsheet in the first place. Responding to a point that Mr. Byrne made, you know, I was a candidate in the 2022 elections. I also got elected to the London Assembly in the 2024 elections while all of this was going along. And I can assure you that it is not conducive to good plan making whilst electioneering at the same time. And that goes for any politician. I don't think any colleague would disagree with me on that point. The issue of the 7,000 documents has already been addressed, but I'd like to point out from the perspective as a leader of a group and an elected official. So as you know from our representation on matter 1, the full council meeting was due to be held on the 6th of March, where we were meant to debate the local plan proceeding through representations made through various residents, a petition, a lot of work on our part as well, saying to the council, we understand there are a number of missing documents and pages that are very important for us to consider before this meeting. So in our view, inappropriately, the council said, okay, we will delay the meeting, but then dumped 7,000 documents, including, if I remember correctly, the exceptional circumstances for building on the Greenbelt document, therefore only allowing us 1 week before the full council meeting was moved to the 19th of March to consider them. Now, look, all 25 of my, well, including myself, 25 councillors, I believe, are very diligent and voracious readers. But with the greatest respect, given we are not lawyers nor are we planners, we are politicians, could we possibly consider 7,000 pages in a week? It is impossible, even if you divide that up between you. With regard to the Reg 22 comments, and my colleague Councillor Rye will be addressing the cross-party working group, but what I've understood from Mr. Reid is that he is content with the Reg 22 consultation statement. Well, there is actually, and I have to be very careful with my language, because please correct me if I'm being inappropriate, but there is at least a misleading statement in the Reg 22 consultation statement, which suggests a cross-party working group had been meeting since 2022 with full involvement with the opposition, which was not the case. On the SCI, so the 2020 version relating to the consultation principles, as far as we're concerned, clear and non-technical information, meaningful, strategic and early engagement and openness, as elected representatives, we feel these have not been met by the council, especially due to many of the complaints we've received from our resident. So I would summarise before I hand over to Councillor Rye that there has been a clear democratic deficit in this process on our part. But I will hot seat over and I'll allow Councillor Rye to continue.
Thank you very much. I'm speaking as a councillor who's served through 2 sets of local plans. And what is different about the present local plan process is that on each of the previous occasions, and as far as I'm aware, always previously, there had been a cross-party working group, originally under the committee system and more recently under the cabinet system, with the minority party attending but not having a vote in terms of the process. The consequence is that the first iteration of the local plan under Regulation 18 would have come forward with a considerable degree of support from probably both sides of the chamber. This did not occur on this occasion. Notwithstanding that I did bring forward an opposition business paper to request that this took place, and the comments that I've just made were repeated in the council chamber to explain that this was the process that had happened previously, with the councillors on that working party going through each ward of the borough, looking at every piece of land and every site and deciding which category they might fit in terms of a new local plan. The majority party agreed the opposition paper to have a cross-party working group, but then when the group formed, they were only prepared to put forward half a dozen or so sites for discussion that they had already predetermined, the majority of which were in the Green Belt. And this was completely against the spirit of the opposition paper and unacceptable to us, so therefore there was no cross-party group and there was no cross-party working. I'm bound to say I'm disappointed we're in this position, because I think the shambolic nature of things thus far have in part been because there's been a lack of oversight by experienced councillors on both sides on a cross-party working group from the word go to address the issues that some of us have heard about this morning. In terms of the original iteration of the plan under Regulation 18, to which there was a considerable degree of public response, there was no sign this public response had been responded to in the second iteration that eventually ended up at the delayed full council meeting. And therefore you do have to question whether representation has adequately been taken into account thus far, or whether they will be moving forward. And I'll conclude at that point. Thank you.
Thank you very much. Thank you, everyone, for that. Quite a few points raised, some overarching points. If you've made a note of those, I'll happily let you come back on that. And if I think you missed anything out, I'll get you to respond to it. That's okay.
Yes, thank you very much. So yes, if I can start. I think with Mr. De Vos, which is a representation that is really about a concern that the forum's own issues around parts of the plan haven't properly been taken into account. Now, when one goes, we'll of course go through this when we get to the various stages, sir, but you will see that RUR2 has been properly considered, and that's one of the principal issues.
Sorry, that was not my point.
Sorry, if you could just wait until I bring you in. As I said at the start, I don't want people talking over each other. It really doesn't help me. So once Mr. Reed's finished, you can respond. Thank you.
As I say, I'll do my best to cover off the matters. I can't promise, given the number of issues that have been raised, that I'll be able to do so. But aside from RUR2, I was going to go on to say that, of course, there are other issues raised about other allocations, particularly in the Greenbelt. And the issue being raised by Mr. De Vos is essentially that there hasn't been a proper consideration of those matters. And we, as we'll come on to at the appropriate stages, show that they absolutely have been taken into account. So that, I think, deals...
I think the general point, which is picked up by a few people,
Yeah.
is whether or not there's sufficient evidence running through the Reg 22 statement and or the process that representations made at either Reg 18 or Reg 19 have been taken into account. So I suppose the point would be, from my point of view, what you are required to do in this regard, and have you done it?
Yeah.
I think you're right that when we get onto the have you taken, in terms of the judgment that you've come to as the council, whether it be about a particular site or a particular policy issue, then that's something to discuss at the time. But I think the general message from various people has been a significant amount of representation is made. It's not entirely clear that they've been taken into account, or indeed that a side issue to that is whether they've been summarised, and if they've not been summarised correctly, how can they have been taken into account correctly?
Sure. Absolutely. So I was going to come on to that in the context of some of the other representations. But when one looks at the Regulation 22 statement, and one has to take a step back and look actually at what the requirement is, which is a summary of the main issues. It's not absolutely every issue that has been raised. And that's a theme that comes through a lot of the representations here that you've heard. And they are complaints that the totality of the issues haven't been properly taken into account, when actually what needs to be reflected in the Regulation 22 statement is only a summary of the main issues. And when one looks in that light, one can see, for example, in part that we'll actually come to in the context of another representation, that issues raised by representors have specifically been taken into account and summarised. So that's what I'd say in relation to Mr. De Vos's points. Mr. Harbert's, I think, and I certainly apologise to Mr. De Vos if I've really focused on Mr. Harbert's points, because Mr. Harbert makes similar points, actually, I think, with regard to taking into account the documentation. He has raised, as one of the issues, the number of technical submissions that had to be responded to, he says, at a very late stage. And I'll deal with that, and it covers off a number of the other representations as well. In this way, that, well, firstly, there are some representations made that there were 7,000 documents. I think that was Councillor Georgiou's point initially. He corrected himself quite rightly that it wasn't 7,000 pages. But even if that is right in terms of the specific general number of pages, of course, there were, in terms of those documents, non-technical summaries that gave a clear indication as to what conclusions ultimately were being reached on various matters. So one was able to then fill it out in the light of that, the issues that have been raised. And it's important to note, and this is an issue, I think, for Mr. Byrne's comments, that whatever is said about the difficulties around the issue of considering that documentation, nevertheless, I'll come on to a specific point in a moment with regard to industrial land, but with regard to the representations that had been made by NCAF and Better Homes Enfield, they have made very detailed representations at Regulation 19 stage that you will have seen. And they've been carried through, indeed, and cross-referred in the hearing statements. And so it may be that there are difficulties surrounding the delivery of, or the consideration of documentation. But that is an inevitability when you are dealing with technical documentation that justifies a plan's approach. No doubt the council would have been criticised had it not actually published that information. And indeed, part of the criticism is that some things weren't published or republished. So in a sense, the council would be criticised whichever direction it took. We think that we've taken the right approach, and indeed, and I'll reiterate it, members of the public were given longer actually than the statutory period for consideration of the various representations. That deals with that issue. Then I think the next person is Ms. Fisk, who I think that is right, who also, she referred to the NPPF's requirement that the plan should be succinct. And it is succinct insofar as it deals with the range of issues that have to be considered. And of course, sir, that it is right. And I, of course, you know, it would be wrong of me to suggest otherwise. It is a lengthy document. I'm not going to suggest otherwise. But in terms of the way that it had to deal with a range of different issues, it has done so in a clear way that can be fully navigated. And the question is whether ultimately it does the job of being a sound plan, and that will be tested. But I do, on the part of the council, not accept that that point being raised by Ms. Fisk. Ms. Fisk also raised the point about the public, further advance notice being given to council members as a result of a public petition that had been given. I hope I've correctly ascribed that to Ms. Fisk. I think I have. And yes, I think she is right about that. As to how it arose, that's less significant than that it was correct that there had been advance warning. And I will just deal with Councillor George's point on that, which is that, well, I only had 7 days to consider all of the documentation. He, of course, is making actually a set of observations on the determination process, and that isn't something for consideration in this examination. The question is whether or not there has been a breach of the public engagement requirements. And a similar point can, of course, also be made in respect of Councillor Page's observations. And one needs to focus, of course, on what the issues are of relevance in this case. And it isn't the determination process, it is the consultation and engagement processes. And looking at Mr. Lack's points, yes, Mr. Lack's observations are that he can't be ultimately assured that our assessment as to whether or not various representations were on the system, and that we are left with only 117 representations of 41 representors is correct. We think we are correct on that, and the question is ultimately what is the prospect of there being further people beyond those that have been identified. As I said earlier on, we can't rule that out. The question is what proportionately should be done in order to achieve the right results that is fair in the circumstances. Given, as I said, the declining number of identified issues, we think that the right approach is to make available a later date for consideration of the issues. Then Ms. Pite, on behalf of the Over 50s Forum, made the point that the Regulation 22 statement is inadequate because it didn't deal with older people. I don't think she's right about that. If you look at the Regulation 20 statement, you'll see specifically that the Over 50s Forum's representations, at least in certain parts of the stages of the process, were identified and referred to. See, for example, page 320 of the document. And then there are, I think, we've done a search of the document. Obviously, we've not had very much time to do so, but we think that older people is mentioned some 48 times in the Regulation 22 statement. So to say that that particular issue, which is what Ms Pipe was concerned about, was not considered within the Regulation 22 statement, we don't think is right. Then Mr Byrne made a number of points with regard to the adequacy of the time that he had available. I've already dealt with the fact that actually he on behalf of his two organisations, did have time to deal with the various issues, quite simply because of the representations that he's made on behalf of his various, or on behalf of his two organisations, or the two organisations that he represents, rather. And he said that one of the issues that he has is that he didn't have enough time to deal with the employment land issue. And I'd seen that he'd made that representation in one of his hearing statements, that he was prevented from doing that. I mean, of course, he hasn't, I don't think, made representations on the industrial land issue. I, of course, don't gainsay the fact that he considered that he wasn't able to make those sorts of representations. And I do raise a query on that, on his ability to have done so, insofar as they were matters that were capable of being understood in general terms with regard to his specific issues. His issues concern the Better Homes question, as well as the environmental considerations around particular forms of allocation. And I think it's right that insofar as he has looked at the question of how you go about disposing of or development around the borough, you do need to consider industrial intensification. And you do need to look at those sorts of issues. So he did have actually a focused area that he could have looked at. And so I don't accept that he wasn't, in the circumstances, able to have presented any representations at all on that issue. But so if that is something that you think needs to be addressed, and that that representations do need now to be made by Mr Byrne, well, again, that can be accommodated through the process. But the question is in general terms, not only on specific issues, but and specific issues which amount to a small part of a very significant case being presented on the part of Mr Byrne's organisations. Has there been ultimately compliance with the relevant principles of consultation contained in the SCI and contained in the regulations? And they have been. One thing to bear in mind, we have not breached any regulation by virtue of the number of documents that have been submitted. And we haven't breached any commitment within the SCI which specifically deals with the numbers of documents. And you can be clear on that point. So it isn't, yes, there could have been other ways of doing it, but that isn't a reason for reaching a judgment that in some way there has been a breach of either of those aspects that you need to consider. He, I think, said that he wasn't able actually to look at one specific representation, namely the Trent Park Golf Course, because what he had seen is that TfL in its hearing statement had now been proposing greenbelt releases. Now that's something that came up post the consultation processes and post all of those issues that you need to consider for the purposes of assessing the adequacy of what we've done. So I will say this, it is irrelevant to the questions that you are now considering. Not irrelevant to the question of how you should deal with the I say GLA. I'm not going to lay it at their door at this stage because, of course, we don't know what the GLA say about TfL's position. But at TfL, we don't know about how to address TfL's position. We will come to that. But in terms of the relevance with regard to our issues, it doesn't and is not engaged. With regard to the summaries that were, Mr. Byrne says, inadequate, those summaries that we have provided, I've said it already, they do deal with the substance of the issues. It is not a requirement, absolutely not a requirement, that we should deal with each and every matter. And Mr. Byrne didn't actually identify ways in which he said that there was something that was misleading or something that was in breach of the regulations or specifically of the SCI as a result of what he had seen in those summaries. I've dealt with Councillor Georgiou's point. I won't reiterate it. Safe to say that he was focusing very much on his ability to consider the matter as an elected individual in the context of the decision-making processes. But again, with regard to whether what we had done in some way had caused a breach of the SCIs by virtue of giving a period of a week before the main council meeting, that isn't something that is relevant to the question of consultation. And that, I think, covers everything. Save for perhaps
maybe more than one point.
Oh yes, one other point I did
sorry?
have, so about the election period, but I will come back to that. Sorry,
That was my. That was my.
Oh, was that
question,
your
yeah.
point as well? So yeah. So the SCI does deal with the regulations, and it's sorry, not the regulations, the guidance, which is at 1.13, page 5 of the SCI, which is sub 14, I think. And the relevant guidance on this point, section K, deals from the consultation principles, says that consultation exercises should not generally be launched during local and national election periods. So that's the nature of the guidance. But you'll see that the way in which it's dealt with in 113 of the SCI is that it's important that these intended outcomes are reflected in the way in which we consult on planning matters and to ensure that we are aligned with the government's consultation principles guidance, which provides guidance on how consultations should be undertaken. And you'll need to look at 112 in the SCI as well. It says, in line with the principles of the council plan for people at the heart of everything we do, this statement seeks to ensure that planning in Enfield encourages, enables and values community engagement. As such, our role is not just to publicise consultations, but to help residents understand the full spectrum of issues involved in successful planning, so that routes to involvement are as accessible as possible. And the one needs to look at the reference to the consultation principles by reference to that overarching approach. And that wasn't saying that we would not, during a consultation exercise, or we wouldn't hold a consultation exercise during a local or national election period. The ultimate issue is whether or not, again, there was a sufficient ability to make the relevant representations, and there was. Again, I'll reiterate, a 7-week period was provided, which has been referred to by Mr. Byrne. So I think that, I hope that's covered off the main points at least.
Can I just ask about document top 5, I think it's the exceptional circumstances document. There was a point there about it not being published alongside everything else.
Yes, it's true that in the December publication included the IIA, the HRA and the local plan. It didn't include the other evidence-based documents. But just to be clear, that wasn't part of the statutory process. As you're aware, sir, of course, it wasn't part of the Regulation 19 process.
They were all there during the consultation process.
Yes, during the
Yeah,
Regulation
statutory
19, yes. Yeah, the statutory process.
Thank you. Okay, I'll take any other comments that there are then. Yes, Hadley Wood.
Yes, sorry. I was just trying, sorry for interrupting earlier, but I was trying to avoid the gentleman answering a question that I didn't ask. My point was about the topic papers, and that's not just top 5, but it's in fact top 1, 2, 3, and 5. So spatial strategy, site allocation, housing, and the Greenbelt exceptional circumstances, only being published after the 6th of March council meeting. The point is really that sort of the 2021 Reg 18 consultation proposed the allocation of a number of Greenbelt sites already, for which the evidence was only published or prepared in 2024, so 3 years later, particularly those 4 topic papers. That was my point. So how can you have an evidence-based plan, but your evidence is only produced 3 years after you've made certain proposals?
Okay, thank you. Over 50s forum.
Thank you, sir. I just wanted to make really clear that I hope I didn't say that there was no mention of older people in the consultation statement. I was referring to the fact that the accommodation for a third of the population of Enfield increasing, to our mind, is a major issue. And you'd said that all the major issues were covered. And because this issue we've raised time and time again over some years has not been addressed, I thought it was timely to make the point.
I think there might be a difference between, which is often comes up, a difference between what's been addressed to your satisfaction and what the council has considered and obviously come to their own view on it. And as I said before, I think that's probably something we'll be something we'll
understood. I was pleased to see that the legitimisation of word search is very helpful too. Thank you.
Okay. And Mr. Byrne.
Thank you, sir. I just wanted to come back briefly, if I may, in response to Mr. Reid. And with the greatest respect, I didn't really agree with his characterisation of the statement I made. And perhaps that's my fault for not explaining the issues properly. So just to clarify, the issue is not one of solely the volume of evidence. We accept that evidence is needed, of course. The issue is the one of the volume of evidence published simultaneously with such a short period in regard to that extensive evidence base given. And that's the issue. It's the combination of effects. So there was a very long time lag between Reg 18 and Reg 19, or the second Reg 18 and Reg 19. And there was plenty of time to publish that information, as guidance suggests. And it wasn't published. It was all published simultaneously. So it's the point of the simultaneous publishing of very large volumes of evidence, coupled with the time given for consultation, which is the issue. And in terms of the not the issue around the elections, if you go on and read point K, Mr. Reid read out the first part. The second part mentions if exceptional circumstances make a consultation absolutely necessary during an election period, for example, to safeguarding public health. Well, this wasn't the issue here. If this wasn't safeguarding public health, greater time could have been given available. So it's important to recognise the full statement there. He mentioned as well that I didn't give an example of where the issues with the summaries had come up, where the summaries had been sort of misinterpreted and then led to an issue. Well, in fact, we do in our NCAF's hearing statement at point 20. We give an example there, and we can provide others. Then we're still not sure, I'm still not sure from his response whether the council did or did not use AI to summarise the representations. And as I say, we tested them, we think it did, we think that's led to some issues, and we have outlined them in our hearing statements. Thank you.
I suppose out of interest, was AI used?
Yes, sir. As I understand it, it was in terms of the responses, but not in terms of summarising the responses, but not in terms of the responses that were issued by the council, as I understand it.
Okay. Was that that wasn't made clear, was it? In anything? Was that made clear in any documentation?
I need to take instructions.
Yeah. I mean, in fairness, PIN's guidance on AI is relatively recent. You'll notice that I think my latest guidance note will refer to where AI is used, whether it be in any part of the process. It ought to be highlighted. But I accept that that wasn't the guidance when the documents were published. But useful to know. Okay. Sorry, Councillor Georgiou.
Thank you, sir. I think just in response, and I don't want to cast aspersions on any comments that are made or put any words in Mr. Reid's mouth, but in his response saying that effectively the statement that both Councillor Ryan and I have made is not part of this section, I would have to respectfully disagree with, because it's almost an implication that we are not part of the public engagement process, which we are representatives of a significant number of the public, as well as being elected representatives. And also, equally respectfully, I didn't hear a comprehensive response as to whether assessing 7,000 pages in a week makes for good consultation, because ultimately it does alter people's responses, it alters their views, the evidence base alters the representations that they make, and votes that we have to have as elected representatives. I'd also say, and that going back to our Matter 1 statement, is that there was a legal debate within the council as to whether these documents should be released at all. With regard to Mr. Reid's comments, on our comments with regard to breach of the SCI, I'm not going to repeat what I said because you've got a lot to get through today, but I'd refer back to our Matter 1 hearing statement, which addresses exactly where they have failed in meeting the SCI. And I would say that, yes, it's fairly obvious and it's evidence that there was an extended consultation period. But in my opinion, in my group's opinion, that doesn't matter if it's not conducted well. So I'd leave it there. Thank you.
Thank you very much. It's very helpful. Do you have any final comments you'd wish to make before I wrap up on this?
Very briefly, sir. Just there was a suggestion, I think, that all the documentation was new insofar as there was just nothing available for consideration. And I don't know whether or not that was being suggested. To the extent that it was being suggested, there was documentation available. And if necessary, we can provide a list of what that documentation was. But I think the more important point is the amount of Mr. Burns' case is that he just didn't have enough time, given the amount within the scale of the period that we gave. As I say, the question is ultimately whether we have breached any part of the relevant regulations or the SCI, and we just haven't by virtue of that. And the evidence bears it out, given the detail of the representations that Mr. Byrne has made already. And as to Councillor Georgiou's points, I'm not suggesting that he's not in any way relevant for the purposes of considering compliance or otherwise with the consultation principles. Of course, his role is just as important as others. In many ways, more so. But for the reasons that I've said already, we've complied. The last point I think I just need to deal with is Mr. De Vos's argument that none of the top papers were available for consideration at an earlier stage in the process. Well, the issue is actually what happened with regard to the Regulation 19 processes. And with regard to that, we've certainly made them available at that stage. And at the period before, or in the periods before, during the Regulation 18 stages, we gave enough information.
Okay, thank you. Are these new points?
It is. I'll be very brief because we do actually deal with the information that was already available in our hearing statements at point 10 and point out that some of that was available, but it had changed. So that meant we had to recheck all of the information which even looked like it had been previously provided, which created problems for us. So I just wanted to be clear on that point that we have addressed that in our statement.
Thank you. Any more points on engagement? If I could just... Did you want to say something? Yeah, very briefly. Okay, yeah.
Yeah, thank you. I think the implication that anybody here, especially the Conservative group, has implied that no documents have been released ever is factually incorrect. What we have said is that there was an inordinate number of documents and pages released for us to determine over a very short period. And that's borne out by the evidence, so I don't think there's any debate there.
Okay, but from your point of view, I'm sorry, I'm prolonging it myself now. From your point of view, that was the shortness of time between publication of committee papers and the committee meeting. Not, you might also feel this, but not the same as Mr. Burns, which is there's not enough time to deal with the fullness of the consultation period during the statutory consultation period. It's a subtly different argument. It amounts to the same thing, I think, but it's a subtly different argument. So.
If I may just say, full counsel is a key component of this statutory process. So exactly what you've said is the point that we're making, not a committee, but as full counsel to determine those, as you've said, within a suitable period of time.
Beg your pardon. Council, full council. I better get it right. Councillors are very precious about these things, aren't you? So, okay, thank you for that. Now, I'm going to move on. Thank you, everyone, for that. I've got a lot to think about there. I'm not going to come to any decision now on any actions. I think there inevitably will be actions as a result of this. I'm not going to. I'm going to continue with the agenda for now. So it gives obviously, and I need to take some time at some point to think about what I've heard and come to a view. At which I will come back on in due course. But I think because of the importance of some of the other issues we've got to talk about today, I may as well continue with those, and we'll, I think, make a start at least on duty to cooperate. I don't think I'll get through all of that. I'm not sure I might not get through all of my questions because I've got quite a lot of questions on the duty. So I may not get through all of those by lunch, but so again, apologies for anyone who's got a burning desire to talk about the duty to cooperate. You may have to wait until after lunch, if that's okay. So, no further ado. Okay, so, oh, sorry, Councillor sorting himself out.
Yes, thank you, sir. Ms. Raymond is going to be
You okay? Right,
yes,
okay. So, just a bit of preamble. The duty to cooperate is the requirement to engage constructively and on an ongoing basis to maximise the effectiveness of local plan preparation in the context of strategic cross-boundary matters. So a strategic matter that falls within the scope of the duty is something which affects more than one district. For the avoidance of any doubt, the duty to coordinate is not a duty to agree. So the fact there may be disagreement at the end of the process is not necessarily a reason to conclude it's not being discharged. However, obviously, if there are areas where there's been no agreed outcome or no agreement to disagree or no clear engagement of any kind, then that is something I'd have to consider. The Council has produced a duty to cooperate statement, as well as a number of statements of common ground, some of which were subsequent to the submission of the plan, and some more recent ones in response to MIQs, and I think there's some updated versions of statements. You may have to take me through some of these, because again, the amount of time I've had to look at some of this is not being extensive. Similarly for other people, and that's another thing I may have to, throughout some of these, you know, the extent to which people have been able to engage with the new evidence, I may need to give people the opportunity to come back. It's also worth noting at this stage that the duty only, again for people who are not in the know, the duty only covers the period up to the submission of the plan. So on that basis, while things which have been done since the submission of the plan may be helpful to you know, consideration of other factors and soundness, they're not something I'm going to be considering in the scope of the duty, and any activity that's taken place since the plan's been submitted can't rectify any errors or any deficiencies in the duty before this plan was submitted. So, and I think that's just so everyone knows where we start from. So I think I'm probably going to, my questions Q1 to 1.1 to 1.6, I'm probably just taking the round rather than, you know, general issues. And I want to start by asking about the engagement, sorry if you can hear me, ask about the engagement you had in relation to housing and employment matters in particular. The information you provided, and again, if at any point I'm incorrect about this, please let me know, suggests that letters were sent out asking other authorities whether or not they were able to help meet your needs in 2021, and that there were discussions, at the Regulation 18 stage. I'm not quite clear to the extent to which they were separate activities. But is it correct that that's some of it? 2021 Reg 18 was where you discussed this.
Yes, sorry, Inspector. Rebecca Rain, Planning Policy Lead. Yes, that's correct. We had the continuous discussions throughout both those Reg 18 consultations.
So, other than the consultation, though, what form of engagement actually took place?
Okay. So, Appendix 1 of the Duty to Cooperate statement, which is sub 14A, sets out a summary of all of that consultation. So some of that consultation dates back to, I think, 2018, 2019. So you can see we've had regular updates, local plan discussions in the round, and obviously formal letters. We've had formal requests to agree strategic matters. We have had in-house discussions, both through officers and through external consultants as well. And then as we get into the detail, as we move through the last 12 months, we've had quite detailed discussions about very specific matters.
But am I right in... Sorry, before I jump ahead. In terms of there's reference... I'm just talking about meeting needs at the moment rather than some of the other issues. There's reference in Appendix 1 and in the documentation about letters that were sent and responses. Are they before me?
The letters themselves, no, but they can be. We were conscious of the quantity of information we were presenting, so we can present those to you.
And the responses as well?
Yes.
I understand, and I'm just talking general terms at the moment, I understand that those councils responded to that letter. Not all of them did, but the ones that did all concluded they couldn't assist.
Yes, that's correct.
And what reasons were given in broad terms for that?
In broad terms, they were struggling to meet their own need, therefore they wouldn't be in a position to assist Enfield in meeting in their need. Although everyone was quite in agreement that we would continue to collaborate and discuss those strategic issues as they arise.
So, just out of interest, when the councils came back and said to you, we haven't got capacity ourselves to meet our need, did they provide any evidence of this at all? Was there any discussions about what their capacities may be and engagement on that?
No.
No. So you took their word for it?
We have been responding formally to Reg 18, and again, they have to ours. So at that point, and obviously through the Statement of Common Ground as well, we are able to establish what their housing employment needs are and cross-refer them to our own. But no, in terms of physical evidence, we haven't requested that.
And considering, I suppose the first question I should ask really is considering on the basis that there are unmet needs, that's Enfield's position, I take it, that there aren't met needs that could be considered?
For other authorities, yes.
Yeah. When you've been engaging on their consultations, have your representations as part of Reg 18, Reg 19 made it clear that you're looking for assistance in this regard? Or?
We'd have to double check the wording, but yeah, we have been quite clear when we've formally responded to other authorities' consultations what our position is and what our intention is.
So presumably any consultation at those stages that happened prior to your submission, you've indicated you need, can you meet our need? And they've, as part of their response to, as your Regulation 22 statement, would respond to say, no, we can't do that.
Yes, I'd have to check on the actual precise wording, but yes, we have indicated that we are not in a position to meet our own need. As set out in our spatial strategy, which is why the plan is going in the direction that it is. But yes.
Okay. I might need some evidence of this. I will say, in terms of Appendix 1 in the DTC statement, it only refers, as far, unless I've missed some reference, when it talks about this letter that was sent in 2020 or 2021,
yep.
Only talks about meeting housing need. I've seen in some reference in the discursive parts of the document to discussing employment needs, but does this talk about housing and employment, this letter?
Yes, it's both housing needs and employment needs.
So it's just been incorrectly referenced on the Appendix 1 schedule.
Okay. So again, again, I'll come up with an action point, but some of this needs to be before me before I can make a view. I think the DTC statement refers to you had letters sent out, you got responses to say no, but then you also had meetings with two authorities. Is that correct? It was two authorities you met directly?
Can you just clarify, just so I'm clear, which two authorities you're referring to?
No, you can put me on the spot now.
Sorry.
This is where I should make
should have said more questions of the inspector, so I'm sorry.
More, yeah, exactly. I'm only to ask questions, not answer.
Which meetings did we have now?
So we'll check through that as well.
Well, I suppose my main point really is not so much who you had meetings with, it's were any meetings taken, why were no meetings taken with anybody else during that period if it's quite a significant issue?
Sorry, I think it depends on the wider context in terms of what the issues were. So, for example, I know we had a meeting with Hertsmere because we had site-specific issues that we needed to discuss. So we would have met them in the round to discuss duty to cooperate issues with them.
I may come back if we don't get through. I'll probably revise. I'll check my point on that and come back on it. The meetings that you had are again. I don't think any agendas or minutes before me. Would they be available?
Yes, again, we can put that package of evidence together for you.
And so, just to clarify, you had the 2 meetings referred to. I'll find out where that was referred to. And then you didn't have any other meetings with any other authorities about unmet need at the time or before 2021? Specific meetings about that or engagement about that? I'm just trying to get a feel for, has it literally been, we sent a letter out in 2021?
And that's it.
And that's it?
No, is the answer. And we can provide a full picture, but invariably there were individual meetings and then, as I understand, forums and collaborative events where we would have engaged in duty to cooperate through less formal structure, shall we say. We have duty to cooperate at different levels as well, so directors would engage as well as officers.
And does that is that also since 2021? Because obviously, you got an answer of no in that period, but then, so obviously we're 3 years hence. So has any further discussion or engagement taken place on this issue since then?
Since 2021? Yes, but more on a site-specific basis.
So in terms of the general question of whether or not any other authority is able to meet your housing or employment needs, there's been no further engagement?
No formal meetings, but it would have been done in written communication, is that right, May? Yeah, through formal Reg 18, Reg 19 responses.
How, although I may need to see what you have done since 2021, but how does that suggest there's not been much in the way of formal engagement taking place, tally with the requirement for ongoing engagement?
Are you talking about, sorry for the questions, are you talking about after submission and that form of...
No, I'm between 2021 and...
Right, okay.
If there's been very little or no formal engagement on housing and employment needs since 2021,
Yeah.
the question is, how does that stack up against the DTC's requirement for ongoing consultation, ongoing engagement?
So since 2021, there have been ongoing engagement with our local authorities, so DTC through DTC matters. Every local planning authority is at different stages of their plan making process. So, for example, Barnet at the time they were under Reg 19 and under examination. Similarly, with Waltham Forest, they were also, at a similar stage, but just consulting on their strategic plan. So, throughout the process, there have been ongoing discussions and engagements with our joining authorities as well.
And has that engagement, addressed the issue of unmet need? Have you ever gone back and effectively, if the situation has changed, because obviously things can change over 3 years, you've re-asked the question?
We've re-asked the question. They formally come back to us through our consultation through Reg 18 and Reg 19 to confirm that they can't meet our unmet needs in relation to housing and also employment needs. So we could provide evidence. We could provide the evidence.
And similarly, we've done the same through their formal consultations.
Okay. And again, is there evidence of that through things other than consultation?
There is. There is. But mainly through the written representations, but also through, we do have minutes and agendas and meetings of other director updates or specific meetings that we've had through our consultants, etc., on our behalf. We've had sit-down arrangements where we've had it requested to agree the strategic matters And I believe there have been working groups. There have been, so the Epping Forest and Oversight Group Meeting Corporation Board, for example. Again, depending on the county council, sorry, the Hertfordshire County Council, we've had transport assessment, spatial planning group. And then,
So, yeah, and I think we'll come on to
Sorry.
the transport stuff.
I
It's
know.
really, I'm really focusing at the moment on the unmet need.
Housing.
I'm not, I want to get to a clarity on
That's fine.
what's happened with that, really. So, okay. But there's, I mean, is it right to say that as of now, I don't have the evidence in front of me to set out exactly what's happened on those issues? I have indication, but I don't have the letters, I don't have the responses, I don't have minutes and agendas and so on.
Yeah, you don't have all the evidence. Yeah, it was summarised in the Appendix 1, but I agree, we haven't put the evidence in front of you, but that we have been collating that in the background, so we should be in a position to be able to present that to you fairly quickly.
Okay.
Can I also just say that you do, of course, have the Statement of Common Ground from the various authorities of July 24. And that, of course, is evidence of the degree to which ultimately those boroughs considered that the DTC have been complied with. They're all alive to the question of housing and industrial land needs. So that is reflective of the lack of an objection by any of those bodies in relation to that. There's also the other overarching point, which of course is the GLA's position with regard to housing provision within a London borough, and the extent to which discussions with the GLA are capable of incorporating the overarching considerations around housing need that might exist for other boroughs. Because they set the strategic, at least ostensibly for the first 10 years, as you know, subject to the 4 and 11 debate. They set the...
I'm looking forward to that tomorrow.
Yes, exactly. I thought you might be. So.
If we get there.
Yes. Yes.
Okay. I think I'm a little unclear, I have to say, about, and this is one of the reasons for having this today. It's good to back and forth on this, but it's simpler just to talk about it. So I'm a little unclear what's, I suppose, because I've just got a very basic summary of what's happened, or what form the engagement that's led to the Statement of Common Ground. The Statement of Common Ground is a culmination of the work that might be done, but it doesn't tell me what work has been done. It doesn't tell me when it's been done. It doesn't tell me when these issues were discussed, or what the outcomes of those issues were, and so on. So I think there's something that I need, and I'd need that before obviously I could come to any view as to whether things are satisfactory.
Yes, so what we'll do is compile a schedule that includes all the documentation that bears on those two issues. And if other matters come up through the further questions that you have, then we can, of course, add to that schedule.
The DTC statement, paragraph 6.5, does refer to Uttlesford and Newham, potentially, based on the back of a study, being able to meet some employment and needs. And I think it talks about discussions were not fruitful or not. So again, it's useful to know some discussions took place, but I think it's needing to know what those discussions were. I think if you were to look at the PINS procedural guide, it sets out what sort of information is required in these regards. Going back to the initial point that was made about, you sent letters to 12 authorities, I think, and 10 replied, and it may be that the 2 didn't, to the ones you had meetings with. Was there anybody who hasn't responded at all to that query during the process?
I can respond to that. Everyone responded. We also followed up those that didn't respond in the first place.
Okay.
So did everyone respond to me?
And looking at, although the, notwithstanding what I said about due to cooperate, it's not due to degree, are there, in terms of the scale and distribution of growth proposed, are any local authorities, relevant local authorities, in objection? Are there any outstanding objections to that?
To the duty themselves or to...
To the issue.
To the
I mean,
issue.
yeah, I mean,
yes, we do have a couple of authorities where we have outstanding areas of agreement, but nobody has any outstanding concerns in terms of the duty itself.
okay. Mr. Reed's just mentioned it, and it may be something GLA will want to comment on later. But insofar as it pertains to the duty, which this may or may not, depends on what you think. Policy H1, we're talking about the housing requirement here, obviously. Policy H1 refers to agreeing things in consultation with GLA. We can pick, this will be picked up potentially when we talk about conformity this afternoon, and probably almost definitely tomorrow. So, in general terms, do you consider that to be a DTC issue or not?
No. As you highlighted before, we know that there are areas of disagreement as to whether we've met the duty to cooperate. I believe we have, and I think we've evidenced, or certainly we will be evidencing that, specifically in terms of the GLA's communications. We have a substantial audit trail with the GLA and communications that we've had with them, including 2 statements of common ground now signed. So no, in terms of the duty, absolutely, we've met that with the GLA, and we're confident of that.
And is that engagement set out somewhere?
That will form part of the package of evidence that we can present to you. But again, we do have all of that very readily available if you need it fairly quickly.
The list of that, Sarah, is set out in the reasoning schedule at the back of the DTC document. I did have it. It was...
It's Appendix 1 of Sub 14A.
Yeah, but it's... the particular page deals with the discussions. 34, is it? Thank you. Yeah, 34.
Okay, fine. Yeah, thanks. Yeah. Yeah, obviously these tell me that meetings took place, don't necessarily tell me.
Exactly so.
Tell me what. I understand. It is an. I mean, I understand why councils don't get. It's a huge amount of information, but it's difficult to.
We were looking to deal with it on a proportionate basis, which would ensure that we focused in on those matters that were still at issue. And with regard to the DTC issues, of course, with the statements of common ground, we were clear in terms of what we had arrived at with those bodies, that we had discussed all that needed to be discussed in terms of the availability of accommodating those needs outside of our own area.
Yeah, I mean, of course, yeah. Whether or not you've passed the duties for me, and lack of objection is material, but not.
And absolutely, and that says something we entirely agree with. In hindsight, it would have been worthwhile.
Yes, and yes. Maybe I could have picked it up. I'm just going to go 5 minutes before I want to break for lunch. I want to talk about. It says moving on slightly from meeting unmet needs, but it still relates to meeting unmet needs. Is the gypsy and traveller issue? In your view, is meeting the needs of gypsy and travellers a strategic matter in the context of the duty.
I'm not sure if this question's trying to trip me up, but yes, it is a strategic matter.
No questions of trying to trip you up. It's purely.
She's used to planning inquiries.
Yeah. I'm not a barrister. It's not my job to trip you up. It's a simple yes or no. You may have considered it isn't, in which case I would have investigated that, but it is. Now, in the duty to cooperate statement, it suggests, if I can find it, that there are no issues to address. As in, I'm not saying it was not a duty to cooperate matter, but there are no outstanding issues to address at that time. Mm-hmm. I'm conscious that since the plan has been submitted, you have suggested to me that the pitch requirement has changed.
Yes.
This plan would ostensibly set the pitch requirement.
Yep.
So that changed. Mm-hmm. My understanding, again, and we'll come on to this, is that the GTAA, the new GTAA was at least available or published prior to submission. So it falls into the scope of the duty. And so what I want to understand is when the situation changed from the 20 pitches to the 31 pitches, did you then go out and engage with neighbouring authorities to reassess the situation?
Yes, we did. We did that under a separate local plan, so that was undertaken through the Traveller local plan, the duty to cooperate engagement through the Traveller local plan. So the authorities would have been contacted separately. But again, we have the evidence for that, and we could submit that as part of this duty to cooperate. It's a slightly grey area, but we can provide those letters and those responses to you as part of this local plan examination. But yes, we did go out and ask the question, can you help us meet our need?
Can I just flag up that there's also the point made in the DTC statement as to the needs assessment that has been undertaken or is in the process of being undertaken by the GLA, and this is at 628, page 13 of the document.
I think that's where I first highlighted and asked the question, what it was. Okay, thank you. When was the consultation on the Traveller local plan?
Right, just remembering right now. So the initial Regulation 18 consultation took place in 2023, so September to, I think, November 2023. And then there was a second round of Regulation 18 consultation, which took place September to November, September to early November 2024. So there's been 2 rounds of Regulation 18 consultation for that.
And this plan was submitted in August?
This plan was submitted in August.
So would consultation on the 2024 regulation, the 2024 Regulation 18 consultation actually would not contribute to, or couldn't contribute to this plan's duty to cooperate?
Well, so the evidence that post dates may be indicative of there having been satisfaction of the duty earlier. So if it's identified that there never was, through that evidence base, the availability to go to other areas to satisfy the needs, then that would be indicative of the fact that the earlier discussions had done enough. So it's capable of being, in short, it's capable of being relevant.
Is that the test? Done enough, or is it the test is ongoing?
Done enough to satisfy the test.
The test is ongoing?
It is ongoing.
So is it not the case, being devil's advocate, if something significant changes, so if you've gone out and said, well, there were 20, I don't know if at the time the 20 meant you would have had to go into the green belt or not, or whatever, but safe sake, 20 is what we have, and everyone comes back and says no, even if the answer's the same, when it's now 31, and you go back out, and everyone comes back, it's still no. Isn't that not still what the duty would expect you to do?
Well,
or is it up for as soon as you've got an answer, that's it?
Well, if insofar as it certainly doesn't mean that one would stop complying with the duty, which is an ongoing one. But my point is that if there was a question mark as to whether or not before or at the relevant date there had up until that point been adequate discussions, if the answer that comes back after, is evidentially if the answer after the relevant date is supportive of the position previously, then it is suggestive that the original series of steps was adequate. That's the simple point I make. It's just an evidential one.
But the original steps, sorry to knock it over with bones, the original steps took you up to the pre-existing GTAA, the 20 pitch. So if there was no engagement even prior to the Reg 18 consultation, then how does that fit in with the ongoing? So presumably the new document was available X. There was a certain amount of time before this plan was submitted, where it existed. Sounds like there wasn't necessarily any direct engagement about that document with other parties prior to September.
Well, I think before September, there was an original round of there was a Regulation 18 round of consultation in 2023, if I've understood that.
Yes, but that was on different evidence.
Different evidence entirely. Yeah. All I make as a point, sir, is that if you've got a situation where it was clear that there was a need and it couldn't be satisfied outside of the area, and if the same situation pertained after the relevant date, it's just supportive of the adequacy of the steps that have previously been taken. Whereas if it had been shown subsequently that there suddenly was a need that could be satisfied elsewhere, and all of that relevant information suggested that there should have been further discussions around that particular area, then you would conclude potentially that there hadn't been compliance with the DTC. Okay. So that's how it's perhaps an academic point. I think we're focusing really on the steps during the main period.
Okay. So I will need, though, to see at least what engagement took place about the old
yes.
situation to assess whether or not there was any fundamental change.
Yes, and if you're satisfied with that, then there doesn't need to be anything further done to address it. It's only if, as I say, that there is something in that later round of responses in the second Reg 18 consultation that somehow bears on that question that you may need to consider it. But so can we look at that information in the second round before providing it to you, just so that we can see if it does have anything relevant?
Okay.
That bears on.
We'll be, again, assuming we get there, we'll be touching on this again anyway, yes. Under matter, issue 2.3, I think 2.2.
That's right.
Sorry.
Thank you, Inspector. It's just a minor point on the gypsy and traveller accommodation assessment. So I wouldn't class that as new evidence because the methodology and the interviews, etc., all remained the same. So no new interviews, etc., were undertaken. It was to incorporate the new definition through the MPPF. So effectively the pitch need increased by 7 pitches.
Okay. Okay, thank you. Right, it's a good place to stop. Apologies for all of you who have been sitting there listening to that if you weren't interested. It's very important stuff. So I'm going to now take a break until 2 to give everyone plenty of time to have some lunch, and we'll come back. And I'm afraid I've still got some more questions, but I'll get through them as fast as possible. Yeah, thank you very much. Back at 2. Okay, good afternoon, everyone. It's 2 o'clock. It's time for me to resume. I was going through my questions on duty to cooperate. I've got a few more, if Council will indulge me. I just want to move on. I finished with the gypsy and traveller needs, the housing and employment needs. I'm just going to move on to transport matters.
Yes.
In the main. I've had various statements of common ground with highway authorities. And I think the Appendix 1, in fairness, looks like there's more detail in terms of numbers of meetings, activities that's taken place, albeit I don't have the agendas and the minutes for those, but I do have more information on the activity that's taken place for transport matters.
Yes.
So
I think it's an internal system.
Okay.
So apologies for that. If you can believe it, that's a computer.
do we have to evacuate?
No, I think the computer does.
Right.
So there was one matter I want to raise, if I may,
Okay.
about something that I said earlier on this morning. I just want to flag that up because it's important, certainly, in relation to the issues with regard to engagement. Do you remember the answer that I gave in respect of the AI response issue, that they were all, that's to say, the responses generated by AI? I'm going to, if I may, withdraw that statement because we've undertaken further investigations. We think that that's not the right answer. But I don't want to be precipitous in terms of making a statement about it at this stage. We're still just undertaking final checks on that. But can we come back to you tomorrow morning just with a final answer on that?
Okay. I'll make a note of that.
Thank you.
Right. Sorry. Yes. So, sorry about that. I should have asked if there was any housekeeping matter before I started. But yes, on to transport issues. So, I've had, say, various statements of common ground and new statements of common ground subsequent to submission in the MIQs, although I'm not suggesting that some of that is in relation to activity that took place beforehand. There's reference in the document, in your statements, to a revised or updated statement of common ground with TfL. Is that, I think I'm right saying that's not before me yet, is it?
No, that's in progress. So you have a signed statement of common ground, and then we've appended the detailed considerations for the modifications as part of the MIQs. So that is before you, but the statement itself isn't.
Okay. And when can I expect that?
As soon as possible, but we will liaise with TfL on that.
I think it may have been signed by now.
The statement of common ground, the updated statement. The updated statement of common ground hasn't been signed yet, but the detail has been signed off, if you like. But I think it's a procedural process matter in terms of getting the statement signed.
Okay. Obviously, there'll be issues in there, no doubt, which relate to other matters and topics. But some of my questions might be answered by that once it's available. Just for the benefits of people around the table, you might get a bit confused. Generally speaking, statements of common ground are useful to me, and so I will tend to accept them when they're produced because they are helpful. Statements of common ground can be produced by anybody. The council can enter into those with anybody, which is different to a evidence-based document. If we've produced a new study or produced a new piece of research, that's a different thing. That I need to understand why that's been produced, and it'll be up to me whether I accept it. But as a general rule of thumb, statements of common ground can be helpful because they obviously narrow the focus of discussion and debate, and we don't necessarily need to go over things that are agreed, unless I obviously have questions about them. It's obviously better to have them when we're talking about the issues rather than subsequent to that. But I suppose once I get it, I'll have opportunities to ask questions at some point about this content. From a duty perspective, you will have seen, and obviously TfL will be here to answer for themselves. And if I'm putting words in your mouth at any point, you'll be able to correct me. But in answer to question 1.1, there obviously concerns have been raised from TfL about the outcome of engagement, if not engagement itself. In fairness, the document does talk about how much engagement has taken place, but there are seemingly outstanding matters of some significance. So I just wondered what your perspective was on that in terms of the duty.
So can I deal with this as a starting point by reference to the approach that was taken by TfL at the point of submission of the Regulation 19 representations? Because at that stage, one gains an understanding as to whether or not there was truly a DTC issue. And you'll have seen that in those representations, there wasn't a suggestion that the DTC had failed. There was a disagreement, and principally around the degree to which Chase Park and Cruise Hill were appropriate locations for sustainable settlements. But that was a disagreement, which goes, of course, to the question of soundness, not to the satisfaction of the duty. Ultimately, of course, one will get to a position where there is an agreement to disagree, and that is actually where their position has arrived at. And I mean, just to be clear, that TfL said in their representation, we look forward to continuing to work together in drafting the final document, that's to say, Statement of Common Ground, and committed to continuing to work closely with the GLA to deliver integrated planning and make the case for continued investment in transport capacity and connectivity to enable good growth in Enfield and across London. So that was the approach that they had then taken. What one sees actually is, in terms of the approach taken by TfL with regard to the failure of the DTC, is the position that they adopted in relation to the discussions in the August 2024 Statement of Common Ground. But that is an issue that ultimately was or is of relevance to the position post-Regulation 19. And really this comes down, you'll have seen something that some of the other parties to the examination have noticed, that TfL are now taking an entirely different tack with regard to the approach towards delivery of housing within the Enfield borough area. They are suggesting that there should be greenbelt releases. It's just a different location from the greenbelt release that is being proposed by this council. And that was something that actually wasn't the focus of DTC discussions previously, but it is very much what has driven the arguments around the failure of the DTC now. And so that's important for the purposes of actually just engaging with the question. The point of submission of this plan, had we failed in our discussions with TfL. And it's unsurprising that TfL didn't take that particular point, because one can see the very detailed analysis that have been undertaken, or the very detailed discussions, a number of those discussions in place at an earlier stage for a good many years. And that incorporated principally the incorporation of various modelling work that informed the decision-making of this council. So that's the overarching position, that actually we need to focus in on what the real issue is, and it's one of soundness, actually, and not a question of discussion.
Okay. Just to pick up on a point you had said there, it's about there's been a change in positions post-Regulation 19. Yes. Was that change in position pre-submission?
Well, I've got my what I've been told by the people working the machinery that I'm not speaking clearly enough into the microphone. What we have is, from what I have seen, a position taken in the Statement of Common Ground in August 2024, a series of points, but actually not a point being made around the DTC. So at the point of submission of the plan, that wasn't an issue being taken. There was discussion, there was disagreement, but not a point around the DTC. So in short, it is related, as I say, to matters that have occurred after submission. Ms Rain.
I was just going to come in and say, obviously, you've made the point in terms of duty to cooperate. It would be continued engagement, considered continued engagement after that. From our point of view, we would say that the council has demonstrated a proactive and an ongoing engagement with TfL, and we have regular meetings and collaboration on lots of issues, transport assessments. And we can evidence that through our continued engagement schedule, if it's helpful to present that to you. We've got a number of evidence-based documents, including the Cruise Hill topic paper, which details the site-specific spatial framework, density strategies, transport infrastructure. All of those topic papers have been inputted by TfL. We also highlight master planning approaches and land use optimisation, which TfL have also fed into. So in terms of the duty to cooperate, I do believe that we have met that. It's more to do with outstanding areas of disagreement. Thank you.
I'm sorry, so just to give you the reference, but you'll see the first of the TfL, or in fact the only signed TfL Statement of Common Ground with the Council at page 110. And I can either give you references or perhaps you want to see them. But as 1.3 is the relevant reference where you'll see the DTC is specifically referred to. And then 3.1, page 112, you can see the points of agreement, which make quite clear that actually it's a continuing discussion and dialogue that's going on.
Okay, thank you. This is sort of technically outside the scope of, I've been talking about the scope of the DTC, it was upward submission. I've seen various references, I think you just alluded to them yourself, about continuing engagement and discussion with TfL and others since submission. I think just for my benefit in terms of the examination as a whole, and while we're here, I may as well ask the question is, what is that entailing? Because when I read comments in paragraph 1.519 of your statement that it's going to lead to, could lead to lots of modifications to things, it starts to get me in a bit of a cold sweat about what I'm likely to be, it's going to be put to me in terms of changes. So if perhaps just, I mean, it's a slight digression from and divergence from the DC, albeit one question that might flow from that is, why are we having these discussions now if, shouldn't they have been before submission? Yes. So that is a DTC issue.
Okay. So the ongoing engagement, do you want to come in, Ria? No. So the ongoing engagement is around quite detail-specific issues rather than kind of the broad approach to what Enfield are doing. What we can do is provide an audit trail of the email communications and the meetings that have taken place and provide a summary of what the key issue is and how it's been resolved, if that's helpful to you, Inspector.
So I think this perhaps comes up in the context of the IDP. And maybe that's where we also discuss it, but there's been a point taken by TfL that the IDP at the moment, they have queries as to whether, in truth, it is something that is deliverable ultimately through Cruise Hill and Chase Park, and or whether it is capable of further or additional matters can be added such that it improves the sustainability of those two allocations. And of course, the IDP itself is an ongoing document that will inform the development of particular sites. And I think what we certainly had in mind by the authority is that there would be further developments of the IDP in the usual way, and particularly for long-term developments, there'll be further changes with regard to that. But it's not going to, at least principally, alter the strategy with regard to the plan that we are dealing with now, just in order to give you some comfort about how that will go forward.
Thank you. My other point about the effectiveness of the engagement that took place prior to submission, if now, and I'm mindful of the fact that it's always, it's not unusual for discussions to continue, but obviously if there are very significant issues that are now, if you like, the council are agreeing with, that they need to address, perhaps, post-submission, then was the engagement prior to, within the scope of the DCC actually effective?
The point I alluded to earlier on, namely that there is a debate between us and TfL as to whether or not Cruise Hill and Chase Park are capable of being sustainable, are ones that remain at issue. And we don't envisage, at least as I understand it, we don't envisage that there's going to be any significant change of position with regard to the appropriateness of what we're proposing for those sites under the IDP. And so that the debate was there previously, it hasn't been resolved.
Okay, I'm going to move on. No, I'm not. Well, I'm going to move on from TfL. TfL will come into it at some point. But seeing statements of common ground with the other highway authorities and national highways, and they've raised no concerns. But again, similar sort of point really, is work, say with national highways and M25, is work still ongoing with them as well? I mean, they've said they've no concerns about the duty, there's been engagement, but I'm not clear in my own mind whether that means everything's been resolved or whether work is ongoing to resolve outstanding concerns. But they may be confident they're going to do it, but you know, what is happening basically.
Riet Rohan, WSP Transport, on behalf of Enfield Council. We have now a signed statement of common ground with National Highways, with a solution being identified should the needs arise to mitigate any impacts on the M25. Therefore, there is no additional work being done.
Thank you. That's what I wanted to know. Thank you. The reason why the statement of common ground or statement of common ground with the highway authorities collectively wasn't submitted prior to submission, any particular reason for that?
It was a practical issue of running out of time to get it signed, but certainly a draft was circulated a couple of weeks before submission. But yes, it just timing.
Okay. And then just finally from me, I think just effects on biodiversity beyond the borough boundary. You've been working with Natural England on those issues, and all those have been resolved. Is that my understanding? At least to their satisfaction.
Yes, absolutely. And we have submitted a signed statement of common ground, an updated, signed statement of common ground to you last week as part of the MIQs. But yes, they have confirmed there's no outstanding soundness issues from their part.
I'll just check. This may be an issue for Friday. This talk of a shadow appropriate assessment, and all that. When was the work commissioned or whatever to carry that out? Was that pre or post submission? I don't need the particular details of, because we can cover that later. I'm just trying to get an idea of the timeline.
Work was undertaken pre-submission.
Was there a reason it wasn't available at submission?
We were liaising with Natural England in terms of the scope of the piece of work and agreeing the methodology with them.
So it was commissioned prior, completed after? Oh.
Well, working collaboratively with Natural England on this matter.
I may have a question about why, but this might relate to a few issues, why the plan was submitted when there were still so many outstanding issues. That's probably a rhetorical question as much as anything. But it is one that's likely to come up time and time again, because it does seem to be quite a few issues that were not resolved by the time the plan was submitted. Is that a fair point? And again, I think, if anything, where it falls into the scope of the duty comes back to the constant question of, was was all this engagement, this is collectively, engagement effective, and really in the spirit of the duty, if the plan was submitted, then this sort of, oh, actually we now need to do A, B, C, D, E, F, G to get to a point where the plan is sound.
I won't come into the detail of it, but I think we made an assessment overall that the plan was ready, subject to further work of a proportionate scale and timescale could be done. That was the internal assessment.
I think in terms of the position with regard to HRA work and Natural England, it was work that built on the existing work that had been undertaken and what was expected to be the position as a result of those further discussions. And I think that's what Ms. Rain means when she says proportionate, that actually the direction was that it was going to be resolved necessarily, it just hadn't been formally resolved at that point.
Thanks. I mean, it's an opportunity to say it now, is that, of course, we'll say it. There's lots of references in lots of documents to we're doing this, we're doing that, we're doing the other, and we've still got to do this, we've still got to do that. I am a little concerned that there's a lot of seemingly we're still drafting the plan through the examination process, and talk of the significant amounts of work that might come out of this TL, even if it's detailed, not strategic, it could have implications for how we move on. And obviously, at this stage, as I've just said, if you're producing large pieces of evidence, they're only accepted with my discretion. And so I'd need to understand why it wasn't done before the plan was submitted and why only now. So it's just a little general point, I think. We're not going to get to the bottom of that today, but it is an ongoing, the number of times I've read,
yes,
we've still got to sort this out, we've still got to sort that out, we're doing that, and we're going to make changes to this, and we're still engaging with that. It happens in plans, obviously the world doesn't stop, but often that's with a mind to detail and get it in implementation, not necessarily actually we're still sorting out issues that should have been sorted out before it
Yes, I entirely accept that. So I would say that when one looks at the position in overall terms, those issues that are said to be still needing to be resolved are not ones that go to the overall principle of the plan, and they can be categorised as dealing with matters of detail. That's to say, with those that are anything that is left to be resolved. I say that somewhat guardedly. I will make sure that we'll check to see that there's anything else there.
Thank you. I don't want a particular discussion on that point. That was a point I've made.
It was understood, and yes,
it's just a shot across the bows for future things. So bearing in mind, I'm also conscious of time, I will open up the floor to any points that anyone wishes to make about the duty to cooperate. Mr. Byrne.
Thank you, sir. Just very quickly on the last point, a point which we wanted to raise anyway, touches on this, and this is about the costing of key infrastructure, which first came up from us in our representations in 2021 and lots of other people, specifically in regard to the Cruise Hill and Chase Park sites and their viability. The whole plan seems to have been built around the sort of incomplete cost evidence regarding the infrastructure those sites need. We recognise the viability assessment, we've read them in detail, we're quite comfortable with them, and yet these questions remain. And this is a perfect example, we think, of there not being effective collaboration. The costs could have been done in the 3 years between 2021 and 2024. We could have had those in front of us as part of the consultation, and we could have those in front of us now. And we notice one of the things that TfL bring up as well. So we are really frustrated on that point, and it does appear to be a kind of strategy of deferral to us, in our opinion. The other issue we would briefly make is in regard to the Statements of Common Ground and their publication. The guidance says authorities should have their Statements of Common Ground available on their website by the time they publish their draft plan, in order to provide communities with a transparent picture of how they have collaborated, even if all the issues are not yet aligned. So that's really important when you've got a plan of this scale and this complexity with this amount of evidence. I think So you mentioned how helpful they are in providing focus. Well, that same helpfulness exists for communities in helping to understand the plan and navigate it. And none of them were published by the time of the consultation. So we didn't have any of that sort of information to sort of follow those threads, if you like, of agreement and disagreement to help us with our understanding of the plan. Thank you, that's it.
Thank you. Councillor Georgiou.
Yeah. Oh, sounds like I'm in a Ryanair flight. I think your exploration around the comments of the council with regard to their duty to cooperate with TfL, I just wanted to see what that went and to express a view that, you know, TfL, and I appreciate that we will come onto this, but they didn't submit what they submitted during the Reg 19 process. And of course, very radical proposals as part of this process late in the day. And so therefore, I think from the Conservative group's perspective, what we would love to see throughout this process is that evidence between the council engaging with TfL, because if the council has engaged proactively with TfL, how do we get to this point in TfL submitting these sorts of things? So from our perspective, we would love to see that process.
Okay. I will just make the point, obviously, on TfL's alternative proposal. If you take your mind back to one of the first things I said in my opening, I'm only examining what's in the plan. Obviously, they can, again, not want to put words in my mouth, anybody can say this plan isn't sound because this alternative is better, and that might be a reason why the plan is sound, but I'm not examining those alternatives unless it becomes, there's a soundness issue and that becomes part of the modification, you know, and then it becomes an issue for me. But I'm not, with the best will in the world, I'm not examining an alternative greenbelt release until at this moment in time. Before I come on to TfL, because they're quite important, I will just ask Hadley Wood.
Right, thank you. I was looking at question 1.3, and that refers to PPG, and we have noted that sort of the plan, and in particular sort of the housing targets and the policies and proposals of the neighbourhood plan have not been discussed or taken into account, which we consider to be contrary to two specific PPGs.
I think, someone correct me if I'm wrong, neighbourhood plans, neighbourhood forums, or fora, are not bound or within the scope of the duty to cooperate. So issues about you've raised about engaging with the forum and all that, if you like, with the SCI side of things, that's, and the regulations, that's fine. The duty is very narrow, relatively narrow. It's local authorities at the highest level, at the high level, and then what we call prescribed bodies, and neighbourhood forums aren't within the prescribed bodies, and the neighbourhood plan, which probably isn't something which has implications which crosses boundaries, wouldn't fall within this duty anyway. So I noted your comments, but in the scope of my consideration, that falls outside the scope. Thank you. But your other general points are. And I'll come on to Enfield Society then. Thank you.
Thank you very much. With permission, sir, I'd like to raise some comments regarding heritage and green infrastructure. Will you take comments about that at this time? The Enfield Society wants to draw the examination's attention to the Hertsmere Council's statement and their situation with the duty to cooperate over site RUR04, which is the junction 24 of the M25. We are concerned that there is still ongoing objection to this site from Hertsmere Council, which is not new. It's been referred to several times during the plan-making process. We're concerned about this because we feel that it highlights that the borough is using the release of this site to further its financial interests that it has in greenbelt land. And we wish to draw...
Sorry, I'm going to stop. I don't want to get into it, the merits of the site. We'll obviously come on to. If you focus on the duty element.
I wish also to draw attention to the Historic England situation, which relates to tall buildings In earlier statements, they were also concerned about the effect on the heritage of Enfield Chase. But in particular, on the tall buildings, it looks from the statements of common ground that they have reached agreement with the council over the way this is to be handled. However, we wish to particularly draw attention to the fact that the local plan as currently presented has two different building heights in Enfield Town, and we're not sure which of those the agreement with Historic England actually relates to, because it's not mentioned. The Enfield Society has commissioned additional evidence, which, with your permission, we would like to present at a later stage, showing the impact on heritage in Enfield Town through that particular policy.
Okay, thanks. Again, I think there's and the council will come back to the point for me is that if there's outstanding objection, it's one thing, and that'll be something we look at in terms of the merits of plan. The duty doesn't necessarily lead you always to a position where everyone is in agreement, but you, I say, you could get to a position where you agree to disagree, and you've reached the end of any logical debate that could be had. So it may well be there are outstanding concerns. They're not going to get ignored in this process, but it doesn't necessarily mean, because there's an outstanding concern, the duty's been breached. But I guess the council will tell me what discussions and engagement they've had with Hertsmere, and they can, and Historic England, they can tell me what's on.
No, I don't have any specific further examples to give. No.
Okay. So yeah, I will now pass on to actually last one. So I think I'm generally content. We'll come back onto those specific points, but and the other one will be the timing of the statements. But I think I'll just ask TfL to comment first.
Thank you, sir. I wanted to provide a few clarifications and just wanted to sort of reiterate that we have raised concerns about the sustainable development in rural placemaking areas of Chase Park and Cruise Hill in terms of we believe they are not well-connected locations, and it risks low density and car dependent development. So that has been our position since Reg 18, Reg 19. And there has been, Council has been forthcoming in saying that we want to engage in those regards in terms of making them sustainable in terms of policy situations, as well as we have raised that to make these sustainable, there will be substantial infrastructure and services that would be required, both at Reg 18 and Reg 19. And at Reg 19, we specifically outlined all of this robust strategy, the infrastructure required, indicative costs should be outlined in an infrastructure delivery plan. We have had, maybe there were 2 conversations with our bus colleagues, because bus services would be really critical for these areas. We had provided in confidence what our bus colleagues thought of the viability and feasibility of these services. We were expecting that we would be included in those discussions, but the infrastructure delivery plan was published on 30th September 2024 without any discussions with TfL, who's the transport operator and would be responsible for the operating costs for all of these, and these were published without any indicative costs. We have impressed upon the criticality of public transport and active travel to be part of the proposals, but those were either considered not critical, important, or desirable. So we have raised all of those points in our further discussions in an appendix that we were hoping to attach with our statement of common ground, but that has not been published on the website. E7.8 kind of publishes the appendices that would be attached to the statement of common ground back and forth between us and Enfield. After the Reg 19 consultation ended, there have been discussions that we would want to collaborate on all of these points to address TfL's concerns, but most of the discussions that happened were quite detailed on the transport modelling aspects, which we don't believe really address any of our concerns that were raised. Also, to clarify, I think somebody made a point on that we were consulted on when the transport topic papers and the crucial topic papers were published. We were not consulted. I would agree that there were quite an extensive engagement on the modeling aspects, but those are some, and it was established in the topic papers that it was, I don't remember the exact word, it was assured by TfL, so that we disagree with that. So we have identified those and submitted to the council. So all in all, I would say that we haven't really engaged on our policy concerns with which council has been forthcoming in saying that they will engage on those since the Enfield planning examination happened. So we wanted to actually make support our point of choosing sustainable locations. We have presented this illustrative example in our written statements of what is the potential if you choose sustainable locations. This was an exercise done in a few weeks' time. While we alerted the council to it, they haven't engaged with it yet because we understand that there wasn't enough time. But this is simply illustrative to say that if you are able to choose sustainable locations, you can optimize densities and you don't have to spend a whole lot of investment in infrastructure that would support sustainable development. So that's the point we are making through the examples that we have presented in our written statements. It is in no way a proposal for development, or in no way it needs a whole lot of work with Enfield Council to become even a practical approach. So that's, I will invite my colleague if she wants to add anything to that.
Thank you very much. So just to sum up, so the examples, fair enough, we're not going to get too bogged down in those, but they are effectively, in your mind, they're demonstrating why the allocations that are in the plan are not sound,
yes,
or consistent with the London plan. We'll come on to those matters. I just want to get to because obviously there is, as I've already made the point, there is a difference between disagreeing or agreeing to disagree and there not being effective and ongoing consultation and engagement. I get the impression, obviously, from your statement, when you talk about well-documented engagement, highways matter, it sounds like there's been a lot of discussion. It might not have always resulted in the outcome you wanted, but I'm trying to get an understanding of, has the,
There's been a lot of discussion on the modelling aspects, which doesn't really address, which was not related to the concerns that we have raised, while the council has promised that they would engage on those aspects, but most of the discussion until sort of examination, except in the statement of common ground, has been on the modelling aspects. So we are hoping to engage further, but I think that doesn't give us enough time to fully engage in addressing our concerns.
and I think, sorry, this is probably a question for the council, actually. In this context, obviously, you could talk forever. You could engage with every party's concerns and get some. Is there a reason why? Well, obviously, first of all, you may not accept the point, but if there is a reason, as far as you're concerned, is a case you've got to as far as you could reasonably get to in assessing those issues.
So that's the simple point, that there is a point of principle as to whether it's appropriate for, as a location, or as locations, to deliver sustainable settlements. That's the issue. There are then questions as to how one goes about improving the position with regard to those settlements. This new example has been given as one of them, and that's something that happened after the submission of the plan, so not relevant to the question of the DTC. The other matters, for example, improving the position with regard to the approach towards parking layouts, just as an example, is something that certainly would be capable of improving sustainable development if it's appropriate to have it. Those sorts of matters really come down to questions of agreements to disagree. The other point that's being made is around the costings with regard to the infrastructure provision. I just want to come back to that because the IDP that is being complained about is the IDP that was lodged on the 30th of September, i.e. after submission of the plan. So the complaint around the lack of costs is around an IDP that wasn't in play at the point of submission. And when one's judging the DTC, it's not appropriate to fix the question of whether or not we complied against criticisms with regard to a document that postdates that date, in obvious terms. And I can pick up on something else Mr. Byrne has said, which is that, well, we always needed to have these costs. We're very comfortable that we have provided costs by way of the whole plan viability assessment and its update, and that those are reasonable and appropriate costs in order to understand the delivery of a very long-term development within the Greenbelt. And this is a point that applies equally to TfL. And we have assessed the costs on actually, as we'll come on to, a fairly protective basis in terms of the levels of those costs sufficient to be able to accommodate development in the future. And so all of those are points of principle that just comes down to, well, is it right or isn't it right that the sort of viability appraisal we've undertaken is sufficient for the purpose? And that isn't going to be overcome by virtue of further discussions. So it really is a matter of agreeing to disagree. I don't know, do you want to say anything more?
Sorry, was there something else? Okay, thank you. Right, okay. Thank you for that. Any other comments on the duty to cooperate? Yes, sorry. Oh, sorry, I missed your sign.
It's all right, thank you. Josephine Voss from TfL. I completely take the points about principles and having to agree to disagree, and that is part of local plan processes. However, a really, really key point for us, which we've raised from the very outset, from Reg 18 onwards, is that we need to be, as the transport operator, able to provide a viable bus service that will enable these developments to be sustainable. And what we have said from the very beginning is that in these locations, with these quantums of development and with the lack of policy hooks around parking and other issues, we are not satisfied that that's possible. I think a lot of Londoners know, but possibly not more widely than that, the bus service is very, very heavily subsidized by TfL, and we are not in a position to be serving low-density car-based developments with high-frequency attractive bus services. So for us, from the very outset, and also there are I don't want to go into the technical detail because that will come out in the transport discussions, but we did provide, as my colleague alluded to, confidential information from our bus service colleagues that show very significant disbenefits for existing bus passengers that would mean we are taking away from the existing network and spreading it further and degrading the bus service, making them less reliable because the routes are longer, et cetera, et cetera. So there's a lot of real transport planning issues that we tried to raise from the outset, and we really have never experienced having an IDP published that was not consulted with us. That includes things like frequencies and bus routes. TfL always has to be at the table from day one when it comes to planning the bus network because we are the operator and we have to pay for it at the end of the day. And planning obligations do play a role, and they play a really significant role in priming services. But I've never seen a case where we get more than 5 years of upfront funding to enable that. And so after that 5-year period, we do need to be satisfied as the operator that we have a sufficient population with sufficient destinations and routes that make sense for us to be able to commit to that. And we just can't do that based on what's in the local plan.
Okay, thank you. I mean, there's a lot of soundness issues in that. So I think a lot of that would come out of the wash in discussions about soundness of individual allocations and strategies as a whole. What I did hear from a duty to cooperate perspective is that you've provided information to Enfield, and whether they've used it to your satisfaction or your well, obviously not to your satisfaction, but it's still, there has obviously been some engagement. So, and that's my role in this at the moment, is that has there been sufficient engagement? So it might not always, and again, devil's advocate, it might not always result in what everybody wants. That's not the test. The test is, has it actually happened? So that's just where I'm coming from this. But again, like so many things, all of what you're raising your concerns about, if and when we get to that stage, will be discussed anyway. So there's always been an opportunity to put those points forward from a planning, the sounders point of view. So do you want to make another point?
Just wanted to make another point on sort of the infrastructure delivery plan, that it was not in the play before the submission. Just the PPG paragraph 59 and 60 of plan making does set out that local planning authorities should work alongside infrastructure providers and service delivery organizations to understand the quality and capacity of existing infrastructure and its ability to meet forecast demand. So while we understand that it's in principle not necessary, but yeah, again, as Josephine said, it would be important for us to be engaged on that. So our point is that we weren't engaged properly. There was information that was relayed one way, but there was no coming back, and the way it has been represented in the transport topic paper, I think it has been misrepresented on the information that we provided. And sorry, can I add, we have provided what was misrepresented in one of the appendices that's not yet published on the website.
Okay. Thank you. Before I go back to the council, if they want to come back on it, I would like to actually ask GLA just a general question. We've been talking about all this, whether you have any, while you're here, representing one of the prescribed bodies, whether you have any concerns about the duty. I guess if you had, you'd probably put your sign up, but I just, for the avoidance of doubt.
No, we don't have any duty to cooperate concerns with our...
Okay, so yeah, is there any points you wish to come back on there, Mr. Reid?
Thank you, sir. I did take some instructions on the issue of whether we had discussed the question of buses, and we certainly did. At least those are my instructions. I don't think it's suggested actually by Ms. Voss that we didn't. I think Ms. Voss was involved in at least one of those meetings. What I did hear was that there were further matters that have been raised with regard to the confidential information that Ms. Voss has received. I don't know anything about that, and I can't take that further. But it couldn't possibly be said, I think, that we hadn't engaged with the issue of buses. The second point, with regard to Ms. Jane's point on the infrastructure and what the PPG says about engaging in discussions around infrastructure, we certainly did. What I think Ms. Jane has done is transcribe the guidance with regard to the need to discuss infrastructure onto the requirement to have an infrastructure delivery plan of a certain standard that she just thinks isn't sufficient for present purposes. We think it is sufficient when engaged alongside the whole plan viability appraisal. But that's different. That's just simply a matter of, again, have we provided within that infrastructure delivery plan a sound proposal, which can be debated at a later point. It's not actually a DTC issue. Then I think I can go back to having dealt with all of the other points from TfL. Just pick up on one point that Mr. Byrne made with regard to the statements of common ground. You'll recall that he relied on the bit of the guidance that said when the statements of common ground can be submitted. I think it's fair to put it like that, because there's another part of the guidance which says that statements of common ground can be produced at any point in the plan production. So you'll see that it's a little more nuanced when one looks at the entire guidance. That's all I need to do by way of response.
Okay, thank you. Any more points on the duty? Don't think there are. Right. Obviously, not least because I don't have the most up-to-date version of the statement of common ground with TfL, which I think, by the sounds of it, would be quite important. And we've already talked about there being areas where I would need further information, which I'll set out at some point, of what that looks like, to satisfy myself of the duty. I can't, at this moment in time, say that I am satisfied that the duty's been passed. I think there's additional work to be done. That does generally call into a question of whether or not to continue. There are examinations which have stopped at this point where the duty, where the inspector can't be satisfied. Some have carried on. I may go and ponder this at a break. I don't know if you've got any views on that in terms of, obviously, if I would, the concern with carrying on is if I get all the information that is not before me, and I have concerns, and say those concerns ultimately are unmitigatable, then anything we do from now on is abortive. Yes. The alternative is that we get the additional information, we may have another discussion about it at some point, it's satisfied, and then we could have carried on and dealt with some of the issues, and dealt with them, and addressed any other points that might come out of that. So it's a bit of a quandary for me. I don't know if you've got any views on that, because I don't want, obviously, I'm aware that if there was an issue, if we carried on, there was an issue, the council may not be happy that we carried on in the circumstances where there was an outstanding concern.
Yes. So the a starting point will, of course, provide that information to you that you've indicated, and I understand that we can do so in pretty short order by Monday of next week. So you should have what lies behind the schedules within the DTC statement. As a more important overarching issue, I think, is the question as well, how concerned should you be in the light of what you've seen? And, of course, the question for you is whether or not the duty has been satisfied. And that's obviously a matter of judgment, but it does need to take into account the totality of the evidence that you have. And the totality of the evidence is that I'm going to put TfL to one side for the moment, but in terms of all of those matters that you've referred to in the context of the Duty to Cooperate statement, they are, of course, to be read within the context of a series of statements that from the various parties that the DTC has not failed. And you'll know that in most of those, well, I won't say what proportion, but a very significant number of those local plans that have been found to have failed the DTC, it's because of objections on the part of DTC bodies saying that there has not been compliance. As I say, my representations at the moment all relate to the position barred TfL. And so we're in a very different situation here where actually there's no indication at all there's been a failure. And when one's looking at that, one needs to look at the totality of the evidence. And the evidence that we're really concerned about here is the highways position, the housing position, and the industrial land position. And when one's looking at the position with regard to London, the availability of land in basically greenbelt locked authorities, the availability of land within the urban area sufficient to meet the needs of a London borough is, looking at it in general terms, very unlikely indeed. And that's why, actually, the conclusions that have been reached in the DTC are well understandable. Because there just isn't that sort of land available, because, as I say, because of the greenbelt presenting the sort of issue that it does. So I'm obviously not here to teach you that which you obviously already know with the experience that you have. But all I'm pointing to is that you can take comfort in the overarching conclusions, the conclusions that sit on their face, as it were, and indicate on their face what is the position. And if when you look at it in that light, you can be satisfied that the duty has been complied with. We're providing, obviously, this other information that I hope will satisfy you. But all of that means that you can be reasonably comfortable that the overarching conclusion in the DTC is the appropriate one to arrive at, and it'd be right in the circumstances for us to continue, certainly until you have that extra information. I did put TfL to one side. I've made my submissions on TfL.
Okay, I'll bear that in mind while I ponder it. Whatever decision I make obviously will be taken with the caveat that until I've got that information and been having the opportunity to review it and maybe ask questions about it, then there can be no, it's without prejudice basically to my outcome. Okay, okay. With that in mind, then we'll move on to matters of duty to sorry, not duty, general conformity with the London plan. Now, this is going to be a difficult one because whether or not the plan is in general conformity with the London plan is not something I expect to be dealt with in one session or today or even the next half an hour or so. It's likely to come up in various places, in various matters and various topics, as it is an issue which cuts through the entire plan. In my view, it is particularly important in terms of what we're talking about in the next few days in relation to the housing requirement and supply, the employment requirement, employment land requirement principle and specifics of green belt release. We're not talking about specifics of green belt release in stage one, but it will obviously come up. So on that basis, question 1.7, which is an overarching question, will not be answered today. And it may well be that I defer some of the points that have been raised to subsequent sessions. And I think it's logical that some of those points that have been raised will be discussed in subsequent sessions. It won't make sense to try and get into too much detail today. Bear in mind, of course, I've got everyone's points. So, for example, if anybody considers that a particular aspect of tall building policy or the effect of a tall building on a particular area is a conformity issue, I suggest that's something we discuss against policy DE6 or the specifics of an allocation, because that makes more sense. If there's some overarching approach to tall buildings, which I need to scratch the surface of now, then we can do that, and I'll bear it in mind for when we get into the nitty-gritty of it. This session will provide, I don't want it to last too long, but this session will provide an opportunity, as I say, to consider some of the headline issues, provide an opportunity to highlight any particular areas of concern or contention, which allow me to focus things at a later date, and provide some context for future discussions. But as I say, I don't expect us to get into all of the detail. Where I've asked about the main modifications proposed to ensure conformity, which is question 1.8 and 1.10, in the main, I think I'll probably deal with those when we get to the relevant aspects of the plan, when we obviously talking about the relevant policies. Again, if anybody's got anything burning they want to tell me today. But it's useful to have the Council's statement on that now, so I can use that as we get to each point, use that to guide discussion later on. One other point I will say is we have the benefit of representative from GLA here today. I don't think you're going to be able to attend any other day, so there may be questions I put to you now that are more relevant to matter 2 or 3 or 4, but as I don't have you those days, then I may as well ask them now, but then it may well be the wider discussion about any answers you give, I defer until another time, given that we haven't got a huge amount of time left today. Is that okay with everybody? Does that make sense? Okay, so first of all, I just want to, as I say, because I'm talking about generalities here, I think it's a useful place just to talk about the principle of general conformity with the Council, to see what that... I've got your general conformity topic paper you set out. I suspect you wrote this, Mr. Reid, did you? The legal requirements of the duty. I call it a duty, the requirement. As a context setter, I think it would be interesting to discuss, at least your view on what you consider my role to be in is, and what constitutes. It's probably easier to talk about what constitutes a failure of the requirement. So, where is the bar set as far as you're concerned? I might not agree with you, but I'd be interested to know where you say that. What would constitute a failure if I was to find it?
Yes, you're quite right. So the position as we see the issue of general conformity set out in topic paper 3.1. And we also produced an MIQ dealing with that issue as well. Of course, when one's looking at the issue of what constitutes or doesn't constitute general conformity, the position of the GLA in this is critical because they, as part of the statutory construct, are required to indicate whether or not they think that the plan is or is not in general conformity. And actually, we do have an up-to-date position now with regard to where the GLA stand in relation to conformity, and that is really a very a highly restricted point around tall buildings and around the application of greenbelt policy. And critically, in this case, it is not around the 4111 issue. And so I'm going to assume, for the purposes of what I'm going to say, that you're clear about the terms of 4111, which in the housing context is looking at the question of what an authority can do if it is seeking targets after the initial 10-year period of the plan. And that sets out a series of parameters that we'll debate when we come to the housing need issue. But as I say, I'll just assume for present purposes that you're comfortable with that, and you've nodded, so you are. And I just, as an opening indication, as I say, we are looking only at the question of greenbelt issue and tall buildings for the purposes of the GLA. They are very clear about that being the principal areas with regard to issues of general conformity. Everything else is capable of being overcome in any event by various modifications. Now, the question for consideration when one's looking at general conformity is general conformity, of course, with the spatial development strategy. And I set out in the topic paper itself, I don't think you need to go to it, but paragraph 4, I set out some of the general principles that are derived from the Persimmon case. And ultimately, it's a matter of degree and of planning judgment as to what amounts to general conformity. I don't know whether so you want to have that to hand. I'll just... thank you. Just get that, just so I make sure I'm on the same as you. Yes. Yeah, and so you'll see the relevant principles set out at paragraph 4. And I set out a series of points that, as to what it identifies, but the overarching point is that it is to be regarded in a flexible way because principally you are looking at policies in a strategic plan that are long-term facing. And that militates towards, the court said in Persimmon, a broader view as to what amounts to general conformity as opposed to a narrower view. And importantly, what conformity requires one to take into account is that there can be some conflict between strategic policies and the proposed local policy when assessing whether or not ultimately there is a breach. I also indicated paragraph 6 within the document, the position, at least in guidance, which deals with the issue of general conformity as between neighbourhood plans and local plans, which again provides a general indication of the position. But what one will find in that guidance, which I've set out in terms, I don't think it's been changed with the update. We will check that to make sure that it hasn't changed. But you do consider again the degree, if at all, of the conflict between the draft neighbourhood plan policy and the policy itself. And so, to answer your question, it's rather difficult to define when something would not be in conformity or when it fails and it or rather when it fails and it's out of general conformity. Because everything, it requires one to look at the context of the situation and, most importantly, the wording of the proposed policy as against the wording of the strategic policy in order to see whether or not there's conformity or a lack of it. And in the light of that, I'm just going to deal with the two principal matters that exist between us and the GLA in the light of the Statement of Common Ground, as to say the tall buildings policy and the Greenbelt policy. Now, the tall buildings policy, as we have got to a situation where, at least as far as the drafting of it has been largely overcome, save with regard to, most importantly, the fact that various exceptions are contained within our policy, within D6. They, it said, should be removed in order to resolve the issue. And we've indicated clearly why it is that we think that there's conformities between those two matters. But ultimately, it's a matter of judgment as to whether or not you just need to modify it in the way that the GLA would require it. So it's really rather a minor issue with regard to the tall buildings matter, I'd suggest. The more important question resolves around the Greenbelt, and what seems to be said is that one would have a non-conformity with the Greenbelt policies of the strategic plan by virtue of the release of Cruise Hill and Chase Park in this case. And it's really rather simple in relation to that as to what the answer is, because policy G2 of the London plan allows for release in exceptional circumstances. And so if exceptional circumstances are established, then necessarily there wouldn't be a lack of conformity. It would only be if, as a matter of principle, one cannot release Greenbelt land for housing needs, that one would be in a situation where there may be a lack of conformity, and that just isn't the situation with regard to that. Just bear with me a moment. Yeah, it's just been confirmed to me so that the guidance that we've included in the conformity position paper is unaltered. So can I then go on to this issue of 4111? So I don't know whether this is the right time to do it. I know I've been speaking for some time.
It's fine. I mean, you're preempting a lot of my questions, which I always appreciate. So
very good. In that case, I shall. I'll press on. So, as I say, the GLA isn't saying that there's a lack of conformity with 4111, nevertheless, a number of third parties are saying that there is. It's understandable that they're not saying, the GLA are not saying that for a number of reasons that I'll come on to. But overarching, they recognise, most importantly, that there is a context for the delivery of housing in this plan. And it's something you raised earlier on with regard to the MPPF, the new MPPF, and what are its consequences. Of course, this plan is going to be tested against the principles of the December 23 plan. But decisions in terms of long-term development that are coming forward, and which will be coming forward within a context of even greater housing need, is something that properly can be taken into account when considering ultimately if the plan is sufficiently positively prepared. As to say, it is looking to the future appropriately. We know the future, actually. It's not a conditional future anymore. So it is a part of a context that needs to be looked at when one is assessing ultimately whether in this case, there's a need for release of the Greenbelt. And the GLA recognise that implicitly by virtue of what they've said in the Statement of Common Ground, if nothing else. And they, of course, object to whether or not it requires, at this stage, the release of the Greenbelt. I'm going to set up my stall rather more generally in terms of what Ms. Jane said, which is I didn't pick up on her on. But if you look at the position in the hearing statements of the TfL, they were not putting forward that Greenbelt release in the context of it being an example of what could happen. What they were saying was, in terms, and it's something that it may be necessary to examine a bit further, but what they said in terms was that in order to acknowledge, I'll deal with the specific wording in a moment if I can get it up on the screen. We'd like to work positively, reading from the statement, this is page 1 of their Matter 1 statement. We'd like to work positively with LB Enfield towards the provisions of the new MPPF and LHN, that's local housing need, with a view to a significant development focused on Chase Park to deliver between 10,000 and 12,000 homes and necessary infrastructure. This was not an example that was being proposed. It was actually a proposal. And recognition, I say, of what the GLA is also recognising, namely the future. And that, going back to my point, is why 4111 has been basically abandoned by the GLA.
We will come on to that, but perhaps move on. You can move on a little.
I'm so sorry.
I want to ask GLA about that.
Yeah, I didn't want to leave the point, so because the reason it's part of the important context is because one can see where we are, why we are where we are, and so I will move on. And I can deal very briefly with 4111 as to why it is not something with which there will be non-conformity. And there are a series of points with regard to this. We've indicated it in our conformity statement. So I'll be reasonably brief about it. And the first point is that it's not actually part of the spatial development strategy. What is required under Section 24 of the 2004 Act, which sets out the Mayor's, the GLA's position, is conformity with the spatial development strategy. That is defined under the Greater London Authority Act 1999, which identifies the policies of the Mayor. And one can see that that is not and does not include the written statements of the strategy itself. And so 4111 is not actually part of the strategy with which there needs to be conformity. In any event, even if we're wrong about that, and it's regarded as being part of the spatial development strategy, 4111 actually does not prevent the identification and release of Greenbelt sites pursuant to Policy G2 in order to satisfy a housing target. It is not prescriptive and it is not preclusive. What it does is say, if a target is required, this is what you can do to identify the levels of housing, the levels of housing for your subsequent 10-year period. On that basis, again, there couldn't be a lack of general conformity with its terms if what you do is seek to release land. In any event, we have complied with 4111 because 4111 is very clear. It sets out a series of steps of what you need to do in order to deliver land, and we complied with those. And that includes identifying capacity. And we identify capacity in part in the Greenbelt, but we are not precluded, so long as the capacity is identified as being appropriate within the relevant documentation, we are not precluded from identifying that as part of the capacity. And it's said that, well, that's all circular, isn't it? Because you can incorporate any land you like. But the point is that you still, of course, in relation to any of these protected elements, let's say if it was sill, you'd still have to go through the process within the plan of identifying whether it's appropriate to release it. just as you would with Greenbelt, and that means establishing exceptional circumstances. So in principle, it's capable of being part of the requirement. What would be impermissible is just to entirely rely upon that self-same argument to justify the release. But that's not what's happening in this case, because there are a number of reasons as to why it is that we have concluded that it's appropriate to release that land. So that's the reason why it's not circular. But for those reasons, and in fact, that's rather a short, potted version of what is in the conformity paper.
Thank you. Because sorry, if you have more to say.
No, that's
the
it.
4.111 issue, I was going to ask GLA about that. I suspect, thank you for outlining that now. I think maybe tomorrow is the better place to discuss some, unless, of course, there's anyone around the table who's not here tomorrow who wants to address that point when we get to opening it up. Before I go on to you've gone beyond a little bit what I probably asked, but that's fair enough. That's okay. I'm going to drag you back a little bit to some of the points that you made early on about, and again, it's just a clarity thing. It's interesting to know your position. Confirm that in situations, so your perspective is, if in situations where the plans pull in different directions, it's not that in and of itself is not necessarily a fails the duty. I keep calling it a duty, the requirement.
It is, you're right, sir. It's essentially
a duty,
yes.
yeah. I don't want to get confused with the DTT. But, of course, conversely, if it could be, however, if the plans pull in different directions of such a significant issue so as to cause be problematic. So it is a matter of planning judgment. That's there's no absolute yes or no. It's purely my judgment.
No, absolutely. Right, so yes.
In relation to, you've talked about, you've actually moved on to, you mentioned the December 2024 framework. I'm not going to get into, not necessarily going to get into how much weight that should carry. That's possibly something more for the actual discussion on the housing requirement. There's some talk in the Statement of Common Ground with GLA, certainly the first one, and the conformity topic paper about this potentially changing of position, which I asked about, is where did, and I think I asked, I can't remember now where I asked about it, but where is this new advice? I think it's in relation to tomorrow. What does it mean, etc., etc. Some of them tomorrow, but in principle, because obviously the reference in there is to the London Plan being considered to be out of date. And I've had some responses to that, and so it'd be interesting to get your point of view, where, obviously, if it were determined that the London Plan is out of date, however, one would come to that conclusion, whether it's inconsistent with the framework or inconsistent with whatever, out of date in the context of age or any point, how does that relate to the requirement for conformity? i.e., to what extent am I able to say, in the context of the statutory requirement, say, well, the London Plan's out of date, therefore I'm no longer considering this to be a conformity issue, when the London Plan is still the London Plan. If that makes sense.
It does.
Yeah.
It does. So it's an interesting question, because the terms of the statute are that there would need to be a consideration of whether or not there is general conformity with that plan. And I think the answer must be in what one looks at with regard to the duty itself. Because if one's looking at the question of what amounts to general conformity, and how it bears on the question of what happens to a plan itself, Section 24(1)(b) says that there'll be a need for, or a requirement, as you said, of almost a duty, that is in general conformity. But it would seem to me that one would be tempering the significance of the breach of that duty when one is looking at the appropriateness of your recommendations on the plan in circumstances where that conformity itself would be non-compliant with national policy. That strategy, the overarching strategy, would be out of kilter with and obviously out of kilter with the national planning policy position. So I think it would come down to the issue of weight. One can't, the test of general conformity is very clear on the Act. It is simply comparing the policies, but it's the significance of that breach is where it would be of relevance for your consideration, I think so.
I wanted to, well, discuss whether or not there was any thought to which or any suggestion from certainly from Enfield, that if I were to conclude that London Plan were to be out of date, which I've not, obviously that's a matter for discussion, perhaps in the context of the advice, whether somehow that changes my position or changes the test. I don't think it does.
I think what we'll do is overnight just see if there is any dicta available that bears on that question, because it is important for your determination, I think so. And I think there aren't many plans actually at the moment in London that are grappling with that question. So it's probably something you do need to have at least confirmation of guidance on. We'll check that out.
Thank you. Okay, I'm going to turn. Hello, welcome. Thank you for sitting there for many hours very patiently. Mr. Reed's covered a lot of probably what I was going to add, general points. I suppose the first things first is whether you recognise what Mr. Reed said about the main points of disagreement, I suppose, and whether the general conformity exists. Is it? I've got the same as common ground, but it'd be useful to have your, straight from the horse's mouth, as it were, as to what concerns still exist and whether or not what I've been told is accurate.
I'm going to run through them right throughout to be really quite clear with the examination and to help your considerations. So set out the Mayor's position under delegation from the Mayor in relation to the local plan. So it is the Mayor's opinion that Enfield's local plan is not in general conformity in relation to greenbelt release and tall buildings, as we discussed. I'm not going to go into tall buildings, which is sufficiently covered in the Regulation 19 response and the Statement of Common Ground. In relation to greenbelt, the Mayor's opinion in May 2024 at Regulation 19 stage was that the local plan was not in general conformity in relation to greenbelt, as exceptional circumstances had not been demonstrated that would justify the release of greenbelt at Chase Park and Cruise Hill. And that view was essentially based on four concerns. There was no need, given the housing numbers used in the London plan. The Mayor was not satisfied that Enfield had done enough to maximise the use of brownfield sites. The locations chosen were unsustainable, and the number of dwellings proposed was not enough to change that. And the density of development was too low and failed to maximise the opportunity. In light of these concerns, the Mayor's position at that time was that the only remedy to the general conformity issue was to remove the sites at Cruise Hill and Chase Park from greenbelt release in the local plan. And if Enfield's proposals are considered solely in that context that was in place at that time, in relation to the previous MPPF and the 2021 London Plan, that position remains the same. However, it is recognised that since that time and following the general election, there has been a new revised MPPF. And while the transitional arrangements mean that Enfield's plan should still be assessed by reference to the old NPPF, it is the Mayor's view that the new MPPF is a material consideration which can be taken into account when deciding whether, if the question was asked today, are there exceptional circumstances which would justify the release of greenbelt? In particular, the new MPPF has removed text from paragraph 61 of the previous MPPF, and the text stated that there may be exceptional circumstances, including relating to the particular demographic characteristics of an area, which justify an alternative approach to assessing housing need, in which case the alternative approach should also reflect current and future demographic trends and market signals. And previous London plans used this paragraph to establish London's housing need figure, and we may well have done so again for the next London plan had this not been removed from national policy. However, that option is no longer available, and the next London plan will therefore apportion London's housing need as established by the National Standard Method across London's planning authorities in the form of housing targets enshrined in the London Plan. Under the new NPPF, London's cumulative housing need figure is 88,000 homes per year. And over a 10-year period, which is the usual planning period for a London plan, this amounts to 880,000 homes. This is a significant increase and is broadly the same as the number of homes delivered between 1991 and 2023, over 32 years. And clearly this will require a step change in delivery. In order to achieve this, the Mayor will continue to optimise delivery of housing on brownfield sites first in accordance with the NPPF. However, this will be insufficient to plan for the number of homes required. In broad figures, the current London plan originally planned for 66,000 homes a year within the existing urban form. This was reduced to 52,000 homes a year following the London plan examination in public, and current delivery rates are below 40,000 a year. Therefore, even with significant interventions, both policy changes and other mechanisms, land supply and reasonably anticipated delivery from windfall and urban intensification, it would be unreasonable to argue that the jump to 88,000 homes a year can be achieved wholly within London's existing urban extent. In accordance with the December 2024 NPPF, where the need for that housing and other development cannot be met through other means, the Greenbelt should be reviewed and alterations to the Greenbelt proposed to meet those needs in full, and that's paragraph 146. However, in light of the new circumstances relating to both London's housing need and the very different approach to Greenbelt set out in the new national policy, and in responding to London Borough of Enfield's proposed release of Greenbelt, it is noted that, as the Mayor has made clear in his response to the draft NPPF and at other opportunities, any Greenbelt release should be on the basis of building sustainable, livable neighbourhoods with access to public and active transport options, making the best use of land. In other words, the rationale for looking at locations well served by public transport first is they give more bang for your buck or more homes for the amount of Greenbelt released, and they therefore make a greater contribution towards meeting London's mandatory, nationally established housing need. As this national picture has evolved, we have kept our response to London Borough of Enfield under review, including the mayoral opinion of general conformity and whether exceptional circumstances exist. Across London as a whole, it is intended that this analysis of exceptional circumstances will be done through a London-wide Greenbelt review, but this matter has been accelerated in Enfield due to the timing of this local plan and the borough's proposed release of Greenbelt land. London's Greenbelt has a limited number of locations served by public transport. The Greenbelt within proximity to Oakwood and Cockfoster stations on the Piccadilly line is one such location, and this connectivity could facilitate higher densities than are possible in locations poorly served by public transport, and therefore more homes, more sustainably, on any Greenbelt that was released. In order to explore this, a piece of work that has been referred to was commissioned from independent qualified professionals to assess the Chase Park area, and the fundamentals of this analysis were to make best use of any land released from Greenbelt, to significantly increase the number of homes to address the housing crisis, landscape-led development, net gains in accessible public open space, net gains in tree coverage and woodland, support nature recovery and climate positive. This review concluded there were potentially other options for Chase Park which would be transformative and the number of homes that could be provided, and approximately 3 times the number of homes for the release of 40% additional greenbelt. The scale of this level of development would support other opportunities in terms of transport connectivity, in turn enabling the increase in the number of homes that could be supported on the parcels already proposed for release by London Borough of Enfield at Chase Park, and concurrently increase publicly available open space, retaining natural assets and parkland, providing compensatory land for any parcels of land loss, and significantly extending the accessible area of Trent Park. It could also increase woodland and tree coverage overall compared to the current situation. And it's important to stress that the timing of this work is running in advance of the London-wide work, including the London-wide Greenbelt Review, and further work to fully understand the potential housing capacity within London's existing form. And we recognise the speed at which we've had to prepare this analysis, its limitations, and the overarching need for proposals to be embedded in their local community and subject to public consultation. But notwithstanding this, it's also recognised it would have been inappropriate and unhelpful to come to you today to give an opinion on Enfield's proposed Greenbelt release based on assertion and conjecture. We do not at this stage endorse the specific option identified in the review, but we believe the general conclusion it has reached about the scale of contribution which is possible and the key principles on which it is based are sound. I also want to be clear that it does not constitute proposals for development. If that additional potential is realised, this is likely to increase the amount of greenbelt land that needs to be released across London overall if we are to plan for an increase in housing supply to 88,000 homes a year. And it's noted that the land taken for homes that need to be planned for on sites with poor public transport accessibility is significantly higher per home. In light of that work, the position in relation to the draft local plan remains it is still not in general conformity with the London plan because exceptional circumstances have still not been demonstrated. But the reasons which underpin that assessment have been reduced. In principle, the need for some greenbelt release to contribute towards meeting London's housing need to tackle the housing crisis appears unavoidable given the changes to national policy about needing to release greenbelt where housing and other development needs cannot otherwise be met, and the significant increase in London's mandatory housing need figure. However, the question whether exceptional circumstances exist is not one that can simply be answered in the abstract, and it will always depend upon a combination of factors, which include the particular characteristics of the site which is proposed for release and the way in which it is proposed to develop that land. And this is entirely consistent with paragraph 1.48 of the new NPPF, which advises that when drawing up or reviewing greenbelt boundaries, the need to promote sustainable patterns of development should determine whether a site's location is appropriate, with particular reference to paragraphs 110 and 115 of the framework. In the present case, with London Borough of Enfield's proposals on the table, the Mayor remains concerned that Chase Park and Cruise Hill are not sustainable locations and cannot be made so by the levels of development currently being proposed, and that the current allocations do not make best use of land which it is proposed to release. In the Mayor's view, these issues are sufficiently important to mean that exceptional circumstances do not exist to justify the release. There is therefore a fundamental conflict with policy G2 of the London Plan, which is sufficiently important to mean that the Enfield Plan is not in general conformity. However, whereas the Mayor's view, when it was considered there was no need for the release at all, the only way of remedying that non-conformity was to delete the allocations, we now consider this could be done in one of 3 ways. The Mayor would therefore invite the Inspector to consider 3 possible main modifications to make the local plan acceptable. And in order of our preference, these are: complete the relevant documentation and consultation for a different release of land overall from the Greenbelt than that proposed by Enfield, together with a very significant increase in the number of houses which the allocation is expected to deliver within the scope of this EIP. The associated policy would need to specify the infrastructure needed to ensure the scheme was sustainable and would almost certainly require a comprehensive scheme or master plan before individual sites could be brought forward. If this can be done, it is likely to be the quickest way of bringing the proposed allocations forward. However, the Mayor recognises that the work required may take some time, and it's obviously a matter for yourself.
Sorry, can I just, how much more you've got? I don't usually allow statements.
Oh, I'm
This is
nearly
the
done.
important thing.
Nearly done. It is a matter for the inspector whether it be appropriate to delay the plan for this to take place. If that wasn't possible, for example, it would take too long, a compromise would be for the local plan to be amended so it establishes both the principle of releasing a different area of land for a significantly more ambitious development at Chase Park and reconsider Cruise Hill, but defer the actual releases and any decisions as to those precise locations to an area action plan. In order to assist that process, the local plan could identify an area of search across a wider geography in which the AAP was expected to identify the precise boundaries. The associated local plan policy would also need to be amended to better reflect the potential of the opportunity presented by the locations with good public transport accessibility and ensure that all development brought forward through the AAP in a way that supports the appropriate housing numbers and sustainable neighbourhoods, i.e. sufficient to support necessary public transport to unlock 10,000 plus homes. One of the advantages of the approach that would tie with the London Plan timetable, which requires timely progress for work towards housing targets, in any case, to support a draft London Plan before 1st of March 2026. And finally, if neither of these solutions is considered possible, the Mayor considers the only way in which the local plan can be amended would be to ensure general conformity would be to remove the sites at Chase Park and Cruise Hill from the plan. And these could therefore be considered for an early review once work has progressed on a new London plan. Whilst this would be the least preferable of the three modifications put here, it would ensure the opportunity represented by Chase Park and Cruise Hill is not squandered, which is our most significant concern, and would therefore be better than the plan as it currently stands. I just very briefly wanted to answer the questions on 4.1.11, not from a statement. The point being that in light of the significantly increased numbers, there are a number of boroughs when they assess their housing need going forward beyond the 10-year London Plan period, their annualised figure drops significantly. And that's just a function of how that text is written. What we did was we advised boroughs that rather than having this great dip and then having to jump up again towards that 88,000 homes a year across London, that they roll forward their existing target. There's no suggestion that's relevant here because London Borough of Enfield are proposing annualised housing figures that are very much higher than the London Plan housing targets as they currently are adopted.
Thank you. I didn't know you were going to be doing a statement.
Sorry,
so,
my apologies.
Just for anyone might have asked if they wanted to say, I don't normally accept it, but bearing in mind you're only here for one day, and obviously what you've got to say is very significant and a little surprising. As I wasn't necessarily going to be aware of what you were going to say. I allowed it. A lot of what you've discussed there will come up in subsequent days, so I'm not necessarily going to go over all of that, and I think you've set your stall out there. If at some point I need some further, because there's a lot to drop on me, frankly, and I need some time to think about what the consequences are. I want particularly, I've had discussions tomorrow and on next week when we talk about Greenbelt and so on, so maybe some additional queries I put to you. A couple of things though. Notwithstanding, if we just go back, if you like, to a pre-December 2024 situation, and we just for hypothetical reasons, put the new framework on one side. If I was dealing with 4.11, as far as you're concerned, Mr. Reid suggests that, as far as he's concerned, conformity with that paragraph or not, and he says in conformity with it anyway. But if I was to conclude, that's not a conformity issue because it's not part of the policy framework. So what's the GLA position on that?
I don't think just by virtue of it being in the paragraph, not in the main policy, that precludes it from being a general conformity issue. But what I would say is that general conformity is exactly that. It's general Persimmon Homes decision. There are a number of other decisions, including Richmond, that we can send on to you in terms of general conformity. But it's not simply a matter of adding it all up and then saying where do we fall. It's also the actual importance and the implications of the various parts of the plan. I would have to take further legal advice, but it's never been our view that elements that are within their paragraphs rather than the policies themselves are incapable, and particularly because they give advice of what you do beyond a statutory period that is covered by the policy itself. I would be very much surprised if they could just be put to one side automatically, because it is the SDS taken as a whole where the general conformity test lies. I'm not aware that it's specifically limited, and I've certainly never seen or heard any legal advice to that effect before.
Thank you. And in your experience of other examinations into London Borough plans, is paragraph 4 point what? I better get a standard way of saying it. I better get a standard way of saying it. 4111 has been a conformity issue that inspectors have considered, or at least councils have addressed as part of their we're in conformity with the London plan because we followed that approach.
It does form part of the overall discussions on how the boroughs set out their housing need figure and how they arrive at their housing need figure. It has to, because it's the only guidance we have to what to do beyond the 10-year period.
Taking the point, Mr. Reed's point to his logical conclusion that the 4.111 is not part of the policy and therefore not part of the spatial plan, and therefore, if that was the case, as far as what weight would I be giving it, and what alternative approach should I be taking? Because if there's no, if 4.111 is not guidance, it's not policy, and therefore it carries no weight, then where do we go from there? In your view, I might ask them that.
I think where we go from there is it provides a very helpful position on what to do beyond the 10-year period. And I think I would pick up on London Borough of Enfield's point, which was more to say that the GLA had abandoned 4.1.11, which is not accurate. What the GLA has said is that it would be unhelpful for boroughs to take a sudden dip and then have to build up their pipeline again towards the 88,000, or what was then the 81,000 homes per year. That was guidance so that we could all work together towards where we need to be in light of those new figures, and it was a discussion with the boroughs. There's by no means an abandonment of those policies. We're very clear that the targets set out in the London plan are the right ones, and they remain up to date, and we have no doubt that the London plan is still up to date at this point in time.
Well, that's an interesting point, because obviously the state now, one of the two documents, Statement of Common Ground or the Conformity Topic Report, or both, does actually refer to the London Plan being out of date. That may well have been London Borough of Enfield's position. It's important to know, but whatever it's, I mean, you know, sometimes Statement of Common Ground site is good to know. So as far as you're concerned, it's not out. And even with the December 2024 framework, it's not out of date in the context of the part of the framework that talks about what you do when a policy is out of date.
No, absolutely not. And it will only be 5 years come the 1st of March 2026, which is why we've got such a critical deadline to work towards getting those new housing targets in draft form in the public domain by that date, because that's the 5-year point at which the London Plan has to have been reviewed under the NPPF.
Just bear with me while I look through my questions, because a lot of these may have been answered in your statement. So yeah, just, I mean, again, this is really a question for tomorrow, but you're not here. So just to get absolute clarity, because you said that you advised councils to roll over the table figures. but that's not, and again, I think in the statements common ground / conformity top paper, there's a suggestion that's your suggestion for Enfield, but you've just said, just to clarify, that isn't the case for Enfield. So Enfield, you're content that they should be using 4.111 as a capacity, looking at capacity, whatever that capacity figure may result in, and that's the approach you feel Enfield should be taking, not rolling over. Is that?
No, the approach we feel they should be taking is rolling over. The issue arises because Enfield's annualised figure is actually much higher than the London plan figure, and that is the argument being used to justify the Greenbelt release. So in fact, we don't believe the Greenbelt release is necessary because we don't believe they should be setting their annual figure that high at this point in advance of the new London plan targets.
Sorry, beg your pardon, misunderstood that. So, okay. And so again, I suppose again, the logical extension of your point is that issues such as, or is this a logical extension of your point, is that issues such as Greenbelt release and the overall distribution of the 88,000 a year and so on should be dealt with through the London Plan Review, not because Enfield have got there slightly before everybody else.
That's absolutely right. Could I make just something really clear? And the reason for that is because if these sites are going to be released as part of the entirety of London-wide Greenbelt, first we need to understand how much can't be met within London's urban form and then make up that shortfall. But what our biggest concern is that the sites will be released for under-ambitious development, and that will compromise the ability for London to get to its 88,000 homes a year overall across the whole of the London area.
Thank you, helpful. One thing, again, I apologise for mixing a little bit today and tomorrow, but Mr. Reid suggests that 4.111 is sort of, again, not whether it's how much weight to give it and whether it's policy, not policy, and how, but in terms of whether or not Enfield have met it, is because they've obviously, there's nothing precluding them from releasing Greenbelt through that. It's about additional local capacity, and we're going to have a debate about that, no doubt, over the coming days. But it does talk about, in consultation with, I mentioned this earlier in the DTC committee, in consultation with GLA, as I've got you, what is your interpretation of that? I think, generally speaking, the views I've had around the table from obviously people is that means, or at least infers, implies that should be in agreement with GLA. So, and it's a ipso facto. If GLA doesn't agree with the sites, then it can no longer agree with the capacity figure. And if it doesn't agree with the capacity figure, then it's not in conformity with that paragraph. So, is it in consultation with and in agreement with? It's very, I mean, it doesn't say that, but is that what the implication is as far as you're concerned?
I think the implication is that the current London plan figure should be met within Enfield's existing urban extent without the release of Greenbelt, that there's no justification for moving to a substantially higher figure, and we think it would be a circular argument to say we're going to set our figure higher than the London plan has apportioned us, therefore we need to release Greenbelt, so therefore that's our figure, and we don't agree with that. Now, moving forward, there obviously may be a much higher figure for Enfield alongside other boroughs.
And the exceptional circumstances point is a point, as you say, there's two, whenever you're doing Greenbelt release, there's two stages at which you consider exceptional circumstances. So exceptional circumstances at the overall principal level, which we'll be talking about next week. If they is okay, in terms, then you move on to other exceptional circumstances for individual sites and locations. So again, is a sort of sense that you may be seeing now that there's an exceptional circumstances case in principle, but the sites are still not ever, there's no exceptional circumstances on the site basis. That's still your position.
On the site, but because of the schemes being proposed. That's the issue. They don't deliver, for their release, they don't deliver sufficiently to warrant the exceptional circumstances being demonstrated.
Thank you. Anything you want to come back on? I'm sure there is.
There is a starting point. Obviously, I know Ms. Vermeer was reading from a statement, and I wondered if she would be willing for that statement to go into the examination so that we can have it in terms. It allows us then to work from a clear basis.
Is that possible? I would find it helpful as well.
Yeah, what we would do is we can produce the Mayor's general conformity opinion as it is at this point, and that's different from the statement here. So no, I don't have delegated authority to release this to the examination, and I completely accept. But what we would do is we would prepare a letter that is done under formal delegated authority. We obviously have the right governance arrangements in place to be able to issue an opinion of general conformity, and we could produce one of those for the examination.
Well, not that at the moment, because I think that's getting into the realms of we're having it maybe ending up with a slightly different. I'm sure it would end up saying the same thing, but I don't want to get a different piece of work. Then there's going to be a debate over whether it's actually what you said. Obviously, you have. Understand you've got your own agreements to go through. I will just make the point, you have just said it all. So it's all in the public domain anyway. It's streamed and been recorded. So maybe whether or not you could take that back to whoever you have to agree that with. Except you might not be able to make that commitment today, but I think it would be helpful. And if you, bearing in mind that, you know, a transcript of that could be made anyway, one assumes, from the recording, and we may as well get it officially.
No, I completely appreciate that, and I will take that away and make sure that you have an answer.
Yes, the reason I say that, sorry, sir. The reason I say that is because, of course, it was very clear as to the approach that Ms. Vermeer was taking on the part of the GLA, or on the part of the Mayor, rather, and the GLA, which was that actually they were asking for a different form of provision. There actually was a specific position taken as to the modifications that would be appropriate to make the plan sound. And that, in principle, led from a conclusion that Greenbelt should be released, and as a result, that itself was as a result of the application of housing need, which was recognised, and it recognised specifically at least the realms of appropriateness of this council's approach towards the housing requirement. Because otherwise you couldn't get to the modifications that were being suggested. So that's why I wanted that in writing, and so then we can work from that basis, because that's a different position from that which Mr. Vermeer was then setting out to you with regard to, well, do we just apply the 4111 rollover? That cannot consistently be applied to the position that was taken in that statement. And that's important, of course, for our purposes, because there is much in that statement that actually was very supportive of the approach that we had adopted. I take the point about them not being sustainable settlements, which the Mayor and the GLA have consistently said is the situation, and that will be for judgment. But it does alter the landscape within which you will need to consider things, and indeed this authority will need to consider things in the light of that statement. I will be saying at the appropriate time that the Mayor's position, as was presaged, in fact, by the TfL letter, as I said, it was not simply an example; it was the position of the authorities combined. Sorry, can I
just you've alluded to this, I think. Just again, for the sake of people who are not involved in this, that, as I said before, those alternatives can only be considered if I determine there are soundness issues, and the resolution and the solution to those soundness issues is to come up with these alternatives. Then they become before me. I would not, in the first instance, be telling the council what to do. If I say the plan's not sound for ABC, the first instance would say, so you tell me what you want to do about it, and then they will come back with a solution. There is a side issue to that now with the issues around pragmatism, and that if it takes a long time to solve, then that might have issues. But that's just so everyone's aware that where we're going with this. These alternatives, it's useful to know, and it is useful for me in context of why the plan is not sound as people, or why people suggesting the plan is not sound. I understand why, and it could be because they're alternatives that they consider to be more suitable. But as I said, they will not be before me formally. I will not be examining them unless or until they are put forward as suggestions to solve a soundness issue. And obviously, I've not even come to any conclusion about soundness issues yet. So, yeah. So I just wanted to make that clear.
To be absolutely clear, I'm not in any way suggesting that we accept any part of that sort of position. But what it does indicate is, nevertheless, a certain level of indications that our approach, at least in principle, is aligned with the future. And that is important for the purposes of justifying next week's whole debate. That's the first point. Second point concerns 4.1.11. 2 points arise in respect of that. I took at one point from what Ms. Fermanagh was saying was that 4.1.11 was still live. But of course that can't be right in the light of the position taken by the GLA that there should be a rolling over of the target. They're just simply inconsistent. So that rather gainsays the suggestion that that is an appropriate approach. There was also this question of, well, does in consultation with the GLA mean agreement? And I'm not sure I got a full answer as to whether or not Ms. Fermanagh was saying that it did mean agreement. I think she ultimately said, well, there was a degree of circularity around that point. That, I should say, was not something that was raised, in fact, in any part of the GLA's statement of common ground or uncommon ground in that context. But I don't know whether or not you want to deal with that now, or whether you want to deal with it later. But we're absolutely clear that that is not what it says. If it had meant with the agreement of the GLA, it would have said so. It's consultation, and we have consulted with the GLA on this, and we've indicated our position. They, of course, are entitled to disagree with it. And ultimately, I take their point that if we are in a situation where we have not established exceptional circumstances, then it would flow from that there would be an issue of general conformity. It would be largely academic, because then we haven't got the releases that we think should happen. But I think the important point for you, sir, is to look at the question of the issue of general conformity in respect of the policies, and can they stand adequately together? And you don't have an in principle lack of conformity just because there is a GLA, there is a London plan, exceptional circumstances release policy. Obviously not. Okay. So that's what I'd say.
Thank you. You may come back. You may wish to ponder those thoughts while, but I'm going to give someone else a chance to speak, as we've been a while. But I'm going to start with Councillor Georgiou. Thank you.
I don't know if this is appropriate, sir, but it's more of a question to you. Given the, I'll choose my words carefully as we're not going down site-specific, the quite interesting remarks from the GLA, and also given the comments from Mr. Reid, it was our understanding as a group and as a layman, as a member of the public in Enfield, that the weight will be given to the London plan, the previous MPPF, and I was just checking if that's still the case, because given what's been presented to you, obviously the council and the GLA are coming at it from different ends. So it's just more of a direction before I made any further comments.
All of it's relevant at the end of the day. Everything's material. I'm examining the plan under the, as I said at the start, under the December 2023 framework. The London plan is the London plan. Submissions have been made to me that I ought to be taking account of the December 24 framework, the new housing numbers, so on. I've had submissions also telling me I shouldn't. So these are all things for me to take away. If you think of it, I've got 1 million threads, and at some point I've got to tie all these together, which is an enviable task. But so my point of view is make the point you want to make, and then I'll take it from there. That's the easiest thing to do, really.
Well, out of politeness, my sympathies are with you completely. I think given if I've understood your instructions correctly at the beginning of 1.2, that you would like us to be general, not be site-specific. And I did have a statement, but in light of your current comments, I won't read it and waste further time. So I think, yeah, the position of the Conservative group very much is that there should be an adopted local plan. However, without the deletion of PL10 and PL11, this plan, and I struggle to understand once again how we're even thinking that it is not, it is in compliance with the London plan, which it is our belief it is not at all. I think the current London plan states very clearly its views on the green belt, despite what's just been addressed. But yeah, I think our position is very clear. If you delete PL11 and PL10, it brings it a lot closer to being in conformity with the London plan. And at this stage, because it is my view that people coming to these hearings should be looking to make the plan sound. And as a group, that is exactly our position. We would like the plan to be made sound, and are happy to work with whoever to make modifications, obviously, after whether you've determined whether the plan is sound or is not. And if you deem it not, that is our position. But of course, where we have colleagues here on successive days, we will make representations on specific sites. So I'll leave it there for now.
Yes, very helpful. Sorry, so it's very helpful. Mr. Byrne.
Thank you, sir. Just one point of clarity, or two small points, and then a more substantive point, if I may. Can I just double check? We're discussing 4.11 tomorrow, because we've got quite a lot to say about 4.11.
We're discussing it now, but we will definitely be discussing it tomorrow as well.
So we can leave.
If you're here tomorrow, my point was, as anticipated, there's a very big overlap, and I've probably been quite flexible today on allowing that because we're very early stages. If we're talking about 4.11 in July, it might be a different kettle of fish. But as for the moment, so where there's, if you're in tomorrow, then it's fair to raise it then. Obviously, if you want to say something now, fine, but we'll probably get into, I imagine we'll have some of this discussion again. Apologies, because we might be saying something, and there might be different people around the table. So, but by all means.
Okay, thank you for that clarification. We'll hold off till tomorrow. Just one small point then about the conformity, and clearly small sites are an important part of conformity. And we noticed that the council has now, in its statement of common ground with the GLA, agreed to meet the GLA target at H2 of 353 dwellings per annum. However, their it's matter 4 statement seems to suggest otherwise, and it seems to revert back to a previous position. So it would be good to have that clarified. Our understanding is it is now committing to meeting that target, and as such, there's a lot of updating to be done so that the capacity figures reflect that target, because that affects exceptional circumstances and all kinds of different conversations. So that would be really useful. In terms then of what we're talking about here, more the general conformity, and we're talking about general matters, we had a very read several times the council's hearing statements and the conformity paper, and reviewed the case law it refers to. And to us, it seems, and I think there's probably quite some agreement here, general conformity is a matter of planning judgment. And as such, we went and looked at previous planning judgments to all the recent London planning examinations. And it showed that general conformity is limited with is interpreted with some limited flexibility, but overall it clearly showed that the local plan must align with the strategic objectives of the higher level plan, as well as the policies necessary to deliver its strategic objectives in order to be in general conformity. Our understanding also of the case law and of the policies, and don't want to get into it, but 4.11, is that it is okay for the council to propose greenbelt land that is within the range of measures open to the council in terms of our understanding of general conformity. But in our understanding of it, that's not really the issue. The issue, in our view, is that the greenbelt land considered by the council and the specifics of the allocations are not in conformity with the plan in a myriad of ways, which reflect the strategic objectives of the London plan. They go right to the heart of the London plan, and that's if exceptional circumstances can be shown. So to summarise, the proposed allocations at Chase Park and Cruise Hill means that in overall terms the plan would not be in conformity with the London plan in terms of achieving the objectives of good growth, which underplans the whole of the London plan. It is the way in which sustainable development in London is to be achieved. So that's really important in terms of general conformity. This is where we went and read as much as we possibly could about general conformity, and this is our understanding. More specifically, the proposed inclusion of Cruise Hill and Chase Park in their current form means that the plan is not in conformity with London Plan's strategic policy, GG2, and the multiple London Plan policies which underpin it. So we also want to see the plan, getting on with the plan being sorted and found sound. We've waited long enough. I mean, we were bringing up these issues about the lack of, if we're going to do Greenbelt, you need to change the density of what you're proposing and think about this differently at Reg 18. So we feel quite frustrated to be in this position, but we sort of feel we have to agree that the way for this to become sound is to take out Chase Park and Cruise Hill. That is the quickest way to get this plan to be found sound and in general conformity with the London plan, and then to look again through the process from the London plan, which has already started, and you can think then about finding sustainable options which will be in general conformity with the London plan, and then it can be found sound. Yeah, that's it.
Thank you. I think Hadley Wood were there next.
Yes, and sorry if as a relative newcomer, sort of, or layperson, if I've failed to decipher the language, but I couldn't quite work out whether the GLA's view was that in consultation with means agreed with or just discussed with.
Okay, thank you. Well, Mr. Reid had that query as well, so I'll probably go back and clarify that. Thank you. Enfield Society. Oh, sorry, no, I beg your pardon. I can't see that far down there.
Okay. Yes, thank you. We all heard the GLA statement, so we can't unhear that. So I do have a question about it for clarity. Given that the Mayor has announced a London-wide Green Belt review and search for grey belt, isn't it rather jumping the gun to be having option one to include the wider green belt in Enfield, when the result of the London-wide green belt survey could find sites to cater to the new housing targets without the need for Enfield green belt, or it might find green belt that can be taken out with less harm rather than taking out part of a park and various other things. So I was just wondering why that was option one. It just seems jumping the gun when there is a survey coming down the pike.
Thanks for that. I'm not going to get into that now because, obviously, as I said, I'm not examining options 1, 2, or 3 at the moment. That's so I don't want to get into a debate about GLA's options when I'm not examining them. Who have I missed? Oh yes, sorry.
Thank you. Forgive me if I don't quite know where the spot is to mention this, but it seems relevant because it's London Plan. I know it's not a general conformity issue, but I'm conscious in the context of our concerns as over 50s, downsizing, etc., and now the talk about numbers of homes and debates about that, which I know will come up tomorrow, so maybe I'm out of kilter. The London Plan has policy H9, ensuring best use of stock requires efficient use of existing housing stock to reduce the number of vacant and under-occupied dwellings. And it goes on to talk about people like me occupying modest houses, but not, family houses, which could be used. Do we have any idea at all how many family houses are occupied by older people that could make a difference?
Well, we'll put are you here tomorrow?
I am.
Yeah, well, I think either tomorrow or that also sounds like, I don't know if you're here on Tuesday. That's a housing need for. There's a housing. One of the issues is meeting the needs of groups, and older people is part of that. So I think because it's not, as you say, it might be a conformity issue, as in there may be issues in the London Plan where we have to compare and contrast what the policies are saying and the approach is saying, but it is a very specific, very detailed matter that I'll probably don't want to get too much into at the moment.
May I just add that in, and I'll say again, I'm a volunteer, and you know, the swan about its feet going furiously, my feathers are flying as well. I don't get a real sense of clarity in the local plan, and this is really concerned us for a long time, between the needs of independent older people who wish to live independently but are occupying properties that are inappropriate, blah, blah, blah. It seems very obvious to us that releasing those properties for families, and we're told family accommodation is the major issue, it seems to revert back constantly to specialist housing, and that's not what we're talking about.
Okay, thank you. As I say, just we're going to get slightly off track.
Understood.
And I appreciate, you've probably been waiting 6 or 7 years to get these points out, and you want to get them out. It's often the way. So I do beg your patience.
Yeah, I can wait.
Before I go back to GLA to clear up a couple of things, Mr. Stevens, you've been keeping a watching brief all day, so you're welcome.
Thank you very much, sir. I think this is the most interesting London Borough examination I've been to for a long time, actually. It's really testing my brain cells, I have to say. I think the test is...
Due to my questions, or is that due to the actual topic?
It's the nature of whether you can release greenbelt land, within the context of what the London plan, the current London plan says. And, I think the key test is conformity with the London plan. And, of course, we are really agonising over what policy H1 says and what paragraph 4(1)11 says, and you might also throw into the mix good growth policy 4, which is about increasing housing supply, and it does refer to ensuring that more houses are delivered. That's in part A of good growth policy 4. So we need to look at all the good growth policies altogether. And then you've got policy G2, the Greenbelt policy of the London plan. And when that was originally drafted at examination, yes, it is true that the Mayor of London tried to prevent any Greenbelt release. But it was concluded that the Mayor couldn't do that because that was a matter for local authorities to decide. And so the current policy G2 is a bit pointless because it just really states what national policy is, but it does include within that part B, which says exceptional circumstances apply. So I think that's the stuff that we really need to look at, and it is my view that the council, Enfield Council, did look at paragraph 4(1)11 and correctly concluded from that in order to maximise housing supply and do its bit to try and help London's housing crisis, it looked at other opportunities to bring forward suitable and developable sites, which included Chase Park and Cruise Hill. The GLA is now kind of introducing new rules. It is essentially saying that, well, we're going to start work on a new London plan, and we've got all these new rules that we think you should apply. But I don't think it can. I don't think it can introduce new rules. Otherwise, what's to stop it from applying these embryonic rules to any other development site, any other development proposal in London? And it just doesn't work that way. It's the London plan is part of the development plan, and it is only reasonable, especially for London boroughs preparing plans in advance of that new London plan, which isn't even available in draft form yet, to try and decide what they do about setting a requirement post 2028-29. And I think it's entirely reasonable that Enfield Council alighted on the approach that it did, while also positively wanting to identify more deliverable land to ease London's housing crisis. Thank you, sir.
Okay, thank you. And I assume you're here tomorrow. Yes, to pick up on some of that point about easing London's housing crisis. I'm sure I'll cover that point. Councillor, do you have something to say?
Yeah, I apologise. In light of Mr Stevens' comments in reference to what the GLA has just stated, I didn't know if it was appropriate for me to also ask a question via you, not necessarily for them. So, obviously it's taken us all by surprise of what the GLA has just said as a statutory and obviously very important body. But in summary, the way I understood it as a layperson is the GLA is saying no to the green belt unless you do it our way. And it would just be helpful to have a clarification.
Okay. Yes, GLA. Perhaps there's a couple of points of clarification. And I should also say, sorry, another digression. It's 4:15. I would have had a break. We're in a flow. I didn't want to break that flow. I'm sure, but once we've got to the end of this, I'll pull up a very short break and then try and wrap up all the other issues we've still got to do. I'm not convinced those will take a lot of time. But if we could just get to the end of this, and I apologise if everyone's sitting there desperately trying to shoot off for a minute. But I just want to finish this off. I am conscious of the time, believe me. Sorry, yeah, there were 2 points of clarification. One raised by Mr Reid and others about what the GLA interpretation, obviously again I'll have to come to my own view on these, but what the GLA interpretation of the in consultation means, is that agree as far as you're concerned or not? And there was the point about the incompatibility between saying 4.111 applies, but also then recommending that you should roll over your requirements, because obviously those two things don't necessarily tie in. And I think there's a third one, sorry, which is saying that the green belt, Mr Reid might have to remind me, one obviously saying that you are not happy with green belt release via, at all, if you like, or versus happy with green belt release, but not these sites because they don't meet your, or you're not content with them because of the details. Just those 3 points.
Thank you very much. Firstly, just in terms of in consultation, I just meant within the normal plan making functions as set out, that we would develop local plans in consultation with our communities. In terms,
sorry, it might be my mistake. It's the line in the London plan which says in the 4.11. I'll just find it so I can quote it.
in consultation with the GLA.
Yeah. So it says. Yeah, any local evidence of identified capacity in consultation with GLA. So I think if the implication being, in order to be in conformity with that paragraph, and I've had lots of debates whether that paragraph, what that means, whether you should be in conformity or not, whether in consultation with the GLA is by implication in agreement with the GLA will have accepted those sites or not.
Yeah, of course. So I'm going to tick off the two 4.1.11 things together then, because what's important to say is 4.1.11, in drawing your figure beyond the 10-year target, it talks about the 2017 SCHLA sites. There might be any number of those that aren't delivered yet. Any local evidence of identified capacity, obviously in consultation with the GLA, taking into account additional capacity from committed transport infrastructure and rolling forward your small sites. So that would be how you'd go about that calculation. The in consultation with the GLA would be that we would work together, and if when we use this in other circumstances like master plans relating to industrial sites, for example, it has the identical phrase. Essentially, it really is very much that we would say, yes, do we agree that? And what we would often agree, we might say, yes, that's a site you might have identified, for example, through the release of industrial land. And what we've been very clear throughout this process is we do not consider that the release of the green belt meets the threshold as meant here. So the release of that would not be in consultation with the GLA. We would have to agree that it didn't compromise other parts of the plans to the extent that it was a general conformity issue, because that wouldn't be in consultation with the GLA.
Okay. So as far as you're concerned, and it is in effect an agreement.
That's
what
is
you believe it means.
Effectively.
Mr. Reid will have a different view to that,
Yeah.
I'm sure.
That's fine. And the second point about just the Greenbelt release, I think we just need to run back through the timings. Obviously, the Mayor's been asked for a general conformity view at Regulation 19, and I've set out that was in a very different time and place. We worked together on a statement of common ground that was finalised and signed on the 29th of November. And again, that was before the finalised NPPF. We've been asked again to come today and give a general conformity advice on the Mayor's view at this point in time, which is different again from the point at the Statement of Common Ground. So I can see that it may appear contradictory, but in fact it's actually because we're in an incredibly fluid situation. So the, for example, the applications to bid for government funding for a Greenbelt review only closed on the 17th of January. So all of these are really playing out in real time, and we've come to you today to give you as clearly as we possibly can where we stand at this point today, but recognising this is an incredibly fluid time, and also conscious that we will be progressing things to do with the new London plan. We've already said we'll be starting consultation in March, and we felt it would be completely unreasonable to come and give evidence here today that didn't make a nod to the things that are going to be going in the public domain in a very short space of time, and certainly before the second stage of hearings.
Thank you. Thank you. Just to reiterate, it would be really helpful if we can get that statement. As it's already, and I say if nothing else, I may ask for a transcript of it anyway, because I'm sure I can ask someone to do that. So it may as well just, if you can, just send us that.
It helps. We've got that in train. Obviously, we'd like to shortcut that and not have to spend the money doing so. If we can just have your document.
Of course, of course.
But don't use the automatic thing.
Don't AI what I just said, please.
That would be coming up with all kinds of things. With my northern accent, it tends to throw it off quite a lot. Thank you. Anything the council? Oh, sorry. Berkeley Holmes, is it? Yeah. I'll come to you first, just in case there's anything new, and then I'll just see if the council got any final words on it.
Yeah, just a couple of points. One of which is straying into a bit of the topic for tomorrow, but just very briefly. So the first one is the sort of question around new MPPF, old MPPF, and whether the new MPPF is what, in a sense, triggers the in principle acceptability of looking at Greenbelt release. I think our view is it's a moot point, really. If we look at the December 2023 MPPF, that sets a framework in which it's perfectly permissible for Enfield to set a housing requirement beyond 2029, which then in turn leads to exceptional circumstances for Greenbelt release. I mean, just very quickly, requirement to look 15 years ahead, Para 22, that's to look ahead to anticipate and respond to long-term requirements and opportunities. It's always been clear that London isn't meeting its housing need. That's baked into the existing London plan. It was always the case that further opportunities would be required for growth. Strategic policy required to set housing targets. The London plan only does that up to 2029, and where we are now, given Enfield's plan, us to look 15 years ahead. I mean, effectively, there's more of the plan not covered by the London plan than actually is covered by the London plan. So clearly the task is there. Quite frankly, I've never quite understood why the London plan only sets 10-year targets, but that's another whole question. Absolutely we don't. But in a sense, once you're in that period of looking beyond 2029, you're into the realm not just of what Para 1, I've now lost that now, 4111, that's the fella. You're into the realm of what the MPPF says. So Para 11A, meet needs unless. Para 61, use the standard methods in terms of what those needs are. The GLA says the standard method's not relevant because of what it says at 1.4.4 of the London plan. Respectfully, that's not relevant because the reference there is only relevant insofar as it relates to the 10-year targets up to 2029, not what happens beyond 2029. So Enfield rightly have to use the standard method.
Enfield aren't using the standard methodology.
Sorry?
Enfield aren't using the standard methodology.
Well,
to establish the requirement, there's an underlying reference to it, but so we can perhaps come on to that tomorrow if you think
we'll come on to that. You don't set it at the standard method necessarily, but it's part of the exercise.
For exceptional circumstances, it's been argued.
Yes.
Yeah.
So I suppose the long and short of it, there's nothing incompatible with what Enfield is doing in its plan here with the 2023 NPPF. And we'll come on to more of that tomorrow. The second point, I suppose, was just really the GLA's position, I think, is that if it accepts the principle of exceptional circumstances for greenbelt release, its concern is really about the sustainability and appropriateness of the two large releases and allocations. And I mean, the London plan is sort of quite famously long and exacting in its policy requirements in terms of development that comes forward. But I think it must be relevant that the GLA hasn't flagged that Cruise Hill and Chase Park are not in conformity with any of those other policies of the London plan. So, for example, policy D1 and D2 of the London plan cover form, character and capacity for growth and infrastructure and density. And it's not being said, as far as I understand it, that those two releases aren't in general conformity with those policies. So, in a sense, maybe it's just parking that sort of point for when we look at what general conformity with the policy G2 on exceptional circumstances actually looks like, that when you look at the ingredients that go into that, it's not being said that the London plan is being breached in any other way. Thank you.
Thank you. Right. Any final comments from you?
Just a couple, if I may. So
Yeah.
can I? Shall I deal with them now? Because, of course, we've got the other matters to deal with as well. Just one point for Mr. Byrne, I think, or perhaps two. But the need for updating and the need for clarity with regard to the 353 per annum. We are clear that there will be compliance with the 353 small sites requirement. And yes, there will need to be updating of the housing figure as a result. I fully accept that, and we'll make sure that that's in train. We've got that in train anyway because of our acceptance. But it will mean also having to update the whole of what is table 8.2 within the plan, which sets out the requirement, if you recall. So we'll do that as soon as we possibly can. I think it's going to be something that we can avoid having to do for the purposes of tomorrow, but for when we come on to deal with some of the other issues around housing need next week, it can be sensibly done at that sort of stage. So that's the first point. Just for the sake of completeness, we don't accept that, and I think this is consistent with Mr. Spry's point that we don't accept the suggestion that the releases are out of conformity with other policies in the plan, and of the London plan, that is. If you look at the totality of the policy application, we fit within it, and that covers off also Ms. Fermana's point. I will just return to the issue of 4111. With respect, I don't think Ms. Fermana has dealt with the incompatibility between essentially having what is said to be a live position with regard to 4111, and at the same time it's disapplication when one looks at the GLA's current position. I leave it there for present purposes. Maybe that we have to go back to that tomorrow. The other point is the in consultation phrase. I think it's very important to look at the totality of the plan. And I'm going to give you just 3 references so that you can see perhaps at some point. Policy G3, HC1 and SI14, they are respectively at PDFs 317, 379 and 387. And if you look at all of those, they all say in consultation with Historic England, other London boroughs and the Mayor. And you can see that that phraseology is being used as it standardly would be used, i.e. in discussion with, not by agreement with. And of course, when you read those policies, you can see that it's completely unworkable to suggest that you've got to have, for example, Thames policy areas agreed with by a neighbouring borough. It just doesn't work. So the phrase should be given its normal reading. It's capable of working in that way, and to the extent that it's still a live issue, that's our response.
Okay, thank you. I will. Has anyone else got anything else to say about that? Sorry, yes. Yeah, please do.
Very briefly, I just want to cover off Mr. Spry's comments about the other policies in the plan. For us, it would be G3, and as far as we're concerned, G3 knocks the sites out. So we wouldn't look in detail at things like we wouldn't assess them against all of the other policies in the plan in detail at that stage. However, now that we're moving to a different space, I just want to be very clear that it is our view that if those sites are going to be released, they don't optimise the use of that land, and there are other alternatives.
Okay, thanks. Yeah, I mean, I think that will come back to that. And you may wish to come back in future to talk about those things. Right. I had one more question, or one more set of questions about duty to cooperate, which was in relation to, and I will make the point very, very quickly that it was debated whether question 1.11 was actually a duty to cooperate issue, but I wasn't sure how else to put it, which is about duplication of policies between the London Plan and Enfield. And your response to that was that the duplication is intended. I did have some points on that, but I think I'm going to put a pin in that because we can deal with it as and when, if we reach a policy where it's duplicated, we can discuss whether or not it's a problem. Because it may not be a problem. In all cases, it might not be. In some cases, it might be. If there's some pulling in different directions, we'll have to look into that. But I don't think I necessarily need to go through that sort of in principle issue.
No,
now.
I think it is. I think you're right, sir, about that. It's very much, isn't it, around the specific policy and as to whether again.
I mean, I do have some views as to whether or not it is necessary to duplicate and whether it being deliberate was the right thing to do. But I still think I can address that under the auspices of each individual policy. Yes. But just before we do have a 10-minute break, before we can, did anybody have anything they want to say about question 1.11, which was about the duplication issue? As I think I can deal with it. It does relate a little bit to succinctness, except, but. Yes.
Since we have the GLA here, it seems to us that the council have substituted their own definition for good growth for the London Plan definition. I don't know if the GLA would like to comment on that or not. But.
Okay. Well, again, I think we can probably. I'm sorry to say it's not quite the point I was making, but I think it's anything like that. I think we will. It's actually the point I was making. Once we get to that point in the plan. We can compare and contrast. I mean, obviously, that's a big issue. That's probably matter 5 next week. But it's a big issue worth debating, but I think it's probably we can pick up. But thanks for making the point. Sorry, was that a new? No. Right. So I think we just have a comfort break then, and then we'll come back on to other matters, which shouldn't take very long. I expect. So if we come back at 1:45, that's just over 10 minutes. That's all right with everyone? Thank you. Thank you, everyone. Coming to the last part of today's session, at least, in terms of discussion, which is issue 1.6, issues 1.4 and 5, sustainability appraisal and HRA are going to be discussed on Friday morning. That was mainly due to availability, but actually it turns out it's probably not too bad because we wouldn't fit them in today anyway, so that's lucky. First things first, I think question 1.21 is in relation to the local development scheme and conformity. I've got the council's position on that. I have no further questions. Does anybody else wish to raise anything about the LDS at all? No? Okay, thank you. 1.22 then is about equalities. And this is in relation to whether or not the plan has been carried out in accordance with the Equalities Act. Now, it's effectively a duty for the council, but I do have to consider, and I have a duty under the Public Sector Equality Duty for my considerations to be in line with the Equalities Act. So there's a kind of symbiotic relation there. I must consider, so my actions must do that, but also need to consider whether the plan does it as well. Again, as with so many things, I think in relation to equality issues, they'll come up during the plan discussion. So we'll be having discussions about, for example, gypsy and travellers. I've got some questions about that, which relate to this issue. Older people, specialist students, specialist housing of any kind. So again, if you are here for those sessions, then that might be the best time to talk about it, because equalities, climate, most of these other issues actually are like a stick of rock, through the plan, and I won't come to a conclusion on them until I've got right to the very end. So we don't have to deal with everything today. But again, if there are points that anybody wishes to raise now, then feel free to do so. Any particular points anyone wishes to go? Yeah, okay. We'll start off with the Over 50s Forum. Thank you.
And I'm so sorry, everybody, if you're as tired as me, then wow. I know. I kind of want to start by just making some general points, if I may. And I think that this is really important, because I think it gets forgotten that equalities may be about meeting a need, accommodating to individuals and groups. I think we very often forget that sometimes equalities is just about those groups being able to be helpful. And I think as the Over 50s Forum, our intention in taking part in all of this process is not to plead special case, we want special treatment. We actually want to help. In the Matter One hearing statement, we said so much in the initial questions that we've not really said very much on this question, because we think the points are self-evident. But in the course of today and subsequent reading, and because there's been so much to read, there were just a few extra things I wanted to be able to say that weren't in the hearing statement. And I don't think necessarily will come up those other things. I want to repeat that I'm conscious that this is treading on delicate ground. It always is. And we really do fully understand that it's for the authorities, on the basis of evidence and feedback and all the rest of it, to determine the main issue. We're really not saying our issue has to be up front. But we also feel that with regard to the legislation as we understand it, elimination of discrimination and advancing of equality of opportunity, the fact that, and I think it is a fact, although I'm really, really delighted if I'm wrong, the fact that older people's concerns do not feel like they're in the stick of rock. I think we have to look quite hard to hear our voice and to feel recognised in this plan. But, in that sense, I am special case pleading because that's why I'm here. But we do try and think about what's reasonable. So insofar as accessibility and inclusion, it's about the layout and the format of the plan. I've mentioned recognition and engagement. It's crude, and I feel guilty about doing it, but we've had it demonstrated here today, so why not? SC1, I think, SCI, I beg your pardon, doesn't include the word older at all. I don't know really whether that's significant. We've written quite a lot about SCI. The equalities integrated assessment, I can't remember what it's actually called, doesn't include it at all. Has one mention, I beg your pardon, and the annual equality statement has 4 mentions of older. One refers to older children, one is a stakeholder, one is just the introduction because it has to, because we're not a protected, I can't remember what the word is, and one is about data. None of them concern action, and there's no mention in older people in the objectives that accompany the annual equality statement and the duty of local authorities. So I think, that makes you feel not very significant. We think the format of the plan, I mean, it is physically unwieldy if you get a page. I mean, this is it with the appendices. Online, it's actually very difficult for older people. The fact that it's 3 columns, you're going back and forward, up and down, you've got photos to navigate. The font size, someone else has calculated this for me, 10.5 points. It's quite small, but you can open up the screen, I recognise that, but then you've not got everything there to look for. It's really actually very difficult. The plan itself, unlike the pre-publication version, doesn't have hyperlinks. Now, if I wanted to look in here, and I have, but I've been using the online version, for something about older people, I challenge you to think about how easy that is, because it really, really isn't. Very few of the chapter headings refer to older people, unlike the London Plan, which is why I mentioned it. You can search for older, but you get a whole lot of stakeholder, which makes life very complicated. I'm sure there's clever tricks that I don't know, but that threw me for a while. It's immensely time-consuming. We want to, as older people, contribute. We want to spend our time contributing. We don't want to spend our time labouring, and believe me, it is a labour of love, because we do love Enfield. Many of us have lived here for decades, working our way through this and wanting to contribute to make it better. So the length of it, I think it's as long as Great Expectations, if not longer. The maps annotations, I mean, they defy me. The font apparently is about 5.5 on occasions. It's really, really hard. If it were single column, and I've mentioned the columns already, in portrait, like the R18 version was, and you could flip around and there were links. If this were like that, it would be 1,000 pages long. I want to repeat the MPPF comment about being succinct, because I think, and this is where I'm going to move from being supportive to saying, actually, sometimes we need help. Succinct is very different for an older person, because, believe me, this is not succinct. And I applaud the MPPF for trying, at least, to establish that. Navigating it is incredibly difficult. Remembering the codes and the chapter headings and all that is almost like a foreign language. It's a bit of a trope that older people, I'm not talking anything sinister here at all, but memory for detail, memory for names, all those things are challenging. So you can be reading a page, you flip a page, and you've forgotten what it was that you wanted. We've all had that. You go upstairs, what am I up here for? Can you imagine what that's like when you're reading a plan? I think I've said there's no hyperlinking in the online new version. That's, I mean, actually, if you're talking about a person's time, that's almost catastrophic, because you just want to throw the computer up in the air or whatever it may be. I've incidentally just got a smallish tablet, so that makes it even more difficult, because it doesn't have the power of bigger machines that I might have invested in had I known that I was going to do this.
I think I've got the point about the document's usability.
Okay, I'll keep going. The navigating the plan and looking for headings. If I were a student, I could find something. If I were a gypsy and traveller, I could find something. As an older person, I'm stuck with specialist accommodation, which is not what we were interested in. It's not where our policies are taking us. I think at one point, possibly in the council's hearing statement, they welcomed the commitment to meeting the diverse needs of Enfield's ageing population and engaging with community stakeholders. And we find that immensely good news. There's only a handful of groups that deal with older people in Enfield and advocate for them. We have good relationships with the council. The Assistant Director of Public Health writes in our bi-monthly newspaper. We have a monthly forum here in the council chamber. The Chief Executive we've invited, he's spoken to us. We've invited the Director of Planning and Growth, also has spoken to us, and we followed up with a letter. We find it kind of odd that, and again, if I'm wrong, I'll be corrected. I don't mind. I found this really hard. But lots of other community organisations have been approached, invited. We haven't. And as far as I'm aware, neither have any other older people's organisations. And I'll repeat what I said at the beginning. A third of the people in Enfield are over 50 and older, and that population is increasing. You'd have thought we'd have something to say, and we do. You'd have thought we would be asked. And I think the disappointment is actually that we haven't. Thank you.
Thank you. Enfield Society, please.
Thank you very much. Very briefly, the Enfield Society echoes the comments made by the Over 50s Forum and my colleague to my left. One thing I would add is that the purpose of the plan document is to be the guiding document for the borough's planners over the period in which it's valid. And we are concerned that the document is complicated and that will be difficult for future planners to understand and interpret as we think it should be at this point in time. I would point to the fact that there is different parts of the plan in different areas. So, for example, the compensation for the Greenbelt development is in BG7. The area of special character that's mentioned in DE11 doesn't appear on the policies map. There's very lengthy details of PL11 and PL10, which has the actual site allocations.
Are we still talking about equalities issues or just general?
I beg your pardon. I will stop
now. General issues, yeah. And I mean, the points that were raised about the document being difficult to use, etc., I think are valid issues about access, whether or not the councils had regard to the Equality Act and PSCD. I think there are issues there, but I think your points are, while valid, we may come on to those shortly. Councillor Georgiou.
Yeah, thank you. I'd align myself with the comments by Ms Pye and Mr Lack. I think to underline our group's position on the point of succinctness as non-planners, as regularly elected politicians, although my wife might be grateful that this was long because it meant I was out of her hair successive weekends, it doesn't mean that it's easy for the layman to understand, and has already been alluded to, cross-reference. I'm in no way indicating that this invalidates the plan, but the point I'm trying to make is that, perhaps through you, as we go through this process, and at the end, if there are modifications to be made, perhaps simplification, because the way that it comes across to members of the public, and I'm not casting aspersions on our officers whatsoever, is that, the best way to bury bad news is to make things very long. And so also this is, from our perspective, I'm not implying that that's the case, but we want residents to have confidence in the plan once it's finalised.
Thank you. Yeah, obviously, as we say, day one is often like this. You get into issues which you'll pick up on as we go through. Repetition, length, repetition, succinctness are issues, obviously, which need to be addressed in the context of soundness. I will say that repetition in and of itself isn't always a soundness issue, because if it's not doing any harm, it's not unsound. But there might be occasions where if policies or parts of the plan are repeating themselves, then if they're not doing it in exactly the same way, you end up with internal inconsistency. That becomes an effectiveness issue. I mean, I've gone beyond it's not about accessibility. There are accessibility things. I think some of those accessibility issues, I would say now, probably aren't soundness issues for me. However, having said that, the council, in adopting the plan, can make change if it considers them necessary. Could make changes to the format of the plan to address points which are raised. But to be honest, I don't disagree with many of the points you made about the usability of the document. That's nothing to do with whether it's sound or not. It could be. Again, there might be times where it's, but I, was trying to read all 1,000 pages, 600 pages of it. Would have been 1,000 if it had been. Yes, I'll be quite honest. I found it quite difficult sometimes to navigate and to read. It prompted me at the age of 50 to get reading glasses. I didn't need them before this plan, and now I do. So it was, it's not just because of that, I'm sure, but it was a contributing factor. So. Yeah, they're valid points. I think, as I say, I think we can pick up some of those. I think will be for the council to take away and think about, and when the plan's adopted, if the plan's adopted, for them to address. Matters of succinctness, Mr. Reid's already answered that, I think, earlier. I think as far as the council, I don't want to put words in the mouth. I think as far as the council is concerned, it's as short as it needed to be to do the job. So there's probably a difference between is it succinct and is it as succinct as it needs to be? Which is the same as when I'm writing my reports. They can be quite long, but it's probably as long as they need to be to do the job and no longer. But that's probably, I guess, that's something we're going to pick up on. If I look at a policy and I say, this is why have we got 78 criteria, very detailed criteria, is that going to cause problems? Then that's where it'll come up for me. But does it need to be white text on green ink? Again, probably outside my remit, but while I'm in the chair, probably not, because it does make it very difficult to read. So if that's sorry, I'm slightly going beyond my remit, but why not? I'm the inspector. I can do what I want, frankly. So yeah. Any other points? As I say, I'm going to touch on Gypsy and Travellers next week. I've got some points about that, obviously in terms of the policies, but also in terms of the approach taking to the separate plan. I don't know if you want to say something about that now, or you.
No, sir. Thank you. We'll leave it till then. Can I also say I've obviously heard Ms. Pite's comments about reliance on policy H5 alone for looking at older persons housing. I will deal with that next week, but just to flag up, sir, that it's important to read that carefully because it does allow for C3 housing development for older persons. It's not confined to C2 uses, so nor to extra care. So it can be simply downsizable elements. But I'll come on to that.
Well, we can deal with that when we get to it. So any other points on equality? This is not the only time we're going to be talking about equality. There's no doubt issues relating to that. But if any other points anyone wish to raise? So my next point, I think, was on superseded policies, which is a very straightforward issue. Regulation 8.5 requires the plan to set out when a policy in another plan is to be superseded. There's a paragraph 1.15 which sets out which plans are to be replaced in their entirety. And we could have a very long and interesting debate whether that meets Regulation 8.5, but I know you're content that it is, and I'm aware of other plans that do that. I'm also aware of plans where we've got to schedule every single policy. I will say I'm personally not convinced of the need for that. There is a main modification suggested. I think in your statement you've queried whether that's a main mod. I've queried whether it's a main mod. Yes. I think for now leave it in the schedule and we can deal with that as and when. But my gut feeling is it probably isn't because it's duplication and repetition, isn't it? My only other point on that really, and it's again debatable whether it's an issue or not, is it's not intended to the plan isn't intended, as I understand it, to supersede any aspect of the London plan, if it can. It may be debatable if it can, but nor the Hadley Wood neighbourhood plan, which is the other part of the development plan, which remains extant.
Yes, it doesn't supersede it, but to the extent that there is any conflict between the two, it will necessarily override it in the event that we're really looking at RUR2. We're really looking at RUR2 and the degree to which the release of that land would in any way be contrary to what is said to be a relevant policy, namely the aspiration objective, which has been relied upon by the forum. To the extent that there would be an effective superseding, it would happen in that way. But our position is that that actually isn't a policy that's engaged, because it isn't a policy. So that there's nothing that it is superseding.
Okay, any points on that? Again, we'll obviously come on to the Hadley Wood neighbourhood plan and that site in the fullness of time. So, okay, climate change. This is another one, obviously, which is the requirement. The legal requirement is for the plan to contain policies which address. I'll get the wording wrong, but adaptation and mitigation of climate change issues. I've had some, obviously, representations which say the policies of the plan don't meet climate change requirements, but that's not quite the test. But we'll come on to that as to whether or not there are concerns in that regard and how to deal with them. The question for me in terms of the statutory requirement is whether the plan contains policies which deal with those issues. Again, I've got the council statement on that. It'll be something I'll assess as we go through. I've no particular questions on that. Any other questions on those? As I say, I know people will say this site or this policy is not consistent with those policies, but we can cross that bridge when we get to it. Is that okay? And then, so I think that's everything on the agenda, everything on the questions.
It is.
The only other point I had, which was other matters, which was the succinct plan point that you've raised. I think we've discussed. I don't know if there's anything else you want to say. We've discussed that now. Sorry, yes, if you want to just, Enfield Society, pick up the points you were making. Yeah.
No, I think we've covered them all. I mentioned the difficulty in that different parts of the plan contain relevant policies or allied policies, and that the policy needs to be read as a whole, and we feel that's difficult in its current form.
Okay.
Thank you.
Thank you. And I think, again, saying what we're saying really, if we come across a policy where that is an issue and whereby the effectiveness, is it the wording in the framework is it clear and unambiguous, for example, on how a decision maker should come to a view, then that's where we can look at to say whether or not it being in different parts of the plan is actually causing a problem or not. It is a tired cliche of planners that the plan is read as a whole, but I recognise that 600-page plan is easier. It's not as easy to read as a whole as a 200-page plan or a 100-page plan. So, but yeah, thank you for that point. So any other comments on anything we've discussed today? Any burning issues anybody wishes to draw to my attention? No? Okay.
No, thank you, sir. So I think it's just that we've got a number of items of homework. We're reasonably clear as to what those are.
Yes, okay.
But I don't know whether, sir, you want to...
Well, I would need probably just to go through my note. I mean, my usual intention is to come back is to reflect on things during the evening, and also to compile my list to make sure I'm understanding where, and then if anything else occurs to me, then I can raise it in the morning.
Very good.
Particularly it's 5:15. I suspect you're not going to be doing. Hopefully, you're not going to be too much for tomorrow morning. So that would be my view. I think, and also when it comes to things like the duty to cooperate stuff, by all means, obviously, if you want to make a start, that's up to you.
Yes.
But I will want to probably do some kind of action note, albeit maybe if it's by next Monday, you might overtake me, but because I haven't got a lot of time. To say exactly what I want out of that.
Of course.
I just want to reiterate the point I made earlier, that obviously I'm content to carry on while waiting for the information. Once I've received it, I may well have other points to raise. I may well need another session on the duty. It by no means means that I'm satisfied the duty has been met, so I want to say without prejudice as well. when it comes to matters of engagement, again, in a similar fashion, I'm content to carry on at the moment and not pause to address the issues that need to be addressed. I need to identify, well, we need to probably identify what's being done, what needs to be done. My main focus on that is obviously making sure that anybody who hasn't been notified is notified. That, and obviously they have the opportunity to address the matters that we've dealt with in stage 1. And then that might mean we might need to rerun some of this when we come back.
Yes.
So if and when we come back later on in the year. Similarly, if there are points where if and when the database is working correctly and all of the representations are then made available to people, clearly if anybody feels that there were things in representations that they weren't able to access, then I need to be able to give some opportunity for people to make those points that they haven't been able to make because of that information not being available.
Yes.
Clearly, that's my initial view on that. I do need to give some more thought to that. But in terms of, are we coming back tomorrow? I think, yeah, at the moment, yes.
Yes.
Because I think we can possibly, until I see what needs to be done, deal with those issues.
Yes, certainly, sir. Thank you. That's very helpful, Will. I think we will start putting things in train to the extent that we can. We understand, of course, with our prejudiced nature of what you suggested, but it would at least allow things to be progressed as far as we can take.
But as I say, even if you, of course, the other thing is if and when additional information is provided, and the other statements of common ground, the TfL statement of common ground, particularly because we've discussed it and it can be quite significant. Again, I'll probably have to give people the opportunity to come back, so there'll be a written representation stage where if we do stage 2, it might be a stage 1.5 where we mop up anything where we're still there's still outstanding issues.
Yes,
that makes sense. So
yes, it does.
Okay. So again, I never like to bang the gavel until I'm absolutely certain everybody's said what they want to say. But if everyone,
I do have.
sorry, sorry, yes, Enfield. Sorry,
I think Mr. Lack has put.
Yes, I just wanted to pick up, as you've touched upon it again, sir, about the missing representations. One point that wasn't raised this morning, and I just want to highlight it, was that there was a long period in the summer when all the representations that had been published in August disappeared because of GDPR concerns, which the Council has acknowledged in its statement on the matter. And that did cause us problems in that we were unable to access representations while we were preparing for this examination.
Well, I'm not, okay, as I've said, I think where there are issues relating to the failings of the database, I'm going to be minded to be reasonably flexible in allowing people the opportunity to say, well, this representation wasn't available, I want to make this point about it. But that's not going to be a free-for-all to basically say, I want to go and make a lot of additional comments which were not relevant or you could have made. If they was able to make the comment at the time because it was your point or something, then I'm not going to sort of open up to basically anything, but it would say it'll have to be related to something you couldn't possibly have seen because it wasn't available. Similarly, if the representations have been back online in time for you to look at it before coming here today, or whichever session. If we're dealing with a session next week and there's a representation that's there now and you've got the opportunity to look at it, then I'm probably not going to be saying, well, okay, that was there, you've had it. But if there's a whole tranche of new ones that raise issues which are relevant, then maybe there'll be an opportunity. I've got to be fair, but also I've got to be mindful that we've got to make progress as well. And you know, Enfield Society has obviously made a lot of comments. You've been able to make as many comments as you want. I'll have to see the scale of the issue, but I'm going to work on the basis that try and minimise any or remove any disadvantage anybody might have had. Okay. Okay, is that okay? Right, okay, I'm going to adjourn for today then, and we'll restart at 9:30 tomorrow morning. Thank you very much for your contributions today. Much appreciated. Thank you.
Thank you very much, sir. Thank you.